All right, I'm about to give my spiel. I declare open this public hearing of the Legal and Constitutional Affairs References Committee inquiry into Australia's youth justice and incarceration system. I acknowledge the traditional custodians of the land on which we meet and pay my respects to their elders past and present. I'd also like to acknowledge and welcome other Aboriginal and Torres Strait Islander people who are participating in today's hearing. I welcome those witnesses who've just managed to get through security. The committee's proceedings today will follow the program as circulated. These are public proceedings being broadcast live in Parliament House and via the web. For people participating remotely, I'm the chair of the committee, Senator Paul Scar. Joining me today in person are the Deputy Chair, Senator Nita Green, and Senators Varun Ghosh, David Shoebridge, Karen Little, Senator Pocock, and Senator Thorpe may join us during the course of the day. Senator Antic is joining the hearing via teleconference, or may be joining the hearing via teleconference. I remind all participants in today's hearing of our obligations to act respectfully, professionally and with integrity, consistent with the behaviour standards for Commonwealth parliamentary workplaces. I remind witnesses that in giving evidence to the committee they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false and misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolution, witnesses have the right to request to be heard in confidence, described as being in camera. If you are a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretariat as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, also be made at any other time. A witness speaking for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly and into the microphones to assist Hansard to record proceedings. And that's especially important when we have a number of witnesses at the table. Mobile phones and other electronic devices should be switched off or turned to silent mode. And before we begin, on behalf of the committee, I acknowledge that this inquiry and the matters that we are about to discuss might cause distress to people participating in or listening to today's evidence. If you need support, we encourage you to contact Lifeline Australia, Kids Helpline or 13 Yarn. Please ask the Secretariat for the contact details. I now welcome representatives from the Australian and New Zealand Children's Commissioners, Guardians and Advocates, both in person and via video conference. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, I'm now going to ask each of you to please state your full name and the capacity in which you appear. And I might just start with you, Ms Hollands.
Thank you, Senator. My name's Anne Hollands and I'm Australia's National Children's Commissioner.
Okay, Ms Griffiths-Cook.
Jodie Griffiths-Cook. I'm the ACT Public Advocate and Children and Young People Commissioner.
Excellent. Ms McGowan-Jones.
Jacqueline McGowan-Jones, Commissioner for Children and Young People, Western Australia.
Okay, thank you for coming. Ms Natalie Lewis.
Good morning, Natalie Lewis, a Commissioner with the Queensland Family and Child Commission.
Ms Turnbull-Roberts.
Good morning, Vanessa Turnbull-Roberts, Commissioner for Aboriginal and Torres Strait Islander Children and Young People, ACT.
Thank you. Ms Musk.
Children's Commissioner of the Northern Territory.
Excellent, thank you. Ms Crompton.
Good morning, Chair. My name is Isabel Crompton. I'm the Interim Commissioner for Children and Young People in Tasmania.
Ms Reid.
Good morning. My name is Shona Reid. I'm the Guardian for Children and Young People in Out-of-Home Care and the Training Centre Visitor in South Australia.
And Ms Robinson.
Good morning, Chair. Zoe Robinson, the New South Wales Advocate for Children and Young People.
Now, I'm going to ask if you've got opening statements. Now, there's a lot of you. Are you doing one collectively or individually?
We've kind of got a bit of a rolling one, but we will try to keep
a rolling
that.
opening statement. Excellent.
Just to see if this is as orchestrated as we'd like it to be.
All right, well, let's see how we go. So who do I start with? Who starts us on the roll?
Thank you,
Okay,
Senator.
thank you. Thank you. Over to you.
Good morning. On behalf of my colleagues here today, I too begin by acknowledging the traditional custodians of these lands, the Ngunnawal and Ngambri peoples, and pay our respects to elders past and present. We also recognise the emerging leadership capacity of First Nations children and young people, noting that the recommendations made by this committee will directly impact their lives. We welcome the opportunity to speak with the committee, noting that individually and collectively as Australia's children's commissioners, guardians and advocates, our responsibilities include protecting and promoting the rights, safety, well-being and interest of Australia's children and young people. While most children never come into contact with the youth justice system, the state of youth justice in Australia is at a crisis level and requires immediate and substantive reform if we are to increase public safety and change the life trajectories of those children who are some of the most vulnerable and marginalised in our society and community. The evidence is well established and clear. The younger a child is when they come into contact with the justice system, the greater the likelihood they will continue to offend, that their offences will become more serious in nature, and that they will progress to engagement with the adult justice system. If we don't put a stop to this now, who will? We have all the evidence we need. Numerous successive inquiries, royal commissions and reports have told us everything we need to know. We now have a roadmap report called Help Way Earlier. But what we need most is a clear mandate that says enough is enough and commits us to implement solutions that respond to the evidence, instead of letting uninformed or deliberately misconstrued narratives drive public policy and decision-making. We know what is needed. Those children who are involved in these systems themselves know that more of the same will not change anything for them. We need to uphold their right to be heard, and we need to act in ways that show we have listened.
As Commissioners, Guardians and Advocates, we speak directly to children and young people in youth detention or those who are vulnerable and at risk of coming into contact with the youth justice sector. More importantly, we listen. It is not a simple narrative. It is not simply rampaging children we're observing. We're observing the consequence of fractures in families, societal and support structures across multiple generations and political cycles. We're observing attempts to contain problems of successive reforms, both legislative and practice, without acknowledging our collective role in this. We cannot simply drive down the same road as we always have, because we will inevitably end up in the same location. Containment, containment, and more containment. Children and young people have a lot to say about the world, how the media and how the community are treating them. They also have a lot to say about what happens to them when they enter or re-enter youth detention settings. Last year, I spoke to children and young people in the Adelaide Youth Training Centre. The underlying sentiment was twofold. First, being let down from the moment they were born. Let down by their families that were supposed to grow them up, love them and care for them and provide them safety. They were let down by statutory bodies that were supposed to protect them when they were hurt. They were let down by schools that were supposed to teach and nurture them. They were let down by their peers who they were trying to make connections with, but ended up being entwined in trouble and offending behaviours. Let down by support systems that promised to be there when the times were tough, but workers changed so often they were hardly able to remember their names, or services were only funded for 12 months and they disappeared as quickly as they appeared. Let down by their legal representation that did not explain the wholeness of their situation, the court processes, their rights, their responsibilities, and they ended up getting into more trouble. Let down by the promise of a new start, that rehabilitation or diversion programs would be offered to them in youth detention settings, and that just didn't happen. Secondly, children and young people express the desire to be part of something, desire to be more than just a passenger in their life, to contribute meaningfully to their own world and to ours. I saw and heard children and young people who want to be part of this community. They truly do. They want to be part of our society. They truly do. To be meaningful to themselves and to the community around them. When I hear from kids, and I'm going to do the quotes because I'm quoting them, I know the statistics for kids like me. I worry that even children know the trajectory of their life at the age of 10, and that our society response to them is so predictable. They simply just give up because they believe we simply just don't care enough. When I hear kids say to me, I reckon it makes you do more crime and more time the more you come in here, I worry that our community thinks that kids are getting rehabilitation in youth detention settings. I worry that people think kids will leave these places being able to make better choices for their life and be rehabilitated. My observation as a training centre visitor is that rehabilitation is an aspiration rather than a reality, with containment of children being the dominating functional goal of these facilities. When I hear kids say to me, they lock disability kids up in here, bro, it's shameful. I wonder if our society knows that in a recent research study in the detention facility I oversight, 9 in 10 children have a disability-related need. I wonder if we know that disability needs of these children may have actually influenced their behaviours and impaired their ability for themselves and our community to make healthy decisions. I wonder if their disability needs have ever been looked at and if supports were ever provided to manage this. When I hear kids say to me, instead of helping us to reconnect society, it's mainly alienating us and making us think that because we've done crime, we're always outcasted and we're always segregated. I hear children asking to be a part of something, to be included rather than excluded. I hear children wishing more people were there for them, and I hear children wanting more from us. And finally, when I hear kids asking me or saying to me, everyone's not a bad person, we're just a product of our environment, it's the way people grow up and not good homes. I hear them that we let them down long ago and we are now punishing them for our failures to protect, nurture and grow them well. It leaves me asking, have we created a situation because we simply haven't cared early enough in their lives? Have we created a situation because we haven't invested in family support systems well enough? Have we created this situation because we keep kicking the bucket down the road? There is lots of wisdom in what children and young people have to say. What they mostly say, if I squash 1,000 quotes into a single sentiment, is that they needed us to help them when they were little, and we didn't. But they still need our help now, and this right here is our opportunity for us to do better.
Shalina Mast, Children's Commissioner in Northern Territory. In my role, I've received countless complaints from children and young people and others about the harsh conditions and their treatment within custodial facilities. This is commensurate with a marked increase in incidents, assaults, self-harming and suicidal ideation amongst the children held in detention facilities. My office has observed ongoing conflicts within these facilities, property damage, staffing issues and the continued use of separation and lockdowns, all impacting the safety, mental health and well-being of children held in detention. Aboriginal children fare worse in this system. Aboriginal children are overrepresented in detention, accounting for 94% and often 100% of the children in detention in the Northern Territory, despite making up only 45% of our youth population. Noting that around 93% of children in custody are on remand, waiting for their trial or sentence, it's clear the Northern Territory youth justice system is geared more towards incarcerating children than investing in earlier supports and interventions, diversionary and restorative justice programs, accommodation and rehabilitative alternatives. What is happening here in the Northern Territory reflects a politicisation of youth crime and any social behaviour by children on the back of hypervigilant and sensationalist media and social media reporting, too often framed in stereotypical and derogatory narratives about Aboriginal children. The Northern Territory's recent toughened crime reforms to laws and policies directed at vulnerable children reflect this. These include reversing the age of criminal responsibility from 12 to 10 years, reintroducing the use of spit hoods on children in custody, introducing stronger bail laws that lead to more children being held on remand, the funding a range of community-led intensive supports and the re-establishment of youth boot camps, and the repurposing of the recently renovated and purpose-built Alice Springs Youth Detention Centre for use as a women's adult prison, and the relocation of all children from Central Australia to Darwin, some 1,500 kilometres away. Pursuing punitive tough-on-crime approaches to youth offending does nothing to make our communities safer, nor does it address the root causes of crime. Youth justice systems, the laws and policies that affect our most vulnerable children must be separated from politics. I remain deeply concerned about the unwarranted and potentially discriminatory nature of these reforms, foreseeing that changes to these bail laws will only increase the likelihood of more Aboriginal children and younger children ending up in custody. In a jurisdiction where close to 100% of children in detention on any given day are Aboriginal, systemic racism remains a crucial yet unrecognised factor that contributes to both the criminalisation and incarceration of Aboriginal children. A punitive approach to youth offending goes against the evidence of what works. Therapeutic models of youth justice are not ideological, they are evidence-based. Here in the Northern Territory, we've had multiple inquiries, reviews and a Royal Commission. It's clear what needs to be done to address the drivers of youth offending and to improve responses to the risk and needs of vulnerable children earlier. And that includes prioritising cautionary and diversionary options, facilitating restorative justice and alternative responses that keep children in their communities with their families, and engage in education, health, healing and cultural programs. We know that once a child enters the formal system, they're more likely to return, particularly if they are detained. In contrast, youth diversion programs and alternative responses that operate outside of the formal court system are more effective in helping children get their lives back on track and reducing the risk factors that operate to offend. Right now, Aboriginal community organisations are working outside the box and with at-risk children, young people and their families to address their intersection needs in a holistic and culturally strengthening way. I implore governments to support and resource these community-led and place-based alternatives now and into the future. We all know what needs to be done, we just need to get on with it.
Like my Northern Territory colleague in Queensland, we find ourselves in a policy environment that is characterised by sweeping legislative reform in response to exceptional and highly emotive incidents, while ignoring well-known evidence and discarding long-standing and universally accepted principles of rights and justice. Over the past 2 years, there have been a series of policy changes, largely and increasingly punitive in nature. The incompatibility of these laws with basic fundamental human rights protections required an override of the Queensland Human Rights Act twice, to a point where now in Queensland, children have less protections than adults do. These reactive policy approaches over successive years have further entrenched core issues of social inequity and diverted public attention and discourse away from the types of transformational approaches that are required if we genuinely want to solve this public policy problem. Justice has long been prone to violent swings of the policy pendulum, highly vulnerable to politicisation. It is almost always an election campaign issue, and the opportunity for reform that follows has a shelf life that is limited to election cycles. The Commonwealth has skin in this game. The Commonwealth can and should take responsibility for limiting how far that pendulum can swing in any jurisdiction at any given time. While typically quick to focus on the state's role in legislating and administering youth justice systems, the impacts of that legislation on children and young people and on community safety should be of keen and ongoing interest to the Commonwealth, especially given that those outcomes are integrally linked to Australia's obligations as per international law and in the language found on the pages of numerous national agreements such as Closing the Gap and the National Framework for Protecting Australia's Children. There is no carve-out clause to suggest that you should care less or abrogate your responsibilities under such agreements if those children, Australia's children, happen to be in conflict with the law in any particular state or territory. When it comes to closing the gap and the hyper-incarceration of Aboriginal and Torres Strait Islander children, setting expectations and accountabilities would be far more effective than setting targets. Agreements without meaningful action and without accountability for inaction are nothing more than an exercise in appeasement. In fact, recent policy changes have created the conditions that render the goal of reducing overrepresentation of First Nations children virtually impossible. Violating children's rights should never be accepted, yet that is exactly what is occurring within our justice system and clearly not only in Queensland. What will it take for the Commonwealth to intervene in state and territory youth justice systems? Is the torture of Aboriginal and Torres Strait Islander children the standard to compel Commonwealth intervention, as we witnessed with the Dondale Detention Centre? Is the removal of detention as a last resort and the introduction of 20-year mandatory minimum sentences in Queensland's legislation, is that grounds for Commonwealth government intervention? It is not overreach to proactively engage and assert minimum standards. The Commonwealth has a duty of care to ensure that all Australian governments meet international human rights obligations, including those under OPCAT and the UNCRC. Establishing and monitoring minimum standards is a key action that the Commonwealth could take, reinforcing the flaw that will safeguard the fundamental protection of children's rights when interacting with the justice system, regardless of what state or territory they happen to live in. Clear, consistent expectations of all Australian jurisdictions, such as legal recognition of the status of children as distinct from adults, and ensuring that those differences are not readily disregarded or ignored based on what is convenient or on the limited capacity of the system or its actors. Simply rights-affirming minimum standards about the use of custody and the treatment of children in custody, including, for example, establishing a national policy position regarding the definition and impacts of isolation upon children, and perhaps a prohibition on the use of solitary confinement of children and all disciplinary measures that constitute cruel and degrading treatment. This too would make an amazing difference. The Commonwealth can and should demonstrate leadership, requiring states and territories at a minimum to provide access to requisite supports to make rehabilitation and successful reintegration actually viable, safeguarding the standards of care and the continuity of care, such as health, mental health and disability supports, regardless of whether a child is in custody or in their community. To effect change that adequately protects Australia's children requires leadership. Now is the time for the Commonwealth to intervene. If not now, Australian children deserve to know when. I know we've only got 15 or so minutes, 18 minutes left in this session. So I think the statements are very useful, but I do want to provide an opportunity for colleagues to ask questions. How much longer have we got to go in terms of our rolling statements?
Approximately 4 to 5 minutes, Senator.
Okay. If everyone's happy, we'll continue then. Thank you. Please.
Jacqueline McGowan-Jones, Commissioner for Children and Young People, Western Australia. I asked the committee, in what other first world country do we see children dying in custody? In what first world nation do we think it's reasonable that we detain children in cells for up to 23 hours a day, that we leave them in great need and they die in a system that should be protecting them? We are one of the world's wealthiest countries, and yet while other developed countries are closing youth detention facilities and investing in community-based therapeutic approaches, including improved drug and alcohol and mental health services, the recent Human Rights Watch report and the United Nations Convention on the Rights of the Child Committee Chair have condemned Australia for its flagrant breach of human rights and international law. Australia has administrative standards for youth justice signed by every jurisdiction, and it says they're nice to have. They're not nice to have. They are critical for the well-being of the children who are in contact with the youth justice system, and particularly those incarcerated. We need solutions that reflect what children and young people tell us will work for them. This involves getting in early and working with them and their families in ways that recognise their underlying trauma and respond to root cause such as entrenched disadvantage and poverty. If we want to stop the pipeline of children into crime and youth detention, we must intervene early with children and families who are at risk. We must value and invest in the importance of our future generations, our children, within the context of their families and communities. We must read and listen to the evidence about neurodevelopmental stages of life when we are incarcerating 10 to 14-year-olds who do not possess the necessary development to make informed decisions and understand consequences of actions. If we want to make a difference and change the life trajectories of children in ways that positively influence their children and their children's children, we need to place the child at the centre of our solutions and ensure multi-agency responses that genuinely work together in collaboration with each other and with the child, the community and the family. We need to ensure that when an agency says they will do something, they do it, and that they recognise their contribution is part of a greater whole and that outcomes will not be realised unless everyone commits to doing their bit. The things these kids need are the same things that your kids need. And they are the same, the family's needs are the same as your needs to grow your family up to be healthy, safe, happy, contributing members of our society. We must individualise responses, and given the significant overrepresentation of Aboriginal and Torres Strait Islander children in the criminal justice system, or in fact, I would prefer to call it a legal system because there is not much justice involved for children. But if we want to keep our children safe and ensure our country has a future with really functioning families and communities, we must invest in our children now. We must stop blaming children for the circumstances into which they are born, over which they have no control. If we are truly committed to making a difference, we must have a systems approach.
Zoe Robinson, the New South Wales Advocate for Children and Young People. My colleagues have clearly explained the crisis that we are in. We have all the evidence we need to know that what we are doing right now is not the solution. You have heard children share stories of being let down from birth by family, by the support services, by policymakers and legislators. You have heard how majority of children incarcerated have a disability. Each state and territory is taking different approaches, but it is clear that none of these have the safety, well-being and best interests at heart for the children and young people. So, in the words of a child incarcerated that I sat with, the only way you get heard is to yell and scream. So here we are, as commissioners, guardians and advocates for all the children across this country, yelling and screaming, figuratively of course, on behalf of all children incarcerated. We welcome your questions.
Oh, that's okay. Thank you very much. So, Senator Little.
Thank you, and thank you for your presentations. I just want to talk about the theme that's recurring here, which is obviously intervening much earlier. We've got recent information that 2% of children, Aboriginal children in remote areas, are actually going to school regularly. We know the drivers of alcohol misuse, drug misuse and violence. I don't have to tell you, you know that. How do we actually ensure that we are addressing the drivers of parental responsibility and those issues of alcohol, drug misuse and violence? And even programs themselves. We've got a program currently that has a bus service running, and it's not the first one, there are many, until 4 a.m. in the morning. And I pick up your theme, treating children just like you would treat your own. How do we actually change the culture of treating children differently?
So I might start with Ms Hollins, if you want to answer, and I'll give everyone an opportunity, but if we can just bear in mind the time, and feel free to take questions on notice, so if you'd like to provide a more exhaustive answer, you have that opportunity. Ms Hollands.
Thank you, Chair. I'm going to pass on to my colleagues because I will be appearing and speaking this afternoon at the Australian Human Rights Commission session, so I will allow my colleagues to speak if that's all right.
Sure. Who'd like to go first?
I think importantly in that space, and as we've spoken to, it is about how we support our families. It is about recognising and intervening as early as we possibly can. If we don't put in the scaffolding around families to enable them to build that parenting capacity and build their ability to themselves respond to their children's needs and to the needs that are evidenced both in terms of disability needs but also just broader needs of being a child. If we don't scaffold families to build those skills, then it's impossible for many families, if they haven't grown up with those, examples themselves. It makes it extraordinarily challenging to know what that standard is that we're asking of them. Time and again, we see families coming into the care and protection system who I talk about circumstances of inadvertent neglect. They don't know what they don't know or what they need to know to be an effective parent. If we don't teach them, if we don't give them those skills, how can we expect them to reach the bar that we hold over their heads?
I'd also like to add, from Western Australia, when I was in child protection, we installed the Parental Support and Responsibility Act 2008. That act doesn't help legislating for parents to be fined or otherwise if they don't parent their children. If they're not parenting their children, there is a greater problem. We do know that we have problems in remote and regional locations that we don't see perhaps as in depth as we do in some of our urban locations. But we also know the lack of services and supports, the further you get away from a capital city, is incredible. We've got children who come into detention who are under the influence of alcohol. We dry them out. We don't detox them. We don't get them into a drug and alcohol program. They can see someone once a week. But they've grown up with drugs and alcohol in their family, and the family hasn't had the supports. We can find $1 million a year to keep a child in custody in Western Australia, but we can't find $1 million a year to work with that family to provide the supports they need to make sure the kids don't end up in contact with the justice system. We are putting the money at the ambulance at the bottom of the cliff, and as we continue to do that, we will continue to lose more children and we will continue to see a breakdown in our families and communities.
In terms of how do you change the perspective, I think media has a very huge role to play in this in terms of how they are speaking about children and young people and how that they are depicting what is going on. And so I think in terms of your question, a lot of people don't sit with these children and young people. And I have the great fortune at ACYP to have a young person who was incarcerated for 5 years who works with us. So it's so important that it's not just a media reporting about children and young people, and the way that they're doing it right now, I say, is putting a lot of thoughts in people's minds about who these children are, versus the fact that actually policymakers, legislators, those need to consistently sit with children and young people, not just when they're incarcerated, but in the lead up and the things that we know. We know enough to have someone turn up to a hospital prepared to remove a child, but we can't ask questions like, are you a parent? How many children do you have as they're coming into that justice system? So I think there are some really practical things we can do, like asking the things and then immediately wrapping family support around those families.
I also want to make it clear, Chair, I get a bit annoyed because the narrative really is about our kids, Aboriginal kids and Torres Strait Islander kids, being the real problem. We have many children and young people in custody who are not Aboriginal and or Torres Strait Islander, but unfortunately the way the laws work, we are at greater risk of our children coming into the system.
Okay.
Can I just
send a little.
Ms McGowan-Jones, I'm glad that you raised that. There are children across the spectrum in custodial settings. You would know that when you look at the census, the number of Aboriginal children that are in this country is nowhere near the number of children that are actually in custody. So we're actually talking about a very small portion of the population and that demographic, aren't we?
Well, in WA we have 665,000 children and young people aged 0 to 17, and at any given time I have between 50 and 60 in detention. We have 48,000 Aboriginal children and young people in Western Australia aged 0 to 17.
So although you're all children's commissioners and we're talking about incarceration today, what is the effect of this on other children who might be seen in that similar demographic?
I'm
talking about stereotyping of all children.
The effect is the same on all children and young people in the current way in which we deal with their interaction with the legal system. We don't rehabilitate. We don't support them to have rehabilitation for drug and alcohol problems. We don't support them with the needs they have for their disabilities, cognitive impairments and other things. We are condemning these children to a life of institutionalisation.
I need to pass the call. Senator Pocock, you've got 5 minutes. Thanks.
Thank you very much for your opening statements, for being here today. My questions, and I acknowledge the focus on keeping young people out of youth detention, but I have some questions that are specifically for the ACT once young people end up in places like Bimberi. I was hoping for evidence from Commissioners Griffiths, Cook and Turnbull-Roberts. I understand that at the Bimberi Youth Justice Centre here in the ACT, there are issues with access to and contact with family members and friends. For example, young people can't hug or kiss visiting family members and are restricted to 10-minute phone calls. So if you could sort of confirm that's the case and outline for me the importance of family connection for young people in the justice system.
I'm happy to start, and then Vanessa can perhaps pick up if she has additional comments she'd like to make. We certainly raised the issue of the lack of physical contact for a very long time. Effectively, that policy position had been stood up during COVID times, but had never been stood back down until we started rattling the cage, I guess, last year before. Pleasingly, toward the end of last year, that policy position shifted. It did take a lot of work to get there, and I think we are still we're still having to ask to make sure that it's actually given as a rite of passage, as opposed to something that children and young people detained in Bimberi have to ask for. My view is that it actually should be a given that physical contact is allowed, as opposed to an exception that children have to bargain for.
What's the thinking of having it as something you have to bargain for? That makes no sense.
Look, I can't speak for my government colleagues in that regard. I think, when it comes down to it, my concern remains that it should be, the exception should be those where there are identified risks. And in those individual circumstances, then it may be appropriate to actually say that perhaps contact may not work or may not be appropriate at that time. We know how important family connection is. We know how important it is to get a hug from our parent, from our brother, from our sister. When you are incarcerated, and as my colleague said, often for up to 23 hours a day, and that doesn't happen often here in the ACT, but we're still talking about lockdowns at night for 13 hours. That's still a significant amount of time that children are in their rooms as a result of operational requirements. So we need to be looking at ways to make sure that that connection with family is as wholesome as it can be, despite the constraints of being in a detention facility. We need to recognise the strength that comes from that connection, and we actually need to do what we can to embrace that and to actually make that work for our children and young people.
Thank you. Commissioner Turnbull-Roberts, just in the interest of time, I might ask you a separate question, obviously related. In your submission you say that, and I'll quote you, "Tragically in the ACT there is a direct pipeline from child protection to Bimberi to adult prison." This seems to indicate a pretty appalling failure of programs that actually work with young people to divert them and keep them out. Can you comment on this? What needs to change, and why aren't we seeing this, given, I guess, people in the ACT, I'd say, probably want to see this from their leadership in government? I think you're on mute there.
Oh, sorry, you're on mute. If you could just unmute, please. Sorry, you're still on mute.
I think she's off mute, but there's no sound.
Not sure what's going on there. We might just ask the witness to take that on notice.
Okay,
Senator
I
Pocock.
might just move on. Last question,
Just
Chair.
last question,
Right?
yes, please.
In reading the review of Bimbri by the ACT Custodial Inspector released 12 December last year, some pretty harrowing feedback from young people detained there, including not enough food for some, sometimes get hungry overnight, it gets cold in the cells, feels like some staff deliberately mess with you. On top of this, allegations obviously broken this morning of historical and pervasive sexual abuse. I'm sure you're advocating on this and many other issues. Have you heard these concerns from young people? And are you aware of anything that's being done to address it?
Look, those the statements of historical abuse, as I understand it, are historical. I certainly haven't had any concerns brought to me in the nearly 9 years that I've now been in this role in that regard. I think it certainly speaks to, though, some of those elements of detention, it's part of the reason why we're here today. We need to actually look at alternatives that actually keep kids out of those facilities. The difference isn't made, as my colleagues have so eloquently spoken, but the difference isn't made within those facilities. The difference is made outside of them. The difference is made when we intervene early, when we support families, when we wrap supports around the child and recognise that their needs exist beyond them in isolation. There are different ways of operating that we need to adopt. That collaboration that we spoke to earlier, we were privy to some work in New Zealand that actually they had all of the relevant systems around the table. They'd drawn from all those relevant systems to stand up a team that worked together to respond at the immediate point of call. The first response when a child was first brought before their system occurs within 24 hours and typically within 18. That is something we don't yet have here, but if we could stand that up, that first contact that a child has with the youth justice system, if we could stand up a response within 24 hours that doesn't just respond to that child, but starts to look at what's happening in the ecosystem around that child, we will start to make a difference.
Well, thank you. Thanks, Senator Pocock. Senator Shoebridge.
Thanks, Chair. Thanks to all of you for your cooperative way you've presented your evidence today too, and I'd urge everyone who hasn't, if anyone's watching, to read your detailed submissions. We've got a system across the country which you've articulated. We've got record numbers of kids in Queensland watch houses, crowded cells, appalling conditions. We've seen some of that on video. We have conditions in WA that have been described by the Supreme Court as torture, ongoing torture, and yet the state government refuses to act. We have almost 100% of the kids in NT jails are First Nations kids, and that territory wants to torture the kids by putting spittlets back on them, and the Commonwealth has done nothing. Often we hear from, doesn't matter which party is in government, it's not the Commonwealth's job. Although we've just seen the opposition leader come out and wanting to have national knife laws. It seems the Commonwealth is willing to act when it comes to harming kids, but is refusing to listen to all the evidence about setting minimum standards and trying to protect kids. Do any of you have a kind of answer to that riddle? And I know you touched upon it.
I think you've elegantly put what is the consistent problem that we all have. So whilst I can't speak to the ACT experience, Senator Pocock, I can tell you that there are children in New South Wales who talk about the fact that they don't have halal food, that they don't have access to cultural programs while they're in there, and that they don't have some of the fundamental things like being able to go to the school. So I think it appears, and I speak from my perspective in this in terms of New South Wales, that it is a problem that we don't really want to go in terms of truly trying to fix it and look at the intervention and look at that. As my colleague said in the opening, it is easier and sometimes politically more palatable to open a new centre than it is to talk about the difficulties that we have in terms of actually how do we wrap around in terms of a problem and how do we find real solutions, which we know exist, to truly support families. And I think everyone wants to be able to take a step back from something as opposed to stepping into it and saying, yeah, there's some real problems here and we need to come together as a collective. And we can see that the things that are currently working, every state and territory is not changing the trajectory for these young people. So I think you have put it very elegantly in that space. But also, I just think that some people, like I was saying in terms of the media, want to make it this kind of problem that's messy and yucky and they're bad kids and all of that kind of stuff. And that's easy to deal with than actually the hard work we need to be doing in terms of true intervention and prevention.
Well, we've got carrots and sticks. Do people want to talk about carrots and sticks the Commonwealth could use in this case?
Well, Senator, I think the interesting thing is that we have multi-national strategies, approaches, whether it's family violence, child protection, education, health. The Commonwealth has a stake in many of our systems. It is absolutely unfathomable to us that when the Commonwealth is responsible for the human rights of children and has signed up to the United Nations Convention on the Rights of the Child, the United Nations Declaration on the Rights of Indigenous Peoples and People with Disabilities, and many other similar ones, the Commonwealth is standing aside. The Constitution enables, under external affairs powers, to be involved. They use carrot and stick for education. We'll give you this much money, but only if you do X, Y, Z. Well, it's time for the Commonwealth to step in, because this is about all Australian children, not dividing our children up into jurisdictions.
So from a, perhaps I'll go to Queensland. From a Queensland perspective, I mean, there are as many kids in jail on a given night in Queensland as in New South Wales and Victoria combined, the two biggest states in the country. It should be a national disgrace and there should be national action. You're here in Canberra. What are you asking of the Commonwealth?
Yeah, so we're asking for leadership. We're asking to recognise the responsibility that exists for children and young people who are in contact with the criminal justice system. There's such, in terms of the policy environment that has evolved in Queensland, there is no other ending to this story than continuing to escalate the numbers of children and young people that are in watch houses. I believe yesterday was the last day I checked, there were 56 children housed in adult watch houses across Queensland, some for over 10 days. Last year...
It is basically a bare police cell with nothing.
Yes, that's correct. And so that should be unlawful. That is cruel. If I go back a decade, even 2 decades in Queensland, it used to be unimaginable that a child would ever spend 24 hours in a police cell. There were so many things put in place that made it so difficult for approvals to be given to hold a child for more than 24 hours. But now it is common practice. We are seeing children, young people coming into contact, being placed in watch houses when it is their first interaction with the system because of the presumption against bail. So it is not that the laws are playing out and focusing on serious repeat offenders, which is how a lot of those things are marketed. Many of the children that are sitting in watch houses have never been there before. So the harm that is done, the disincentive that provides in terms of helping kids to reintegrate because they're kind of feeling, I've seen the worst of it now. Those things are incredibly harmful. They are an absolute impediment to reintegration of children and young people. And I'm not sure if any of you have ever sat inside of a watch house or visited children and young people in those places. It is horrific. And so to think that we have 10-year-olds in Queensland where it is now lawful to place a child in a watch house for an indefinite period of time at the sole discretion of the Director General for that department should alarm the Commonwealth, because in terms of a worst-case scenario, the poster child of failure of our United Nations Convention on the Rights of the Child, that should concern you. But that is happening in Queensland.
And can I just add, let's think what we're creating for our society in 10, 15 years' time. We're actually creating our community right now, and this is what we're creating. We're creating people that have first contact with police and sitting in police cells for indeterminate periods of time. What is their relationship with people who we as a community expect? They're associating those feelings, those emotions with the police officers, with the correctional facilities, with the social... These are things that children don't forget and carry with them for the rest of their lives. We are creating... I think I put that the question, what do you think we are creating as we go forward, and they have their own children? It is a cycle that will not stop unless we interrupt it, and interrupt it with meaning and purpose and with the evidence that backs it, and we have that and we've shared that with you.
Chair, just with the indulgence, one final question briefly.
Just quickly,
Senator. From a Northern Territory perspective, we saw a new government come in and actually lower the age of criminal responsibility, actively wanting to put 10-year-old kids in jail. And from your perspective, when there was silence at a Commonwealth level, when there was literally nothing said and nothing done, and letting the NT do that and reinstitute Spithoods, how did that appear from an NT perspective? Charlie?
I'm going to get emotional over this question, Senator. The difficulty is I've lived through decades of racist laws and policies in the Northern Territory. My grandparents were the subject of the stolen generation, and we've had an intervention that's gone well over a decade, and it seems to me that there's a perception that Aboriginal people, particularly Aboriginal children, do not have human rights, and it's up to the Commonwealth, who is a signatory to these United Nations conventions, to honour those, to take action both in laws and policies, and in holding states and territory governments to account, to ensure that we can all realise our human rights, that they are all protected and respected within our jurisdictions. And I provided a submission to this inquiry, and I know all my colleagues did, which talks about the importance of human rights and laws and policies being consistent with that, because if you honour the human rights of children and young people, you're going to get better outcomes. And jurisdictions where that has occurred, like I've worked and lived in Victoria and had seen a marked decline for many years when I was there, when organisations, community and government were honouring the human rights of children and young people. So a marked decline, particularly in terms of Aboriginal children in the youth justice system, because they were working with community, they were working with families, they were investing in place-based responses that addressed the root cause of the crime. But sadly, the Northern Territory, particularly in the lead up to election cycles, focuses on tough-on-crime responses, laws and policies, which wins votes rather than acts on the evidence. And so it is disheartening, and I do get emotional because, we seem to be the people who are often trodden down when it comes to winning votes. And it is the responsibility of the Commonwealth Government to ensure states and territories protect and promote the human rights, embed this in legislation. They've got funding responsibilities here. They can take action in many different ways, and minimum standards would be a good start.
Thanks, Commissioner.
Deputy Chair Green.
Yeah, thank you. I have a number of questions, but I'm very conscious of the time and have an enormous respect for the witnesses, so I don't want to skim over them. I'm going to put a series of questions on notice to you, particularly around diversionary and prevention programs and the impacts of youth incarceration and the current policies that have changed recently, what we might see in 10, 12 years, as you noted, Ms Reid. If, on indulgence, if I can just put one question to the witnesses to maybe finish this session, and again, I'm sorry, the opening statements were very helpful, but we've run out of time. Just in terms of current key priorities for the Commissioners, jointly or separately, to finish, I guess, in a place where we can start with other witnesses, what are the key priorities for the Australian and New Zealand Children's Commissioners, Guardians and Advocates right now in terms of immediate policy requests or reforms?
Is that a question you're putting on notice, or you
well,
like
they might be able to point us to them briefly, and then I do have a series of questions I'll put on notice. Thank you.
Okay, thank you. Over to you.
So I'm one of the co-chairs along with...
Thank you.
Sure.
Sorry. We have a list of 11 priorities, so we can get those to you. They are due for review at our next meeting, which is on the 12th of February.
Thank you very much.
Could you provide an update after the meeting on 12 February if they are changed? I'm going to put two questions quickly on notice. If you could respond. First, I'm going to give each of you an open opportunity to respond to the Attorney General's Department submission. So if you could review that submission and provide your thoughts and reflections and any commentary in relation to that submission, please. I'd be very interested in your thoughts. And secondly, the Law Council of Australia in their submission talks about, this is their phrase, the responsibility dilemma in terms of international human rights, where you have a federal system, so the federal government enters into the Human Rights Treaty, but then you have a state which is actually legally responsible for some of the issues which are covered by the treaty and how that all works in practice. So very interested in your thoughts and reflections in relation to the commentary in the Law Council of Australia submission in section D, because there was a lot of talk about what action the Commonwealth should take. And with that, if I can thank all of our witnesses. In my time in the Senate, this is probably the most formidable panel of witnesses I've ever come across. So, Ms. Robinson, can I say to you, you achieved the aspiration you set in terms of the message being conveyed. So, thank you very much, and we appreciate your time and all the work you do in this area. Thank you.
Thank you.
We'll now move on to our next panel, and I'm going to read my blurb whilst the changeover occurs. I now welcome representatives from the Australian Child Rights Taskforce, the National Association for Prevention of Child Abuse and Neglect, and UNICEF Australia, who are joining us by video conference. Thank you for taking the time to speak with the committee today, and I'll just give you a little bit of time to... It's okay. Ms. Breeze, you can hear us?
I can, thank you, Senator.
Excellent, excellent. No one else by video, just UNICEF. Okay. Okay, so information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, could I ask each of you to please state your full name and the capacity in which you appear? And I'll go to you first, Mr. McDougall.
James McDougall, co-chair of the Australian Child Rights Taskforce.
Thank you very much. And then Ms. Waters and Ms. Al-Halali.
Lisa Waters, I'm the CEO of NAPCAN, the National Association for Prevention of Child Abuse and Neglect.
Thank you.
Zara Al-Hilali, Campaign and Policy Strategist at NAPCAN.
Excellent, thank you. And Ms. Breeze.
Nicole Breeze, Chief Advocate for Children, UNICEF Australia.
Excellent, thank you. And then we'll go to opening statements. The Australian Child Rights Taskforce, Mr. McDougall, do you have an opening statement?
UNICEF is the co-convener of the task force, so if UNICEF could make the opening statement, that would be great.
Ms. Breeze, over to you.
Thanks, Senator. UNICEF works to improve the lives of children across 190 countries. Our work is underpinned by the United Nations Convention on the Rights of the Child, to which Australia is a signatory. In Australia, UNICEF works to protect and promote these rights, amplify the voices of children and help them and young people to fulfil their potential. We're pleased to share this panel today with the Australian Child Rights Taskforce, of whom we are a member, and NAPCAN, an organisation whose vital work we respect and admire. I'd also like to acknowledge the critical leadership role of the State and Territory Commissioners and Guardians and the importance of their expertise in shaping reform. I agree with you, Chair. What a formidable group of witnesses, and I encourage the committee to take heed of their expertise and advice. For all the technical reform that needs to be done in this field, it's so important that we remember that children who encounter the criminal justice system are children first and foremost. Some of them are as young as 10, just like the children in our own families. Children and young people told the National Children's Commissioner in her recent national consultation that one of the things they want all of us to remember is that they are, and I quote, just kids who need an opportunity to go in the right direction. Children in contact with the justice system usually have multiple and intersecting needs which have not been adequately addressed by the service systems which exist to help them. They are falling through the gaps. Many are living with poverty and disadvantage. Some are children with disabilities, mental health issues and learning problems. Many have themselves been victims of crime and experienced other forms of abuse and neglect. We need to do much more upstream to ensure that they receive help way earlier, to borrow the very powerful title of Anne Holland's latest report on this issue. Because children who are in contact with the law are amongst the most vulnerable members of our society, they have special protections under international law. The Convention on the Rights of the Child makes it clear that every child deprived of liberty shall be treated with humanity and respect for their inherent dignity, and that detention should only be used as a measure of last resort and for the shortest appropriate period of time. Well-established principles and evidence point to the inputs necessary to deliver a youth justice system that truly works in the interests of children, families and communities. Yet in many jurisdictions in Australia, as we've just heard, we're seeing a trend in governments shifting away from this in favour of punitive approaches to youth offending. In some instances, we're witnessing serious harms to children and young people that do not uphold our commitments to protect and promote their rights. We need to elevate children more systematically as a national priority. We're seeing this happen increasingly with respect to gender equality and women's safety. And we're seeing commitments to work as a long-term process of reform. We need to set minimum standards. We need to engage in long-term planning, and we need the Commonwealth to enhance its role and its accountability. Finally, UNICEF Australia thanks the National Children's Commissioner for her leadership on this matter and her recent investigation. The recommendations of her report we firmly support, and we believe these provide the basis of action. Of utmost importance, we would emphasise the critical importance of adhering to international principles of child rights in reform. And we see three levers for the Commonwealth. Legislative reform. We need to establish enforceable national youth justice standards. We need to increase oversight of detention facilities, and we need to legislate human rights protections to build a culture of respect for the human rights of children. Secondly, systems reform. We must increase investment in early intervention and prevention of youth offending. And finally, there's a field of reform focused on child-friendly justice. Those children encountering the youth justice system are finding environments that are not friendly or appropriate for them. Thank you, Senators. I look forward to our discussion.
Okay, thank you very much. Senator Shoebridge, you have the call.
Thanks, Chair, and thanks everyone for your submission and the work you do. And I know that there is 100 organisations behind this submission, so I just credit you with that ongoing coordination work. The Commonwealth sets standards for safe motor vehicles, the safety of a toaster, coordinates building standards so that, patios are safe, but has no enforceable mandatory standards for keeping kids safe in detention or when they come into contact with the criminal justice system. Your report talks about the unenforceable standards and gives the case study of Banksia Hill. Does anyone want to talk us through that?
Look, I'm happy to do that. I want to start by saying the starting point is to accept the evidence that the Children's Commissioners Group has produced, and that evidence is clear. What we would like to explore in our evidence is something around the mechanisms that might work to address that on an ongoing basis, which I understand is the basis of your question.
Well, I mean, it just strikes me as extraordinary. We have standards about having a safe toaster, but we don't have standards about having a safe jail cell that we put kids in, or even a safe justice system that might prevent kids going into a jail cell in the first place.
Yes.
I personally think we should have protections for kids, at least the equivalent of toasters.
And there has been work done by that at a state and territory level. So there is a existing group of national standards that have been developed by state and territory youth justice administrators.
Repeatedly breached, unenforceable, not worth the paper they're written on.
They're a starting point. But yes, the issue then becomes monitoring and enforcement and the coordination of response and how you ensure that there is systems reform in that space over a period of time.
You sell a dodgy toaster in this country and you get prosecuted. You put a child in torture-like conditions for 10 days in a Queensland watch house and you get cheered on the front page of the Courier Mail. What's gone wrong?
Well, it is the policing mechanism, the enforcement mechanism. I think we have the skills and knowledge to be able to identify what the issues are. And I think that there are levers that the Commonwealth can use to lead state and territory governments to better practice. Currently what we have is that there is generally shared worst practice and not shared best practice. The starting point from the Taskforce's position is enforceable and monitored national youth justice standards, which are examined by agencies that are properly resourced and coordinated to be able to give clear messages to those governments when the actions they're taking are inconsistent with both national standards and international human rights principles.
Ms Al-Halali, what does enforceable look like? What does it mean? If the government in WA ignores repeated judgments of the Supreme Court there and keeps torture-like conditions open, puts kids in torture-like conditions and refuses to even comply with orders from the WA Supreme Court, what do enforceable national standards look like? What would it mean?
I think that comes back to the question that you posed earlier to the commissioners around what levers the federal government might have. And as the Western Australian Children's Commissioner identified, in education there are levers, both in terms of setting standards, the work of ACARA, and then funding levers to encourage reform. Within the health system, there are clearly very strong standards that are enforced. There are commitments that need to be made and are often made by federal and state governments, and then it's a question of what penalties and incentives, to use your expression, carrots and sticks, can be used to encourage that. It's also worthwhile looking at the OPCAT system, which is an attempt to do that progressively over a period of time, to identify necessary reforms and then monitor progress towards greater compliance. That system would be useful in these circumstances. It also calls for a parallel system that addresses youth justice in particular.
I've not heard anyone tell me that OPCAT works. This division of responsibility, a totally unfunded Commonwealth level devolution of responsibility to the states. Nobody's putting their hand up and pointing to OPCAT as a solution.
No, well, it falls back on the federal government.
So yeah, I come back to the point, and maybe I'll go to you, Ms Breeze. What should we be looking at as the specific levers, the specific enforcement mechanisms?
Yeah, thanks, Senator. I think it all starts with us working to build a deeper culture of respect for children in Australia. We've seen other countries legislate their international commitments to the Convention on the Rights of the Child into domestic law. Australia hasn't done this. Most recently, we've seen Scotland just last year put in place a federal act which then places the obligation on governments to ensure that legislation does not contravene its commitments under the convention and actually sets up legal remedy in situations where it does. So I go to the National Children's Commissioner's critical recommendations for a 10-year process of reform, and that's where it begins, Senator, with the incorporation of our commitments to the convention into our domestic law, and then that would set the legal basis for greater monitoring and increased accountability by states with respect to these commitments.
And so that would be the stick element. The Commonwealth then, of course, has funding available, and one of the other mechanisms that's referenced in a number of the submissions is once you put in standards, you can actually provide funding streams for states and territories to actually invest in the diversionary programs, and if they meet standards, they can have the funding available directly to do the kind of diversionary programs that the submissions call for.
Yeah, that's right, Senator. And I would say, one of the terms of reference for your inquiry is about how well we're going or not with the meeting of our commitments to the human rights of children. And what we can see clearly with respect to youth justice is that we are failing to support children to uphold their rights upstream. So by the time they're encountering the criminal justice system, they've already encountered multiple failures, and I'm sure my colleagues at NAPCAN can say more about that. So as the National Children's Commissioner has outlined, what we need is a national plan for children, a long-term plan for children, which has these commitments to international law embedded as their foundation. But we also need to look across all of the domains of children's health, development, learning, safety, participation, and agree what our commitments are. And you're right around the funding. We've got to increase investment in the upstream prevention and then ensure that we're working in compliance with our commitments.
Well, I'll go to NAPCAN then and ask, what's your response to Ms. Breeze?
Agree that we absolutely need legislative reform. We need to have systems reform, but we also need to bring the community into this, and we need to look at this across all portfolios. I think if we embed children and the value of children across all portfolios from an early stage, I think that we really look at prevention. One of the recommendations of the Act for Children campaign, which I'm sure the National Commissioner will talk about this afternoon, is a federal minister for children. And when we have a federal minister and we have accountability across all levels of government, I think that we can really look at valuing the voices of children in all of our portfolios.
All right. I know we're short on time, Chair, so...
Thank you. Senator Thorpe, are you there? Sorry? Oh, okay. I just want to make sure she had an opportunity. Senator Little.
Thank you. I'd just like to ask, the focus of this inquiry is mostly children who are already in custody. I want to focus on some of your ideas. We heard some earlier from the commissioners about diversions earlier, before they come into contact where the outcome is incarceration. What are some of the fundamental things that you think the Commonwealth could do in terms of the drivers of alcohol and substance misuse, domestic and family violence? We know that most of those children are in there because they've been victims, survivors, witnesses or perpetrators of domestic and family violence. I just want to understand what the Commonwealth could do in terms of program delivery to help reduce some of the risk to those children because we can control some of the drivers.
Thanks, Senator. We did prepare an opening statement, but did you want to speak to that?
Yeah. Chair, is that okay if NAPCAN presents their opening statement?
Oh, sorry, I didn't realise you had a separate opening statement.
We're separate.
Oh, sorry.
No worries at all.
That's
No
my
worries.
fault. So please
Chair.
proceed.
I'm proud to be presenting our recommendations from our submission written by a collective voice of young people aged 12 to 25 from every corner of Australia. However, unfortunately, I believe today I am the only young person presenting to the Senate today, and that is not good enough. Today, we will be providing evidence, research and the lived experiences of young people and children at risk. And yet, the children and young people who are most directly impacted by our discussions today will once again be excluded from the very tables that are having discussions around their future. We're once again replicating past systems. We know we are here because young people's futures are on the line. But why does this conversation feel different now? Because the challenges they are facing are deepening. Yet the systems meant to support them remain unchanged, overstretched, reactive, and too often failing to step in until it is too late. We cannot continue to wait for young people to be in crisis before we act. At NAPCAN, we know that this is not justice, this is neglect. Too many young people are slipping through the cracks, not because they lack potential, but because the systems designed to help them were never built with them in mind. We see this every day. Young people forced to navigate institutions that don't understand their realities. Families struggling to even access the most basic support, and a justice system that punishes rather than prevents. This is our moment to do better, to shift from crisis response to real prevention, to invest in young people and their families before they reach a breaking point, and to create a future where young people don't just get by, they thrive. The question before us is not whether we have the resources or the knowledge to act. It is whether we have the will to make prevention a priority.
Thanks, Sarah. Focusing solely on youth justice systems is just such a small piece of the puzzle. We must not mislead the public into thinking that reforming these systems in isolation will provide a true solution. While we are here today to address this piece of the puzzle, youth crime, we will not progress the entire puzzle and we will continue to fail marginalised young people and their families through enabling the ongoing system failures. Instead, we need a holistic approach that tackles the root causes of youth involvement in the justice system, from social inequalities to system failures. As a CEO at NAPCAN, I bring over 30 years of experience working with marginalised children across some of the most at-risk regions in New South Wales. I've seen firsthand when young people come into contact with the justice system, and it's often because we as a society, we've failed to support them and their families early enough. It's like putting a Band-Aid on a severed artery. If we do not invest in all of these systems before all of these children hit the youth justice system, we'll see it bleed out entirely. An overwhelmed system, worsening reoffending, and a generation of young people failed by the very structures that are meant to protect them. Prevention is not just a moral imperative, but an economic and social necessity. If we fail to act early, we're not just failing these children, we're failing society and failing at the task that communities have empowered you to tackle, or us to tackle. I for one, I want to be standing on the right side of history on this. The reality is that most children do not need to be removed from their families, that they need their families to be supported. Yet our current approach too often blames parents rather than providing the tools they need to keep their children safe and well. Prevention's not just a concept, it's an investment in families, in communities and in a justice system that prioritises rehabilitation over punishment. It's not just an initiative, it's a commitment to ensuring that young people and their families are supported long before they reach this crisis point. It means recognising that a child's trajectory is shaped not by a single moment, but by the systems and structures that surround them. True prevention requires us to embed support where it matters most, in schools, in communities and in families, so that mental health care, stable housing and quality education are not privileges, but they're fundamental rights. It demands that we confront the undeniable link between poverty and youth justice, understanding that too many young people enter the system not because they are dangerous, but because they have been denied the basic resources that they need to thrive. And at its core, prevention requires us to trust young people, to see them not as a problem but to be solved, but partners in shaping a future where justice is not denied by punishment but by opportunity. To ignore their voices in this debate is to fail them. To listen and act is how we create a real and lasting change. We would like to see a shift from a system that punishes to one that nurtures, and we would like to see, we call for the voices of the foundation of the solutions that affect them. Young people are not passive recipients. We want to hear their lived experiences and in the decisions that impact them. And one of the things that, as an NGO, we submit numerous grant applications each year, many which are unfortunately unsuccessful. These applications demand rigorous examples of long-term impact and evidence-based research, expectations that often overlook the realities faced by grassroots organisations in regional and resource-dependent communities. These communities are on the front line. They often know what works in their communities, but to be able to access the funding from government is near impossible. So in those regional areas, we often have agencies that aren't on the ground in those communities, the recipients of grants. If you go to some of these regional communities where there's a heavy debate about youth crime at the moment, we know that there's lots of really good initiatives on the ground. We need to make it easier for those communities to access funds to support the initiatives that are actually working on the ground. So we're at a bit of a crossroads. I hope that we're able to provide information, discussion that may be able to help change some of the decisions before the Senate today.
Thank you, Ms Waters. Now, Mr McDougall, did you have any opening statement you wanted to make that I inadvertently overlooked?
There are some points, but I've managed to cover most of them, I think. Probably there are a couple that I could just pick up and highlight.
Very happy for you to do that.
That would be great.
Before I go back to Senator Liddell.
Okay, no worries. Thank you. And once again, the evidence of the Children's Commissioners and Guardians has largely covered the area that we're concerned with. But our argument is that the international principles of youth justice and child rights already provide effective guidance for how youth justice systems should be run. What is missing is national leadership in youth justice, which can provide monitoring and accountability to drive improvements. Enforceable national standards are required to frame consistent monitoring and to drive accountability. That monitoring must be properly resourced by agencies with appropriate skills. It must be independent, compliant with the Paris Principles, and supported by civil society. A legislative framework would probably be required. There are plenty of existing developments, though, within government and at a cooperative level between state and territory and federal governments that already can guide in the right direction the movement, the reform initiatives that are required. We have commitment by the federal government and state and territory governments to the implementation of child safe standards, which was a recommendation of the Child Abuse Royal Commission. Think of what could happen if the child safe standards were applied, as they should be, to youth justice and to youth justice detention. If there was a full national enforceable system that sought to apply child safe standards, that would go a long way to ensuring that many of the crises that we see occurring at a state and territory level are less likely to occur. There is a requirement for coordination and cooperation. I know that Senator Shoebridge is looking for enforcement, and I agree that enforcement ultimately will be what drives governments to take measures. But in the meantime, there is a lot of existing work that can be built on. The issue is the question of monitoring and the question of how governments can be encouraged along the path of reform, whether it be in closing the gap, child safe standards, the National Justice Policy Partnership. They all provide opportunities where government comes together. The issue currently is that a lot of this is not done transparently. It's not done with the active involvement of independent monitors, community-based systems. You'll hear this afternoon from SNAICC, who also have an investment in supporting Aboriginal controlled organisations who are essential to an effective reform strategy in the space of youth justice, given the experience of Indigenous children and young people currently within the justice system. So I'll leave it at that.
Okay. Senator Little.
Just wanted to ask about thoughts about recidivism in terms of neglect. If many of those children that are in custody are there because of substance misuse in their immediate surroundings and because of domestic and family violence, what is able to be done to stop those children coming out of custody and then returning almost immediately again?
Yeah, from my experience, I think that it's circular, but if we invest in those families from the initial stages, in my time in child protection services, I've been at people's doorsteps when they're in crisis and they've said, where were you when I needed some help? Because there's no systems. The systems aren't set up to support these families earlier. If we set these systems up to support the families and also support those families when these young people are being released to community, then I think that's the answer.
Can I add that there are existing programs at a state and territory level that look at diversion. They look at the support that can be provided at a community level. They, within youth justice, as in child protection, are underfunded and not given sufficient priority. The systems that work most effectively are where they are integrated within a statutory youth justice framework. So there is a clear priority that's given to the diversion away from court system into community-based initiatives. Youth justice conferencing exists in a number of states. It draws on the resources of the community. It provides a better opportunity for victims to be heard within offender mediation systems, and there's no reason why that can't also happen in the circumstances of children and young people offending. It also provides them with a very opportunities for clear guidance about the impact of their offending behaviour and allows them to see that in a way that the experience of detention does not address. So we would argue that there are a number of existing measures which could be implemented, better funded and integrated within statutory youth justice systems to good effect.
I just want to go back to before children end up in custody. A recent report has identified in some remote areas only 3% of children are actually attending school regularly. School, we all know, provides some protective factors. If we're talking about the ability to have a view over these children early, what do we do to address getting those children into school so that we can also, you can only have so many social workers knocking on doors and by then we've already failed these children. How do we actually get those kids into school early? And we know the early childhood development target in the Close the Gap strategy is going in the opposite direction. So is out-of-home care, so is self-harm and suicide, and adult incarceration. How do we actually get those kids in view earlier if those kids aren't going to school? The most at-risk kids aren't going to school.
I think it's a real challenge, and I think that we cannot look at it as in one size fits all. And I think in regional and remote, I think those communities often know how to get those children to school, and it might be as simple as paying for a bus, purchasing a bus in a community and getting there.
In a remote community, they can walk across the road.
Yeah. Oh, yeah, but not all remote communities. Say regional New South Wales, for instance. You know, like if we're looking at somewhere like Walgett or we're looking at somewhere like Brewarrina, their communities where those type of initiatives have worked. So I think that if we fund initiatives that on a place-based basis that are tailored for individual communities and especially regional and remote communities, and we spend time listening to those communities, I think we'll have the answers.
In the APY lands in South Australia, less than 3% of children are going to school regularly. There are about 8 remote communities that can be defined as remote there. So I'm giving that example because in most of those communities, except for the outlying outstations, they can walk to school. They're not going to school. How do we actually do you have any thoughts about how we address children not going to school, because schools can provide protective factors?
Look, NAPCAM does do some work in remote communities in the Northern Territory, and I think education of parents and communities is a key aspect of that. When I've been out there doing workshops with communities and I say, hey, this could actually be something that could be a protective factor for their children, and it has normally fallen on, that's interesting. I didn't know that talking, singing, playing, interacting with my child could have benefits for them. So I think it's about educating some of those communities as well and working with those communities, because most parents would choose to do something good for their children if they knew that that would have a significant impact. So it's how do we frame that in a way that resonates with those communities for them to understand the benefits to their children. I think that that's a starting place.
And I'd encourage you to ask that question to SNAICC when they give evidence, because I'm sure they'll be able to give good examples of the supports, community supports that can be provided at a community level from Aboriginal controlled organisations.
And Senator, if I just may briefly add to what's been said already, on top of the importance of place-based solutions that my colleagues are talking about, I think fundamentally you're asking really important questions. What we need to do, again, and this goes to the need for a positive and aspirational national plan for Australia's children. At the moment, policy and service delivery with respect to Australia's children is fragmented and siloed. And what we need to do is make visible across all of the critical domains of the wellbeing of Australia's children what these data points look like. These statistics that you're raising here, we should all see them as unacceptable. However, the problem is we don't have sufficient view across these critical domains of child wellbeing. And as I said earlier, we are starting to see progress now with gender equality and women's safety. And we need we've got a women's economic budget. We need a national plan for children that makes the links between these different aspects of child wellbeing and sets in place some clear data-informed indicators about where we need to be. We can't monitor this situation. It's too fragmented at the moment. We need national focus and accountability across these key domains.
The Taskforce and Save the Children 54 Reasons and UNICEF have produced a guide document called a blueprint for a national plan for children, which we'd be happy to provide to the committee, which addresses some of these issues.
Okay, if you could provide that, Mr McDougall, that would be very helpful and appreciated. Senator Ghosh.
Thank you, Chair, and thank you for the witnesses for being here and giving evidence today. My first question is to the Taskforce, and it relates to the part of your submission that referred to victim engagement and restorative justice as a part of the process. And there was a reference here to opportunities to support victim engagement and examples of restorative justice programs in New South Wales and New Zealand. And I was wondering if you were able to briefly elaborate on those programs, the outcomes that they're potentially seeing, and also give us a sense of what types of offending profiles they've been most successful with, if that's available.
I might have to take part of that question on notice. I can indicate that in New South Wales, the Youth Justice Conferencing Scheme was built on principles of restorative justice and is integrated under the Young Offenders Act and sits within a range of diversionary options. It provides the opportunity for offenders and their families, members of local community, and where appropriate, victims to meet and develop solutions to address not only the concerns of the victims around the offence, but also the behaviour of the children. Over a period of years, it's been a powerful tool, I think, for many young people. One of its challenges is that it has been less accessible to Indigenous young people. So there is always a question when diversionary programs are developed of ensuring that they are also developed and accessible to the children who are most in need and who may face the most significant barriers. There are also restorative justice programs, which I'm sure you're aware of, that have operated in Bourke. Fewer that are specifically addressed at youth justice, but around the country there are a range of these options. The disadvantage is that they are not necessarily integrated into a statutory framework. You will always rely on police referrals, as police are ordinarily the gatekeepers, the first point of contact. So finding ways that those opportunities are available at a community level for police, and that there is a framework that directs them to use those options when appropriate. To your question of the types of offences, clearly there are some offences which are too serious to be dealt with by such systems, and there need to be other programs set in place to address them. But there is no reason why the large proportion of offending behaviour by young people cannot be addressed by one of a range of diversionary options. The more challenging circumstances is the support for those programs within Indigenous communities in a way that empowers Indigenous communities to find solutions for their own young people. And that's an area that requires greater investment.
One of the references in the NAPCAN submission was to the use of restorative justice in Indigenous communities involving the participation of elders or members of the community in that process. Are there, to pick up on where that answer left off, are there examples of where that's being done regularly or in a systematic way that we could build upon? Or
I can't speak to that. We've got two representatives, First Nations young people from the Northern Territory. I know that one works in Maningrida, so I would suspect, but I can take that on notice and provide some further details in that regard.
That would be great. Can I also ask about early prevention education, which was referred to in the submission? That's in terms of, first may I ask about engaging, the submission that says engaging caregivers in early prevention education, focusing on effective non-punitive parenting strategies and integrating culturally safe educational initiatives. Just briefly, what does that look like, and where, if anywhere, is it currently being implemented?
We undertake a lot of training in remote communities in the Northern Territory, and we go out and do educative piece that's tailored for those particular communities, and it's often about child development, domestic family violence, and obligations around child safe organisations within those communities. At the end of, it's usually a 2 or 3 day workshop, we then bring the community together, and like often in communities, we start the day with small numbers, but by the end of 3 days we've got a large amount of the community, and they come up with the solutions. So in each one of those communities, the solutions are tailored by them, and they're quite different. Some of them might have child right in when we were out at Nooka, they did here 10 principles of what we expect for other workers when they're coming into communities. We look at solutions about within the limitations of how you can keep kids safe in some of those remote communities. What are things that community members can actually do. And we were talking about domestic and family violence, and we got a phone call from a remote community that said, there was a big brawl that broke out in community, but we pulled the blinds down in the daycare centre and we started singing with the young people because we talked about the impact of violence on brain development. And so I think knowledge is really powerful a lot in those communities, and I think we underestimate the lack of knowledge and education that is available to those communities in a way that resonates with them.
Thank you, Chair.
Thank you, Senator Ghosh. If I could just ask you to take on notice 2 questions, and I'm asking all the witnesses to take these 2 questions on notice. Firstly, if you could provide your response and comments with respect to the submission made by the Attorney-General's Department. So interested in your perspective in relation to their comments and positions. And secondly, the Law Council of Australia, in its submission in section D, refers to, quote, the responsibility dilemma, end quote, whereby a federal state enters into international treaty obligations, but in a federal system, state and territory governments actually have responsibility for areas which fall within the purview of that treaty and the sorts of issues that leads to in terms of effective enforcement of the treaty obligations. Would you be able to provide your comments on that on notice?
Yes.
Yep, thank you. Thank you very much. So thank you for appearing today. Thank you for your submissions, and thank you for all the work you do in this space. Thank you.
Thanks for your time.
Thank you, Senators.
I now welcome representatives from Shine for Kids, both in person and via video conference. So if you could come forward. Thank you, Ms Horrigan. Also, the Australian Youth Affairs Coalition via video conference. And also Justice Action, both in person and via video conference. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, I'll ask each of you to please state your full name and the capacity in which you appear, and I'll go to the witnesses from Shine for Kids first. So, Ms Horrigan.
Julie Hourigan, I'm the Chief Executive Officer of Shine for Kids.
Thank you. Ms McPhee, can you hear me? You might be on mute, Ms McPhee.
I can't hear you. Sorry, I'm having troubles with my camera. My name's Tanya McPhee and I'm the Mentoring Manager at Shine for Kids.
Excellent, thank you. Now I'll go to the Australian Youth Affairs Coalition. Mrs Rostami.
Joanna Rostami, I'm the CEO of the Australian Youth Affairs Coalition.
Excellent, thank you, Mrs Rostami. I'll now go to Justice Action. Mr Collins.
Yes, my name is Brett Collins. I'm the Justice Action Coordinator.
Thank you. And Mr Dowd. Sorry, Mr Dowd, you're on mute.
Hello.
Hello.
I am the head of the Community Justice Coalition, and which part of which is Justice Action, with whom we work most of the time.
Excellent. Thank you. Thank you very much. I'll now provide an opportunity. Sorry. Oh, Mr Collins. Yeah, I think he did. Yep. Thank you for taking the time to speak with the committee today. Do any of the organisations have opening statements? Ms Horrigan?
Yes, we do. Thank you, Senator. Shine for Kids has more than 40 years' experience working with children and young people affected by the youth justice system, including young people transitioning out of custody. We deliver holistic, innovative, trauma-informed programs and services to break the cycle of intergenerational disadvantage and incarceration. We support around 6,000 children and young people each year. On any one day in Australia, there are about 44,000 kids who have a parent in prison. Those kids are 6 times more likely to end up in youth justice than a child not experiencing parental incarceration. When a parent or a primary carer is arrested, their dependent children face sudden separation, which is highly distressing and traumatic, and which is compounded by living disruptions and instability, family breakdown, child protection interventions, poverty, poor communication or information about what is happening, and inadequate connection to trusted support. I say there are about 44,000 kids because in no state or territory is there ministerial accountability for these kids. We need national leadership to identify and respond. It's essential to identify at-risk children before they disengage, disconnect or offend. Shine for Kids recommends that government invest in identifying children experiencing parental incarceration to ensure they are connected and counted with specialised community-based support. We recommend investing in early intervention social and emotional wellbeing programs. We also recommend investment in pre- and post-release services for young people. Over 80% of young people released from sentence detention return inside within 12 months of release. This revolving door costs taxpayers enormously while doing little to address the root causes of offending and reoffending. Shine for Kids believe that investment to scale quality services which are co-designed, culturally safe, effectively evaluated and which address the well-researched risk factors of young offenders is essential. Every step along the road helps rewrite a young person's future. We need to keep young people out of prison so that cycles of offending and reoffending are broken. Thank you.
Excellent, thank you. I'll now go to the Australian Youth Affairs Coalition. Do you have an opening statement, Mrs. Rostami?
Yes, I do.
Over to you.
Thanks to the committee for the invitation to attend today. We are the National Youth Peak body and we represent more than 4.7 million young Australians across the country. Our members include youth-led organisations, youth sector organisations and young people themselves, and our work focuses on systemic advocacy, research, sector support and youth engagement. Our submission demonstrates that Australia's youth justice system doesn't work well. The youth justice system claims to prioritise community safety and the rehabilitation and reintegration of young people who offend and contribute to a reduction in reoffending. However, evidence shows that these goals are rarely achieved under the current framework. The punitive approaches in place today not only fail to rehabilitate young people who have offended or reduce recidivism, but often worsen outcomes. Instead of reducing youth crime, these punitive measures often stigmatise and marginalise young people, especially those from vulnerable backgrounds. In our submission, we advocate for action on a range of recommendations, including a focus on prevention and early intervention, ensuring the rights and best interests of young people are kept at the forefront of policy development, national minimum standards, a national strategy for children and young people, youth impact assessments, and investing in youth organisations that provide a holistic community-based support, as well as a number of other recommendations regarding First Nations, reporting in the media, and even just how youth workers are referred to within the justice system. But the thing that I really want to leave you with is the message that I believe that action can be taken. It's time, really, for Australia to rethink its youth justice system and adopt strategies that promote rights, safety and wellbeing for all. You're no doubt well across the many issues impacting the success of our youth justice system at this point and the many contributing factors, problems and pitfalls. And I'm sure that you are likely overwhelmed by the number of reports, studies, statistics, facts, inquiries that have incurred into the youth justice system in Australia and elsewhere. And I think it really gives the impression that it's a wicked problem that maybe is too difficult to really solve. But I really want to emphasise that there are actions that can be taken that will work, and I believe that change is possible. They just need to be measurable, accountable and resourced, but it can be done. And when you look in other jurisdictions like Scotland, Spain and Ireland that I know were referred to as well, shows that changes can be made in justice systems that result in improved outcomes, although Australia has its own unique set of factors that need an appropriate Australian response. Making necessary and bold changes to our justice system is not just a question of justice for young people, but it's one of smart governance. It's possible for Australia to lead real change that result in better outcomes for young people and for Australian society, and this includes economically. So I would just really like to reiterate that a focus on prevention, early intervention, rehabilitation and addressing social inequalities would lead to better outcomes for young people and society. And I believe there are actions that can be taken. And in closing, I'd just like to say that we support the submissions made by the organisations presenting with us today and the important role that they play in supporting young people in the youth justice system. And the other submissions that I also we've worked with the organisation, the Australian Child Rights Taskforce, as well as the State and Territory Youth Peak. And we welcome the opportunity to be here today and answer any questions that we can.
Thank you very much, Mrs Rostami. Mr Collins and Mr Dowd?
Yes, Mr Dowd will lead actually for us, please.
Mr Dowd, over to
you. Firstly, we would like to thank the members of the committee for the work that they are doing because of the significant importance of this area of concern. The Community Justice Coalition has been concentrating primarily on the use of computers in prisons generally, and now, of course, with youth. New South Wales, we would like to think, encouraged by us, it has joined the ACT in computers in prisons for adults, and we are working with them to improve that. There needs to be improvement in formal education, but in terms of computers, they are starting to spread that. The youth, those concerned with young offenders in New South Wales are a very impressive organisation, and we are very supportive of the work they do, but join them in the request for computers. Young people are more likely to use computers than adults. Not everyone, but the majority of them are more used to it, and the use of computers will help them with the skills for later on in life. The use of computers will allow mental health counselling. There is an inevitable mistrust of prison counselling systems that it will be used against them, and there are organisations that can provide that and continue it outside in complete confidentiality. So our main concern is to stop young people being stuck alone in cells for a large part of their life, particularly Indigenous people who are not used to it, who have no consciousness of it, and who have the greater need for that. So we thank the committee for the work they're doing.
Okay. Mr Collins, did you have anything to add?
Thank you for the opportunity to speak. I speak as a person with lived experience. As a kid, 17-year-old kid, I was in Youth Justice Centre, and then at the age of 23, I was given a 17-year sentence and served 10 years of that. So I have a special role here, and I'm probably the only person to present to the inquiry who's actually sat inside a cell. And I feel I have a special role and a special responsibility in doing so. Now, I'd like to say, first of all, that I think there's a structural problem in the inquiry, and that is the people who have not been, who are most seriously affected by the youth justice system have not been acknowledged. And it's a structural problem. It's a problem that continues. So we're all talking about the kids when in fact they have a chance to, and should be encouraged to speak for themselves, as they have their own representatives, and they could easily have received copies of the terms of reference and been engaged. I think even if it wasn't significant, the fact that they were acknowledged is an important issue. So having their voices, and their voices before, first of all, to be acknowledged and see that being acknowledged and see that they have some measure of empowerment in the process. Now, I also think it's really important to understand what it is like to be in a cell, because we've heard about it from other people, but I think it's really important that people who are making judgments should actually be in a cell for a day and a night, and invite the committee to actually do so before the report, and just be there for one day in Bimberry, because we're actually asking why is it that in Bimberry they have no computers in cells yet? It was actually built after the Alexander Magnetic Centre. So in 2008, the Bimberry was built without a computer in their cells, whereas the adults got it immediately. They've had it for 16 years. Now, that needs an explanation. We're actually asking that quite a careful question. Now, it does make an enormous difference for a person to be not isolated from family. Everyone's talked about how important it is to have a family. Everyone's talked about how important it is to have restorative justice and also access to lawyers and counselling. Now, all those things are achievable very simply and very easily with a computer in their cells. But the kids have been deprived of that, and we're not talking about only the Bimberry Youth Centre, we're talking about 880 youth justice detainees across Australia. Now, that is not an expensive thing to solve, and it's the sort of thing that could be solved by this committee, and we invite the committee to make a recommendation that it should do so. Now, we actually did a careful examination of the costs to actually put a server into a 600 prisoner prison. 600 prisoners, very much larger than a youth justice centre, which normally has about 80 or 90. The cost was only $260,000 to put the server in, and $130,000 to maintain that server over a year. Now, we had that quote. We also have got a quote from a supplier, Optus actually, who said that it would supply an unlimited bandwidth, right, to that 600 prisoner prison, and it would cost a bit over $1 a month to maintain unlimited video calls. Now, if that cannot be organised and that cannot come out of the Senate committee, then you should be asking yourselves why not. Now, we're also looking for support. Now, we heard earlier about how are you going to solve these problems when they come out? How are you actually able to look after them? What's the solution for that? The solution for that is easy. What you're not understanding is that kids trust each other. They look up to their peers. And if you've already been through the system, if, for example, you're a big tough crim, then quite often somebody who's been in juvie looks up to you. So what you're really looking for peer mentors, people who've actually done it. You're not talking about psychologists and psychiatrists and all that. You're not talking about them because they're just part of the system. We're talking now about people whom you trust and people who you look up to, who are role models for you. And you need to also look outside of education. Most of our team, my people, have been expelled from school, as I was. We are the rejected people. And the way you reach us is you reach us through things like music and art. And you have a chance then to have also role models who've succeeded, and then you give them trust, but you have to work with them. At the moment, you're not even trying. If you haven't reached out to them in communication, to ensure that their representatives are contacted, then you've missed the point. So what we're looking for first of all, a continuation of the iExpress service. Now, iExpress was acknowledged as first in the world as a presence in cyberspace of people who are in detention. And what we want support from the committee for all youth in detention to have an entitlement to an iExpress email address, so they then have a presence, have a voice, they have stability in cyberspace. It was acknowledged as first in the world. And we would like that support for the committee for that to occur, so kids are not forgotten, they don't have a voice. You've got 880 kids who come on and have access then to services which currently are not being offered to them.
Thank you. Thank you, Mr. Collins. Thank you very much. I might start off with just two quick questions before I share the call. Mr. Collins, I really appreciate you sharing your lived experience with the committee, and I couldn't help but reflect as I was listening to you, eloquent, passionate, persuasive, what were the things that helped you to actually move from that lived experience to now sitting before a Senate committee and putting extraordinarily impressively structured and persuasive arguments?
Well, look, first of all, support from inside the prisons. I went in as a university student, and I was amazed at the people I found there. They were good people, not bad people. They were the same people as you and I. And it made such a big difference. It meant that, and also I was a troublemaker in prison. So I have the very proud record of being the longest of any person on a prison roof in New South Wales. So I actually needed support from my fellows, and they gave me support, and I feel that I have a role in representation. But we have 42,000 people out there, most of whom have been in juvie before they go to prison. Right, so there's an obligation. There are a lot of good people in there who can make an offering, but you need to turn them on. As we said, flip the switch. Allow people to not just be passive, watching mindless television, because every youth justice cell has a television cell. They each have a television cell. But what we're asking only is that we should flip the switch and have it so it's interactive, so the kid can actually respond. And if you're actually teaching them, say you're offering them some services, some counselling, can they respond to the counsellor? You know, that's not unreasonable. The screen's already there. There's already a coaxial cable. All you need to do is allow them to respond, and then you're respecting them as well. And all the other services come on as well. All that import model then comes into play. You have the first time you have access to mainstream services. You have access to education services. You can then for the first time you have restorative justice happening in the cell when they first go in there. Instead of waiting months and months after court hearings, you can actually initiate it straight away. And you've got trusted counsellors who are already paid for outside. You've got all of them outside waiting to give service. People like Julie outside, you know, and her staff, who could actually be giving counselling, trusted counselling from outside, and then when the person's released, they get out to people whom they know. Right? It makes all the difference. So there's follow-through as well. You've got there's continuity of service. And you also feel as though you're supported from inside your cell. You've got support from outside as well. So you haven't lost connection with the community. You're part of the community still. It's obvious, but it's not happening. That must happen.
Okay, thank you, Mr. Collins. Mr. Dowd, I'm going to tap into your considerable experience in a number of spheres, and I'm going to read to you the introduction, or a sentence from the introduction of the Attorney General's Department submission. So this is the Commonwealth Attorney General's Department submission. This is from their introduction. So this is the first sentence, really, of the submission. In Australia's federal system, states and territories have primary responsibility for youth justice and the criminal justice systems in their respective jurisdictions. The Australian government has limited areas of responsibility for youth justice, including through Commonwealth criminal laws that apply to young people and working with states and territories to implement Australia's international obligations. Full stop, end quote. The Attorney General's Department then provides a number of examples how they're seeking to cooperate with the states, to lead processes with the states in relation to a number of aspects. But it does lead to this question of, and the other introductory point I'll make to you is, in terms of responses to this committee, and we went out to all of the states and territories, we only received a response from one state and from one territory. So it does raise this question of how do we manage the political ecosystem of a federal system to try and get everyone moving together in the right direction? What's the way to do this? Where obviously you've got state governments who are very aware that they've got primary responsibility, as the Commonwealth Attorney General's Department puts it, with respect to the youth justice. But then we have witnesses who are saying the federal government should take a lead in terms of processes. How should we view that dilemma, and what thoughts do you have with respect to how it can be navigated?
The most effective means from when I was Attorney General for New South Wales was the Standing Committee of Attorneys General, that we changed a lot of laws by the collaborative work of the Attorneys General, and we would distribute to each other various acts and so on. Now, I know these don't come under an Attorney General, but ministerial councils are a very good educative and coercive means of changing conditions. The recommendations of the committee, therefore, would be to go to the responsible meeting of Commonwealth and State and New Zealand ministers with your recommendations, because it's the states that do the bulk of the work, but the persuasive power of the standing committees is a very effective tool and one that I recommend.
Okay, thank you very much. I'll go to the Deputy Chair who has some questions.
Thanks very much, Chair. Thank you for your evidence today and for your submissions. I wanted to ask a question first to Shine. Your submission discusses some of the statistics of people that are entering prison, particularly those with dependent children in the community. And this is a phenomenon I wanted to ask about in terms of the support that we're giving to these children if that occurs. What support, if any, are provided to those children, and how do you think, from Shine's point of view, we can support to reduce the risk of contact of these children with the justice system later on?
It's impossible to answer what support these children are getting because we don't count them and we don't identify who they are. And so we need to go back to the beginning and acknowledging the distinctions between state powers and federal powers, and not suggesting for a moment that police or school teachers need to take more on. But at the point of arrest, there is no mechanism to ask an adult or a young person being detained if they are the primary carer of a child. And because of intergenerational offending and a distrust with statutory systems, people tend not to offer up that information until they're asked. So we miss a vital opportunity right at the beginning to stop children being referred immediately into a statutory system. Our police are mandatory reporters, and so we need to work out how we have an alternate system that doesn't simply funnel more children into statutory child protection systems that we know don't work and that are failing our children, and how we can come together differently to work out how we identify children quickly, ensure that they're safely housed, that they're being looked after, that they're in a position where they can be supported to continue going to school. Shine for Kids hears way too often about a carer who is detained on a Friday night or a weekend, and nobody knows that there are children on their own until children fail to turn up at school Monday, Tuesday and Wednesday, and then someone raises an alarm bell. So we don't know exactly what's happening for these kids because there's a don't ask, don't tell mentality, and it's very fragmented.
Okay, I understand the gap in terms of asking the question. Would there also be some reluctance of those families to provide that information because of, past experiences with child protection, or wanting to make sure that children are cared for within a family system or structure?
And that's why it depends who's asking the question.
Right.
We need to reframe our systems so that the community sector and trusted community partners are hardwired into that system, and we don't simply rely on police or teachers or a child protection system to be expected to catch and identify these kids. If we identified these kids early, it would be much simpler to ensure that they remain safely in community and connected through the networks that they trust, whether that's family or their faith or sport or school. We could keep them connected to the things that mattered.
The other question I had was raised by both submissions and the evidence this morning. It's around peer mentoring. We recently had the experience of meeting someone who operates in this role as essentially a mentor to young people who are coming through apprentice programs, but there's actually no defined job role as a mentor, and that's his role, that's what he does. He's Indigenous, had a really good experience with the AFL and was able to come back to community and give that experience as an alternative example to young people. But he's actually employed in a different role because there's no defined funding or support mechanism for a mentor for these kids as they come into apprenticeships. What supports are available, or what would you like to see for more peer mentoring programs to take place, particularly in regards to restorative justice of youth offenders? Because I guess the message from that particular gentleman was that it was very effective, it worked very well, but it's not something that is, it's a bit of a potluck in terms of whether someone comes across a mentor like that.
I'm going to defer to Tanya, who is one of our Shine for Kids mentors and is our mentoring manager.
Wonderful.
So, Tanya, I don't know if you're still having trouble with your camera or not, but over to you, please.
The camera's glitching and won't stay connected. So I think that, you make a very good point that peer mentoring is something that's very effective. It actually happens within youth justice centres without it being labelled. You'll see some of the older young people that have become role models for the younger people that are incarcerated, and they actually will take young men who have, I guess, proven to have made some big positive changes in their life to the high-risk unit to spend time with the boys that are really at a low point in their life where they're in lockdown for a lot of the day. So I think peer mentoring is a fabulous idea. But I also think that there does need to be, as you say, a job description. There needs to be, a clear outline into how you can deliver that mentoring in a safe way, because oftentimes, and I say this with all respect, people with lived experience, and I want to say that I've had a younger brother who was incarcerated, tend to sometimes overly identify with the young people, and there can be an issue around boundaries, if that makes sense. Yes. But I think peer mentoring is a wonderful thing on the whole.
Perhaps.
Can I just add something?
Yes, of course.
For us, peer mentoring is actually a very significant thing. In fact, we launched JA mentoring in the year 2000 in Toronto, and we've done a lot of work behind 23 years mentoring people coming out of the courts as community service orders. 23 years experience in there. And what we found was there were parallels in the consumer worker situation with mental health. In fact, quite well supported, actually. And so that whole question about what happens in mental health as opposed to what happens in criminal justice, there's a similarity there. And so the consumer worker or the peer worker is actually quite well defined in mental health. So we've been giving a bit of support in there too, because we found psychiatric institutions and prisons, they link more and more closely together. Some nice structures in there that are worth looking at.
Well, if there is any examples, perhaps if you could take that on notice, and if there are any examples of jurisdictions doing it well, or where it is funded or supported, perhaps if you can provide that on notice, that would be helpful.
So Shine for Kids does receive funding through New South Wales Youth Justice to deliver a mentoring program. It's pre and post release. It's called Stand as One. We also receive a little bit of federal funding through DSS to deliver it in Townsville as well. Okay. And we deliver it in New South Wales, we deliver it to young men and young women who are inside. And the reason it works is because it's pre and post release. Our mentors are are a part of the multidisciplinary teams working with young people inside, but then they also are working with families outside to ensure that there's connection, that there's healing, that there's those relationships being built and put in place, rebuilt where necessary, so that families have a voice about the support they need for a young person to come home, and a young person has a voice about whether going home is what they want to do, and if they want to live independently, depending on their age, what that looks like, and how the proper solid case plans for post-release are put in place so that young people are set up for success, not failure. And the post-release works really critically because we can't be everywhere in every community, and we don't want to be, but what we are is that conduit to support a young person post-release, because when they're going back into their community, there are often wait lists, very long wait lists for local services. They have to retell their story to access those services, and statistically young people are most likely to reoffend in the first 6 months post-release. And so in that, we can bridge that gap while young people are immediately released, making sure that the warm referrals and the connections back into the support systems locally stick, and that if it starts to go wobbly, they've got someone who they trust. Because once they leave, even they could have the best relationships with their caseworkers inside, but as soon as they walk out that door, those relationships stop. And so we need that continuity of care and support for our young people, so they know that somebody who they had built a relationship and trusted inside is there to help them maintain connections to education and employment, to get their housing set up, to make sure that the only people who they're not going back to are potentially the networks that got them into trouble in the first place. They have to have someone in their corner, and that's what an independent mentor can do, is walk that really difficult post-release stage.
Thank you. Well, I hope your employees and staff in Townsville are safe, if not dry.
Wet, but they're safe, yes, thank you.
Yeah, thank you. Thanks, Chair. Conscious of time.
Thank you, Deputy Chair. Senator Little.
Thank you. Just noting that this particular committee is looking at all children incarcerated, I just want to ask, there are systems already in place. The custody notification scheme is in place across Australia for Aboriginal people who find themselves in custody, who go through the Aboriginal Legal Services, and they, from my memory of it, and very close memory of it, they are specifically asked a question about, is there anyone else in your circle that requires you to care for them? Because that is a really important question. So I'm just wondering, is it possible, given that system I think is still in place, and I think it might have even just recently extended its funding, to improve on that system to ensure that those children are identified at that point at which they're probably at greatest risk?
Absolutely. We need to be building on what we know works to make sure that all children are being identified, and to make sure that anything that is already in place is as strong as it can be to be supporting the safety and the well-being of children.
Thank you. Mr Collins, I just want to ask, touching on what you raised around television, understanding that people go through various phases of emotion when they're first incarcerated, but I want to ask you about the television, because it has been raised with me directly that children incarcerated, that's an opportunity to start beginning re-engagement and engaging them in education, in counselling, and you've come up with an idea that connects them to people on the outside. My question relates to, this was put to me, they have televisions in their cells, and if they don't want to participate in the education, they're just left in there with the television on all day. What do you do to actually overcome that?
Well, I mean, the easiest thing, of course, is to have role models and to have a sense of what you might achieve. I mean, and also having, if you've got no stimulation in a cell, you've only got a television, you've actually blocked in that chance to actually have some sort of intervention. So you really should be able to have either the choice of speaking to your family or the television. It's one of those very simple questions is, do you want to watch your television or do you want to talk to your mum? So at the moment, and people would also, kids feel sorry about what they did. They'd like to say, can I say sorry from inside their cell? That's the sort of stuff we're talking about. If you have an interactive device, you have a chance for the person to then express themselves properly. So I don't think there's any question about the desire of a person in their cell to be to actually say something. They're actually bored, and the television itself just drowns them out, doesn't give them a chance to express themselves. That's the problem.
So I want to ask a question of anybody who would like to respond to this, but recognising that the rate of recidivism of children who actually end up in custodial settings is high, and those children are likely to have had a parent who is either in custody or both parents in custody possibly, what's the importance then? And we hear a lot of programs when people have got responding to these things. There's money everywhere, and everybody comes up with this new great idea. And what I go to all the time is the clinical interventions that must sit beside what you hear constantly, and it seems to be elevated, is this connection to culture, as opposed to, well, that might be significant. So is responding to trauma and interventions using a clinical pedagogy that actually helps address those issues. Tell me how important it is to make sure that those things are interrelated, working together, and lock, stock and barrel beside each other rather than going off and doing one of those things.
Sorry, I don't think you understand how isolated a kid feels when they're held inside a prison cell. They actually don't want to relate to their guards. They don't want to. If they're speaking to a counsellor, they know that they have to tell lies to the counsellor. Everyone knows that. You're not going to tell the counsellor something that's going to work against you. So you have this total a brick wall where you feel as though you're not getting any support inside the Youth Justice Centre at all. So you can throw as many clinicians as you want into the system, but you're not touching the kid at all. You really have to have the chance, first of all, for the kid to be able to speak to if it's not their parents, if their parents have been arrested, at least some elders in the community to link across to the support that you're talking about is created in the community. That's got to be linked across to the kid in the cell to make them feel as though they've got something outside there for them, and then linking into things they can do. So art and music to give them a chance to do something new. So that's what you have to do. Don't to suggest that clinicians have any benefit at all for kids. All you've got then is a diagnosis, and behind the diagnosis you've got things like, for example, we heard from Youth Justice in New South Wales. They said 90% of the kids in Youth Justice have mental illnesses. Really? 90%. And they said, and behind that, we know what happens to people who have got diagnosed as mental illnesses. They all get medicated, whether they like it or not. There's none of the social interactions and support. You're sitting in a cell and you're left to be, you're either injected or you're taking medication, and you have the self-identification as a sick person. When the figures like 90% of people being mentally ill in the cells, when those things are openly stated, that's a real problem. It is a problem.
I think I was talking more about programs that sit outside of that are. That's why I mentioned, things like boot camps, things like people come up with these ideas all the time, and there's actually nothing attached to them that would actually address necessarily some of the trauma that requires potentially a clinical intervention or other intervention.
It requires social support. It requires, first of all, somebody to have been in the same situation themselves, and then to talk with them, to share with them and see where they're going. They need to, when a person comes out, they need to have somebody beside them. That's when the mentor or Julie's team comes in to assist. That's obvious, but it's not happening. How could you possibly expect someone who has a counsellor inside a juvenile justice centre, who has to talk to a counsellor, has to tell lies to the counsellor in order that they get a lesser security rating or they're released, and they're released to nothing? How can that possibly work? Of course it can't. So you need to have external services coming into the person, into the cell, where they are most of the time, where they haven't got other naughty kids running around and dragging them all different directions, and they have a chance to concentrate on what's being said to them privately, and then have somebody whom they can trust to talk with. It's obvious. And then for that person to be outside afterwards. The clinicians do not solve the problem. That's just a superstructure which costs, that's where the $1.1 million a year is spent on each kid. And you have 85% recidivism. That's an outrage. It can't be accepted. You have to say that's wrong. And you cannot refuse access to computers and cells when you have that sort of money being spent. And Youth Justice told us, they said last week, that they did not have the allocation of money or they were committed to having computers and cells. So it's as simple as that.
I just add to that, I don't think it is the community is aware the high percentage of mental health problems in the adult system as well as the youth systems and that requires a lot more emphasis. The cost of crime is horrendous and is not taken into account. Youth have a need for mental health both before they go in, when they're in and outside. And young Indigenous people have the additional problem of fetal alcohol syndrome, which means that they will not do well at school when they get out. So that we need to have a greater consciousness of the need for mental health assistance that cannot be provided trustfully by the prison system itself.
Okay, thank you. Senator Shoebridge.
Thanks everyone for your submissions and your work, ongoing work over decades. Ms Collins, I very much hear your call and saying if kids have access to a TV, at least make it interactive so they can contact community, contact families, so they have some kind of ongoing connection. That seems a sort of low-hanging fruit, really, doesn't it?
It is. It's obvious. Yeah. So obvious.
Yeah. But of course, I mean, a lot of your work is in New South Wales. You're probably aware that in Queensland and WA and NT, often kids have nothing in their cells, like absolutely nothing. No TV, no connection, just a bare cell. That's even crueler, isn't it?
Sure, outrageous. And how can it be possibly justified with the amount of money that's being spent as well?
Yeah. Yeah, I know. I mean, I think it's appalling to think we would throw a 10-year-old child into a cell and just give them a TV, but throwing 3 10-year-old kids or a 10-year-old kid and 2 14-year-old kids into a cell and giving them nothing, like that's the lived experience often in Queensland.
Or a young person into an adult watch house in Queensland.
Yes. I mean, how would you define that? A national system that lets a young person, a 12-year-old girl, be put into an adult watch house in Queensland. How would you define that?
It's cruel, it's inhumane, I'm sure it should be illegal. It has to be against every child rights principle that stands under the conventions of the rights of a child. It's heartbreaking.
What about the fact that it's not illegal, that we know it's happening, and in fact we know that the NT, for example, recently lowered the age to 10. What do we say about a national system where that's not illegal, where it is lawful to put a 12-year-old girl in an adult prison cell in Queensland?
It says that we're fundamentally misunderstanding that these are children. And we have to continually go back to how do we make sure that we are looking after the social and emotional well-being of children. And yes, sometimes kids do bad things and sometimes kids make bad decisions, but these are kids and we have to make sure that our system responds as children and has age-appropriate responses in place that are responsible to be able to support kids to make better decisions and to move forward in their life and not be branded forever as being the bad kid.
And can I add to that, giving that kid, 12-year-old girl, access to a tablet or computer in her cell so she can express herself, then gives her a chance to express her anguish. And then you empower the girl in a way that otherwise wouldn't happen. So it would only require that tool to ensure the isolation was not complete. That's the sort of empowerment we're talking about. We're talking about a game changer which allows a 12-year-old child in horrendous conditions to actually have the right to communication.
And I understand that if we're at that situation where a child's in a jail cell, that having that kind of access is positive. But do I understand from your submission is the best solution is not to put the child in the jail cell in the first place, to be having those diversionary programs and direct connection with communities?
Absolutely.
Yep. The chair asked some questions about the Attorney General's submission, the department's submission here. One of the big chunks of the department's submission is referencing the June 2023 Justice Policy Partnership Framework, which is a one-page PDF that was apparently drafted between representatives of the Coalition of Peaks of Aboriginal and Torres Strait Islander justice experts and Australian state and territory government reps. Now, you know, I've read that in detail. It's one page. But it was in June 2023. It reads like an act of science fiction. It talks about transforming justice systems so that they work for and not against Aboriginal and Torres Strait Islander people, eliminating racism, embedding self-determination, formal partnerships with Aboriginal and Torres Strait Islander people, strong and effective Aboriginal and Torres Strait Islander community law and justice sector, holistic and integrated systems. That was done in June 2023. Since then, we've seen attack after attack after attack in most states and territories. What did we say to the Commonwealth when they reference an obviously failed strategy?
It's obviously hypocritical, and clearly they're saying something which is entirely untrue. What an untrue position, and what a wrong position.
And I suppose, Mr. Dowd, I know you talked about the standing committees, but this was partly generated through standing committees, the Justice Policy Partnership, and I would endorse it 100%. It seems to be directing, if it was ever implemented, it would be directing the criminal justice system in the right way, but none of it's been implemented. In fact, it's been routinely ignored and abused by state and territory governments since they entered into it. What do we do?
The primary thing is a committee such as yours can reinforce. You can't force governments to do anything, and most decisions in government are made by Treasury, and it depends on who the officer in Treasury is who's concerned with corrective services. But if you have fiscal control through the states, then this is a very low priority because they don't understand. I mean, we know you understand because you've helped us over the years and the work you've done on corrective services over decades. But there's a limit to what we can do to force governments to do things, but committees such as yours and the standing committees are the most effective tool. I mean, with the Commonwealth Corporations Act, 3 of us across party lines put that together from the Standing Committee on Attorneys General, and that became law. So it's a matter of having at least one Attorney General or Minister concerned to be educated and to lead the others.
Senator, if I may.
Yeah, Ms. Regan.
I would question the statement that Chair read out earlier from the Attorney General's submission that said the Australian government has limited responsibility. I think.
Sorry, can I just
that was
clarify?
You read that from the.
So you're not questioning that I read the quote. You're questioning the submission.
Some of the content
over
that was in it. Yes.
Want to make
Sorry,
that clear.
Chair.
We're not verbally in the
that
chair.
Was Australian. No, I think. I think, Chair, what you said in the quote was that states and territories have primary responsibility, and Australian government has limited responsibility. I think, paraphrasing. And it's that last bit that I would question, because Shine for Kids receives funding through both DSS and NIAA, which are federal agencies to deliver frontline services. And so, Senator, when you're asking what the government can do. It can actually lead by example. If the federal government has a statement out that says all of those things that everybody would get behind and support, it needs to lead by example and ensure that the services that they are funding and supporting to be delivered and the outcomes that they are setting as key goals within those frameworks, that they are actually being held to account to ensure that they are being delivered. Because I don't think there's any disagreement that we're not meeting any of those aspirations.
Well, I mean, and I might put this question to Mrs. Rostami. We heard from the Children's Commissioners the example that there are state and territory agreements in the health sector which say Commonwealth funding is only provided if states and territories meet certain targets. It has mandatory provisions in it. We have the same actual legal obligations on funding agreements and which have compelling elements in them in the education sector. Why is there none of that in the youth justice sector? What's special about it that just lets, to use perhaps an inappropriate quote, let states and territories get out of jail free in this space?
I don't know the answer as to what's special about it, but that sounds very much to me like an approach that would work well. Like, it's worked well in education, particularly in some jurisdictions. I'm from Tasmania originally, and I know that all those agreements have led to change. If we look at the NDIS as well, for example, where there are state and territory agreements, it does work effectively, and it would be a really, really useful way to lead and, I guess, expect change. So I don't know the answer as to why, but it certainly sounds like a very good recommendation to make.
Well, I mean, we know that states and territories are still running incredibly abusive institutions, even when their own state inquiries have shown it. In Tasmania, there was a Royal Commission that found out that the Ashley Detention Centre was a site of ongoing horrific sexual violence, particularly against girls. It's still operating. No one's been prosecuted or held to account. We know that there was a Royal Commission in relation to the Don Dale Detention Centre, found horrific abuse of First Nations kids. It's still operating. In fact, the NT government is looking to put further funds into it. Surely doing nothing is failing those kids.
Absolutely. I think one thing that really bothers me about, and I can speak more so from Tasmania. Many years ago, I was on the Ashley Youth Detention Centre Advisory Group. And one thing that I found really difficult to overcome, and it's really disturbing when years later you find that when they do an inquiry, things come out. But it felt very much like any issues raised, there was a real culture of cover-up. So many of the issues that came out in the inquiry, for example, were things that were raised long ago and were brushed aside. And so many of the things are really obvious as well, like computers in the room. That seems, disturbingly obvious solution to so many problems like continuity of care and connection to community. In Tasmania, where there's only a couple of girls and they'd be put with all the boys, and as you'd expect, the outcomes were not great. It seems blindingly obvious. So if states and territories are not able to, I guess, run those in a rights-based, fair way, then I really do think it is up to the federal government to expect change and demand change. It's so many of these things should not be happening and have really quite obvious fixes.
And when the Commonwealth produces a document like this, Justice Policy Partnership, and then sees pretty much every element of it breached, flouted, broken by state and territory governments, and then they come to an inquiry like this and say, look what we've done, we've got this one-page PDF. Do you have a response to that submission from the Commonwealth?
I think for me, it's one of the things that we did raise in our submission, and when I look at some of the others that have been made, the problem is that so many of these approaches are siloed. It's a simple, it's a document, it's a piece of research. It's not looking at the whole system. We have seen in other jurisdictions that change has been made. It's been possible. I'm sure it was very difficult for them to do. But when they've pulled every lever they could possibly pull in a coordinated approach, in a rights-based approach, change has happened. Now, I'm sure there's still young people engaging in crime and there's still young people that, you know, need extra support, but they've been able to do something, and I don't see why Australia can't do that. We're really good at saying things on paper that we strongly believe in child rights and that young people have a voice and they're the future and all of these things, but we need to follow it up with really sustained systemic action, not just words on paper. And it's possible. When we look elsewhere, there are things we can learn and we can do them.
Mr Collins, you come to us with lived experience in the space, and I know that Justice Action continues to work with both adults and kids who are washing in and out of detention. When you see these kinds of statements from the Commonwealth Government about, you know, what should be happening, and then you see the reality, which is 180 degrees different, how does that sort of...
Look, we feel really angry about that. We really do. I mean, we also see the amount of money being spent in the system, and we see also the disarray of our people when they leave it. We see the sick people who don't get any time out of their cells, who wrangle with each other and have nothing good to do. We have all the time. We have requests for access to education, people wanting to make a difference in their lives and not being able to do it. So we feel really angry about it. That's the truth of it.
It's like the Commonwealth Government is gaslighting people.
Oh, well, that's right. I mean, look, we also had expected that the OPCAT arrangement would actually be some sort of way of looking into the system. So the monitors, the national preventative mechanisms in each of those jurisdictions potentially could be really, very important. And just the idea of reporting, for example, we heard, as I say, from Youth Justice New South Wales, they have representatives there who can actually speak. And just having a link across to the OPCAT NPMs would be immediately empowering. You'd have a whole lot of people then being able to speak for the first time.
Senator Shoebridge, I do want to give an opportunity to the Deputy Chair and Senator Ghosh to ask any questions, if you've got any questions. Oh, did you? Oh, sorry, I forgot. Oh, I'm out of practice.
But I still take your note, Chair, and I do see the time.
Okay. So I'd like to sincerely thank the witnesses for appearing today, and I'd like to thank you all for the work that you've been doing in this space over such an extended period of time. So thank you for your submissions. It is greatly appreciated. We are going to adjourn for morning tea. Before we do that, though, can I just ask senators to bear in mind, and I'll do this softly at this stage, in terms of Senate standing orders in relation to slogans, etc., that are on laptops. And if when we reconvene we can make sure we don't have any issues in that regard, that'd be greatly appreciated by me. And with that, we'll adjourn and come back at 11:20. Thank you very much.
Thanks very much.
Thank you.
Yep, thumbs up. I now welcome representatives from SNAICC, National Voice for Our Children. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, could I ask you each to please state your full name and the capacity in which you appear?
My name is Catherine Rose Little and I am the CEO of SNAICC, National Voice for Our Children, and I appear on behalf of our members and the communities that support us.
Excellent, thank you. Mr Burton?
Hello, I'm John Burton. I'm the Executive Director of Policy and Research with SNAICC.
Excellent, thank you very much. Would you like to make a brief opening statement before we go to questions?
I would, thank you.
Thank you.
And I guess the first one is a thank you for the invitation to be here and an acknowledgement that I come from Central Australia and not my country, so I do acknowledge the TOs for this country. There's so much I want to say to you, Mob. There's so much I want to say and so much I want to share, and I never really know where to start. And part of what I did in coming in this morning was listening to what other people were saying and taking a look at what was making news around the place and really mulling over, well, if we all know the same things, if we've all been saying the same things, if we all know that the evidence is clear, if we all know that there's been inquiry after inquiry, report after report, then why aren't we getting anywhere? And I started to look at, well, the ecosystem really, because at the end of the day we sit in an ecosystem, and I was really cognisant that as senators you care about people. At the end of the day you represent people, and that is where your concerns are. And I was thinking about what is concerning people on the ground, and I was thinking about how people are behaving even at this point in time and what's driving narratives, what's driving fears, what's driving outcomes. And there was no one real clear answer to any of those things. And these are just things I'm percolating on. And I couldn't get past a story that I heard yesterday, and this story actually isn't about youth detention, but it's about one of the underlying drivers and some of the ecosystems and behaviours that sit in it. And it came out of the Northern Territory from Naja, and they were talking about one of their young clients, who I think is about 16, and this young man was involved in a car chase and he ran away. And we don't know if he was the person driving the vehicle. We don't know if he was in the car. We don't know any of those things. What we do know is at the time he ran, police dogs were set on him, and those police dogs attacked him in a manner that was so vicious he required hospitalisation and surgery after surgery after surgery. And I thought about that a lot. I can't get that out of my mind. A young person being ripped to pieces by a police dog so severe that they require multiple surgeries. And I was thinking, if you saw that in the media, if someone was walking down the street and that happened, we'd be mortified, we'd be looking at it, we'd be feeling distress. We don't hear about things like that, and we never hear about things like that. But what would happen if we did? If we shone a light on that particular example, would people even feel empathy? And my gut is no. My gut is no, because I then went and looked at social media I'm from the Northern Territory. I went and looked at the social media on many of those pages that we have that drive the conversations in Alice Springs. And they were talking about things like this, and I did a little bit of scrolling, and this one's from a few years ago, where they were talking about when we have children offending, who are engaged in offending crimes, well, why can't we just strip them and use their bodies as wetsuits? The one more recently from about a week ago talked about children who'd been involved in the theft of a car, and why don't the police just take them back to McDonald's and give them something to eat and then let them go free, because all of us would do anything to be born free as a brown person in this country. Now, that particular post had 235 comments supporting it. It then referred to things like another case example where some children had been apprehended after, again, it was a vehicle theft, 12, 12, 12 and 15. And the police report spoke of children being returned to a responsible adult, with the exception of the 15-year-old who was going to be dealt with under the Justice Act. and justice provisions. And again, more than 200 responses talking about, well, who's the responsible adult? I've never seen a responsible Aboriginal person in my life, and all of them full of vitriol and hate. And again, anyone who knows anything about this particular subject knows there's a really good chance 12, 12, 12 were in the care of foster care, because that's what the statistics show in the Northern Territory, that the children in the justice system came out of the child protection system. So all of those things are floating around in the back of my mind as I speak to you today, and they're things I just wanted to put on the back of your mind while we have this conversation as well. We got a few things that we really would like you to think about, and the first is really obvious, and that is that all children deserve to be able to spend their childhood years among their families, their friends and their communities. All children deserve to be able to learn and grow and thrive. No child ever deserves to be locked in prison or in a police watchhouse. We know that current child justice system approaches result in far too many children being jailed, and in doing so, they undermine their own objectives of reducing crime and making Australian communities safer. Arresting and imprisoning children does not result in safer communities. Actually, the opposite is true. We know that there is a clear connection between incarceration and recidivism. Carceral environments are, by their very nature, traumatising and criminalising. They remove children from positive influences in their communities, subject them to inhumane treatment, and socialise children to double down on antisocial behaviours. As the Australian Human Rights Commission's Helpway earlier report tells us, around 3 out of 4 children who encounter child justice systems reoffend within 12 months. Data from Queensland Department of Justice indicates that more than 20% of subsequent reoffences increase in severity, and that the number of repeat child offenders is growing. In Victoria, data shows that while overall youth crime is steadily falling, the number of discrete offences committed by each criminalised child has been growing. If child justice systems are directing 3 out of 4 children into cycles of criminalisation and incarceration, then how can they be said to be working? Aboriginal and Torres Strait Islander children are the most over-policed and over-incarcerated children in the world. This is a decades-long and nationwide human rights crisis and policy failure. Despite being just 5.8% of the child population in Australia, there are more Aboriginal and Torres Strait Islander children in justice systems in absolute terms than non-Indigenous children. In 2024, of the 828 children whom Australian governments kept in prison on any given night, 63% were Aboriginal and Torres Strait Islander children. This overrepresentation is especially acute among the youngest children. In 2022, the rate of Aboriginal and Torres Strait Islander children aged younger than 14 in detention was 51 times that of non-Indigenous children. Our children are entering the system earlier, and as a result are more likely to be locked in. That means that they will experience cycles of incarceration throughout their lives. A case study that we were given to again by NAJA when we spoke to them last week talked of a 12-year-old person, a child who had entered the system at 12 and who was now 14 and had been in incarceration 30 times. The data on children who receive a sentence of incarceration is unequivocal. 85% return to incarceration within 12 months of release. Raising the minimum age of criminal responsibility to at least 14 years is therefore an obvious, immediate and critical measure needed to reduce the overrepresentation of Aboriginal and Torres Strait Islander children in the justice system. Aboriginal and Torres Strait Islander children are some of the most marginalised and disadvantaged in Australia. Many of our children contend with complex and stubborn structural determinants which drive their overrepresentation in criminal justice systems. Many children meeting the justice system are victims first. They're victims of poverty and of everyday systemic racism, of histories of trauma and mistreatment. These root causes work against Aboriginal and Torres Strait Islander children's wellbeing and safety. It makes it difficult to thrive in their education and work. It makes it difficult to find safe and secure housing. It undermines their pro-social activities like sport and can ultimately lead them to make mistakes and break the law. Changes to the justice system alone cannot shift these conditions. Any response that doesn't aim to address the structural and socio-economic root causes rather than the symptoms of crime is certain to fail. Among the most important of these structural factors is the appalling, disproportionately high rates at which Aboriginal and Torres Strait Islander children are removed from their families, their communities and cultures and placed into statutory child protection systems. A huge number of our children in child justice systems have had traumatic experiences or are a crossover child. These are the children in the youth justice system who have also been in child protection systems. In 2022-23, 2/3 of children in child justice systems had been in child protection systems in the last 10 years. Again, Aboriginal and Torres Strait Islander children are shockingly overrepresented among these criminalised children. They're 26 times more likely than non-Indigenous children to be among these crossover kids. They are the most vulnerable children. When children are separated from their families, communities, culture, the risk of adverse outcomes for their health, development and well-being increases. However, instead of meeting them with trauma-informed supports and therapeutic care, our systems are reacting increasingly with more and more punitive and often cruel ways. I often think to myself whether or not we'd bring in these things if it was us that had to sit in a chair with restraints with a spittoon over our head for any length of time. While there is no single solution to addressing these structural causes of overrepresentation in child justice and child protection systems, there are a suite of proven cost-effective reforms that can transform and reorientate our systems. The evidence is unambiguous. Keeping marginalised children connected with support services to help them thrive will benefit the broader community far more than exposing children to detention. These solutions must have Aboriginal and Torres Strait Islander community-controlled organisations at their centre. The evidence shows that investing in these culturally safe early intervention supports, designed and delivered by local communities, can set up our children for a strong start and success in life, that they can prevent antisocial or offending behaviour at the outset, and they support families before they are in crisis. ACCOs know that the connection to family, community and culture provide robust and protective factors for Aboriginal and Torres Strait Islander children. For decades, they have been providing their communities with services proven to improve children's developmental trajectories and strengthen families' holistic well-being. However, ACCOs are chronically underfunded and face substantial systemic barriers to impactful work that they do in supporting our children families who are facing adversity. Similarly, children who do come into contact with the justice system need access to a continuum of culturally safe, child-centric and trauma-informed services designed to allow to make them make amends for their offence and prevent further harm. Diversion and rehabilitation programs need to be wrapped around with therapeutic services, family supports, educational supports and mental health, alcohol and drug or disability care, so that the environment from which our children are coming from is changed and that the environment that they are received back into is nurturing, capable and supportive. These diversion supports can act as a circuit breaker for children at risk of offending or of further entrenchment in the child justice system. For instance, according to the Royal Commission into the Protection and Detention of Children in the Northern Territory, just 35% of children were diverted at the point of coming into contact with police. But of these, around 80% of diverted children did not reoffend. Our justice systems deny far too many Aboriginal and Torres Strait Islander children bail and keep them in remand for too long. On any given night in 2023, 83% of children in incarceration had not been sentenced. The vast majority actually never receive a sentence. This means that the majority of Aboriginal and Torres Strait Islander children currently incarcerated have never been found guilty of an offence. These periods of remand are shockingly overlong, often for very young children. Unpublished data from the Northern Australian Justice Agency, Aboriginal Justice Agency, shows that the average child on their caseload spends 197 days on remand before they reach their 14th birthday. The justice system readily and needlessly refuses the presumption of bail. This is a completely unacceptable length of time for unsentenced children to spend in traumatising circumstances, scared for their lives and often far away from their families and their supports and the people that tell them it will be okay. For these children who do fall into incarceration, the experience must be rehabilitative, not re-traumatising. Here too, justice systems are failing disgracefully. Child justice systems and detention facilities routinely fail to provide mental health supports or consistent opportunities for these young people to engage with culture. These are fundamental to the identity, mental health and well-being of our children. Again, information from our peer Naja tells us that in the Northern Territory, where we are now removing children from Alice Springs to Darwin, those children who are on NDIS can no longer receive their supports because those supports are rooted in Alice Springs. So the therapeutic needs are being unmet and their ability to get a new one is not there. Their ability to have any access to any support is unavailable. We need to see more funding for Aboriginal and Torres Strait Islander designed and led diversion and release programs which support children's wellbeing and cultural identities, which develop their leadership and support them into social and economic opportunities like school, housing and work. This social reinvestment promises to have huge social and economic benefits to governments and communities alike. Justice Reform Initiative reports suggest that we spend $855 million a year on youth detention and corrections. The real cost to the taxpayer of this cruelty is astronomical once you account for the lifelong costs of children's entrenchment in justice systems. By contrast, social reinvestment is fiscally sound. In 2014, the University of Queensland academics found that putting just $10 million into justice reinvestment each year for 4 years could save Queensland taxpayers as much as $263 million by 2030, and those numbers come from 2014. No one, of course, is saying that children who engage in offensive behaviours or break the law should not have some form of consequence, but these must be appropriate and proportionate to the age and stage of the child. Across Australia, we see positive examples of restorative justice practice which prioritise accountability and genuine restitution, not punishment, retribution and prison time. It asks children to face up to what they did, make amends with the victim and their family and their community. The evidence that has emerged on the efficacy of restorative justice is certainly significant enough to justify a huge scale-up of its use and further evaluation and learning about its practice and benefits. Accountability of offenders is important, but by asking Aboriginal and Torres Strait Islander children to be accountable for their disadvantage and their poverty, for their near everyday experiences of systemic racism, for the absence of anyone supporting them and the overstressed service system that can't go to those children, we are asking for a greater level of accountability than what we ask of our governments or our justice systems or anything that we assume of ourselves. And what we know, by the time a child hits a justice system, they have been failed by so many. And yet when they hit that justice system, the only person that is ever held to account is the child. We join calls.
Miss
I could talk
Liddell,
forever. Yes.
Have you? Yeah, and it's very. Very relevant and very impactful. I do need to make sure the senators have an opportunity to ask questions. And you do have the ability, if you would like to place the entire document on the record, we could accept that. So it forms part of Hansard. Would you like to do that?
I can do that.
Yep.
The average person speaks at 3 words per second, and I have less than what would be a page. So I reckon that would take me 2 minutes. What do you reckon? Do I put it into Hansard or do I finish it off?
Oh, I think we'll let you finish it off.
All right, no worries. In which case, we certainly join the calls of Aboriginal and Torres Strait Islander organisations for national leadership on child justice by the Australian Government, working with the Justice Policy Partnership and the new National Commissioner for Aboriginal and Torres Strait Islander Children and Young People and the Coalition of Peaks. We say that the violations of Aboriginal and Torres Strait Islander children's rights, detailed in countless inquiries, reports and exposés, belong to all governments and they can't be dismissed at a state and territory level. As a starting point, the Australian Government should action the recommendations of the Royal Commission into Aboriginal deaths in custody, the majority of whose recommendations have sat unimplemented for more than 30 years. It is well within the responsibility and the jurisdiction of the Commonwealth Government to reorientate funding and policy towards eliminating the underlying structural factors that drive our children's overrepresentation in the justice system. It is also within the commitments of the Commonwealth has made to invest in ACCO-led prevention and diversionary supports, as well as increasing the role of our legal and social services that respond to the needs of children who are in contact with youth justice systems. Change needs to be implemented cohesively across jurisdictions at a national level to create a required paradigm and systemic shifts in youth justice.
Excellent, thank you. Just one question from me at the outset for you to take on notice. If you could, I'd appreciate you providing comments with respect to the submission from the Attorney General's Department to this inquiry. So if I could give you that piece of homework.
Absolutely, love homework.
Excellent. Thank you very much. Senator Shoebridge loves homework as well, so I'll give Senator Shoebridge the call.
Thanks, Chair. A deep love of mine, homework. Thanks very much for your submission, both your written and what you said this morning on the record. And I just want to acknowledge the work of SNAICC over decades. It's, been that strong advocate for First Nations kids, not just in the criminal justice system, but also in the so-called child protection system. I particularly, I want to appreciate the work of some of your state bodies, ABSEC in particular in New South Wales, the work they do. I'm assuming SNAICC was part of the Council of Peaks that helped draft the Justice Policy Partnership with the Commonwealth and States?
Correct, yes.
Yeah. And look, I want to commend you for the work you've done in getting the terms of the Justice Policy Partnership where it is, talking about getting kids out of jail, talking about holistic measures, talking about building connections, particularly with First Nations communities and ACCOs, and like the Justice Policy Partnership document reads really well. But it was entered into in June 2023, and since then pretty much every action that's been taken by state and territory governments, whether it's New South Wales, Queensland, NT, WA, pretty much every action has been directly contradictory to it, like 180 degrees different to it. What do you say to that?
Oh, look, it is one of the great frustrations because in order to get all governments to agree to a document like that is extraordinary work. But we know it's only as vulnerable as the next policy shift or the next government or sometimes even just the next minister who might have a different lens on it. So there are a couple of things that sit underneath it. One is if we look to the Productivity Commission inquiry that said at the heart of it, governments didn't work fast enough. They didn't truly embrace the level and scale of change that needed to happen. Now, those things are a bit like the document that you're referring to. They talk to the structural elements and they say this is what you need to do, and the theory of it's sound. There's no doubt about it, the theory of it's sound. Implementation's a whole other story. Now, when you say compare that particular policy partnership to the one that SNAICC co-chairs in early childhood care and development, we had significant structural supports underneath it. So it had a lot more time to come into that space. It had a national plan, so that national plan being safe and supported, which extends over 10 years and effectively is responsible for where the Commonwealth invests its dollars when working with states and territories on the ground. So it has a national plan that can drive and help implement that. Whereas the Justice Policy Partnership does not have access to a framework that brings everybody together. I note from...
Well, the Commonwealth said, just stopping you on that point, the Commonwealth says in February 2024, the government committed a further funding of $10.7 million over 4 years from 2024 to 2025 for the Justice Policy Partnership. That's what they'll say when I say to them, but you don't have any implementation plan. They'll say, no, we agreed to $10.7 million over 4 years for the Justice Policy Partnership. Preempting that answer, what do you say to it?
I say they've got to come up with they've got to work out how they pull it all together. They have to, in order to implement, you have to have a genuine plan that everybody has signed up to, like a safe and supported, which means you're all negotiating. This is what the priorities for all governments will be. This is where all money will be redirected, and this is how we're going to fess up to it. And when I say fess up to it, that means that states and territories still have a level of flexibility in how they govern it and how they work with it, and as it should be. States and territories do need to be able to respond to their unique environments, but it's missing. Now, my understanding is also, and again, I'm not an expert on it because I'm not within the NATSLs, but the Attorney General's is far more complex than the rest of than the environment in which the rest of us are operating. So it has a couple of structural supports missing. But until you can come up with a national plan that you can hook it onto, that commits everyone over a period of 10 years to work towards, which, and again, will enable some level of flexibility, but will enable it to genuinely drive over a period of time in a cohesive manner, you're going to be struggling.
If I could add to those comments, Senator Shoebridge, I think the funds that you're referring to that support the Justice Policy Partnership, those funds really go towards the partnership activities, which are critically important. They enable Aboriginal and Torres Strait Islander organisations and people to be involved in shaping those policy directions and priorities, but it's only one part of the picture. The work of implementation needs to happen. I think something I think that you're pointing to and that we would point to is that those commitments that are being made, they're too soft and they're not genuine enough. And I think that's why in our submission and the information we've been putting forward, we're calling for a greater level of accountability, for standards at the national level that are enforceable, and for a system of oversight that can ensure those commitments are followed through.
Yeah, and indeed, I could go through your recommendations, but which seem to be incredibly, well considered. But they talk about enforceability. They talk about not producing a document in June 2023, referring to it in 2025, and failing to reference that pretty much every element has been breached by the states and territories that apparently signed on to it. Yeah. I mean, sure, we could spend another $10.7 million recreating this document over the next 4 years, but this document isn't keeping any First Nations kid out of jail. It's not stopping racist policing in the Northern Territory. It's a non-answer if you just produce a document, isn't it?
Yeah, absolutely. You do need the systems that drive action. You do need accountability with all levels of government, and you do need to be committing to actions and have a way of measuring how well you have delivered on those actions.
So when the Queensland government signs on to this, which they did, the Justice Policy Partnership, and one of the four goals was partnerships and accountability aimed at, amongst other things, reducing the overrepresentation of Aboriginal and Torres Strait Islander people in prisons. And then, having signed that, they then pass noxious child justice so-called reforms that remove presumptions against bail, have mandatory prison sentence for kids, breach their own human rights provisions to put more First Nations kids in jail and lead to an explosion of First Nations kids in Queensland jails. They've signed the document and then they do the exact opposite. How do we stop that happening?
I think this is why we're giving evidence to you today, because we do believe that the Commonwealth has a role to play in that level of accountability and identifying what it is you can do to ensure those things are not breached. Because we know in anything that we work on, it is vulnerable to a shift. Yep. It is vulnerable to a shift. It doesn't matter how hard we work at the grassroots level, it is vulnerable to a shift that is usually driven by an ideology or what the media might be saying, and it happens over and over again. So we can be as resilient as we want, we can be as well informed as we want, we can point to the evidence as much as we want, which gets me right back to where I started. The evidence doesn't appear to be working. And even the stories don't seem to be cutting through. The horrific nature of it doesn't seem to be landing. And
it's almost as though politicians think, well, it's not going to be my kids. It's going to be someone else's kids that are going to have this.
Absolutely. And again, in my thinking of it this morning, I was thinking most of you are parents, if not all of you. And I was thinking, as a parent, we know that our job is to care and love our children, and we sit at the kitchen table and we say, what was a good thing today? What was the bad thing today? Oh, your heart's breaking. This, oh, you'll get through it. And I was thinking about how that applies in a prison setting. Who does that? Who does that when a child's having the worst over their life?
So I mean, you've been doing this for years. You know what the evidence says. You've been putting these recommendations forward. You've been working with governments, and then they do the opposite. What should be the accountability mechanisms? Is it Commonwealth laws? Is it a mixture of Commonwealth laws and funding agreements that where, unless states and territories deliver on these commitments, their funding gets squeezed? I mean, what is it?
Look, I think both of those things are true. Both of those things are true. I think you've probably heard it this morning, but we also probably need to look at what the narrative that drives votes is as well. Media's got a big story, and it doesn't necessarily tell the right story at any point in time. So I'll give you an example, and again, I'll give you a child protection example. We have seen increasing attacks on things like the child placement principle. Now, the child placement principle effectively has child safety at the heart of it. And I was looking at something in the papers over the weekend that effectively said that the child placement principle was responsible for the deaths of children, which is ridiculous. The paramount principle is child safety. If it is not safe for a child to be there, then it should not. But these are the steps that you go through. Now, that is ridiculous, but unless you understand that what you're reading about was possibly a practice failure, it sounds like a good story. Now, that's really hard, because when we're talking about children, it is reactive, it is emotive, and similarly, when we're talking about children committing crimes, if you're someone like myself and you come from Alice Springs, we live and breathe this every single day. We understand the frustrations that people are going through, but the way it is framed, you're driving in your car and the person on the media says, there was a break-in, the usual suspects have been up to it again. There was a break-in in Alice Springs, or the hardened criminals have been hard at it again, stealing cars. This is a news broadcast that you will hear driving in Alice Springs. This perpetuates that fear, and don't get me wrong, it's overlaid by what we're also seeing, and that is a failure to implement the services that are required to stop crime happening in the first place. It's like the glue is missing in the middle. So even when we're talking about, well, yes, it does relate to funding, yes, it does relate to what powers or legislation can you as a Commonwealth bring in. But what we find is we've got a really good idea here. We can quickly get in extra police, but could we have a dedicated focus on ensuring that that police presence was also creating jobs within the Aboriginal community, where mob from outside of Alice Springs who knew their own community were dealing and interacting with people, but in a frame that is not all about we're going to lock you up, but rather, hey, you mob, what are you doing in town, right? Those sorts of things, almost like a liaison. Could we increase those numbers? That's the glue. That is the glue, the bit that gets you from a fast reaction to your long-term ambition.
Thank you, Senator Shoebridge. Senator Little.
Thank you. I just want to ask a couple of questions that relate more to action and inaction that fast-tracks children into custodial settings. The idea that a child is returned to a responsible adult. I tried last week to get a definition of what a responsible adult is, because if you look at any of the plethora of reports, children will say there is nobody at home who is responsible. Even the Commissioner's report had children expressing that. How do we define a responsible person at home to care for a child consistent with the expectations of our own children?
Look, I think it means, is there a home where that child would be safe? There are always going to be slight nuances depending on what that environment would be. So there would always be a level of risk if you were too strict on it, because what if you live in a house with a lot of people in it? But is there a parent there that will ensure that you're going to go to bed tonight? And being clear, children will always do what children do, but is there a parent that will take responsibility for you and say, yes, here is your bed to sleep in, yes, there is a meal, and yes, you've done the wrong thing, tomorrow we're going to have a chat about it, or tomorrow we're going to go and seek support. Now, again, this is where it fails. When they had introduced the first round of curfews in Alice Springs, they not only brought in the curfew, but when police were out and about, every single one of the children they came into contact with, they knew the names of. They knew the name of every single child. They also knew that most of them actually were running away from their foster parents. They knew these things. Where they weren't running away from their foster parents, they were taking them home to their communities, where the children said, their parents said, I need some help. No help anywhere. There is nowhere to go. So the way the child protection system works is you cannot get support until you are in trouble, which is ridiculous. We should be intervening, like the National Commissioner says, way earlier, help way earlier. So what would that be? We've picked up a child. Not only do we find a responsible adult, but we also triage, and it should be an Aboriginal person triaging, because again, that's a job. And it's likely someone who knows it. What else do you need right now? So, actually, I've been having trouble with this. I've been having trouble with that, so that you wake up the next morning and those supports are immediately kicking in. But that level of wraparound support, that nuance is missing, and there is nowhere that you could walk into, pretty much anywhere, and you go, right now, I'm a little bit worried about my kid, and he's jumping out of windows at night, and he's hanging out with these kids, and I'm at a loss. I've got trouble. I know I might be drinking a little bit too much. Where do I go? Where are the rehabilitation services, even for adults?
Okay, so currently we've got programs in place, and they're in the Northern Territory as well, where there is a different standard for Aboriginal kids. You asked just before, what would we do with our own children? There are bus services that operate to pick children off the street that operate until 4 a.m. in the morning. Well, there's no chance of a child who is running around the streets going to school if they've been there running around till 4 a.m. in the morning. So what I'm asking here is, given some of these children have said, and expectations are, same as everybody else, I want a job, I want to be able to take up a job, and I want a nice car. How on earth do we get these children into school when in remote communities, the most recent report says less than 3% of children are attending school regularly? Yeah,
they're great questions, and this is a passion point for me. So, again, if we look at some of the programs that, and I will use Alice Springs as a context because it's the one I can speak to the easiest. There used to be a hub. So the buses are running, and they've come into contact with a child who should perhaps not be out at this point in time. No responsible adult found, therefore there is a hub. And this hub is where we're going to sleep you tonight until we work out what the best response is. Now, that might mean that we've got to ring up your nana, because it's hard to ring up nana if your nana doesn't have a phone, but we will find an alternative. Or it might be that you're going to go and stay with your cousin. But at the very least, you've had a sleep. It also means that say if it was an Alice Springs setting, schools need to be aware that if you have a child that's been out all night and hasn't slept, then they're going to be engaging differently, right? They might be a little bit more tense. They might be more likely to run out of the classroom. They might not be more likely to disengage. But when, and again, it's a passion point for me, the numbers of these children are relatively small. When it came to school attendance, what was really important is listening to what people are saying. And one of the things I remember most clearly in my entire career was sitting at a table once with educators, and we're going, look, we got buses, we got shoes, we got showers, kids still don't come to school, we've got beds they can sleep in, still they won't come to school. We talk to families and the Aboriginal liaison officers all said the same thing. Kids aren't well enough. They're sick. They got lice. They got scabies. They can't hear. And it wasn't until we found a way to... And we'd go out and we'd go, well, who's going to do this? No glue in the middle. Health services deliver health. The family services deliver family services. This one delivers that. But in the middle, there was no glue pulling these things together. Now, this particular example found that in, say, Saturday, which was having the most difficulty in attendance, once they brought in a health program that brought together all of those bits and pieces, found the dollars, which were minuscule, they were like $100,000 just to link these together with a worker. Children who had been attending school at about 10% were attending school at 90% because they were actually well enough and comfortable enough to attend school. So they were addressing those underlying things that make it almost impossible for a child to engage.
And can I just connect that answer to the conversation we were having earlier about the role of the Commonwealth? I think that that what Catherine is highlighting there is that there is really a large unavailability of services across communities. One thing that we do annually is report through our Family Matters report on investment in early support, which has stayed consistent at around 16 or 17% of funding in child protection services. So, and we're seeing some fantastic examples of the Aboriginal organisations that are out there supporting families. You've got services like the Aboriginal community-controlled family wellbeing services in Queensland that are seeing better rates of family engagement, better rates of families who are having all their needs met through a service and who are not recontacting child protection as a result of being involved in an Aboriginal-run family service. But what we're seeing is that those services are available in a limited number of locations, have limited funding, are only able to respond to a particular part of the need for children and families. So a big part of the answer is that driving that increased investment, which we would say needs to be a responsibility of state, territory and Commonwealth governments working together to get more early intervention supports in place.
Senator Liddell, last question, and then Senator Ghosh has some questions.
Just on that issue of Commonwealth's responsibility and issues of close the gap, you know that the aggregation of data makes the delivery against those targets look better than it actually is, because in some areas the target is nowhere near what the aggregated target says it is. I want to ask a question about, we saw in Central Australia, we know that there were issues there, but we saw a significant uptake in issues post the lifting of those alcohol restrictions. We've seen, regardless of the government ignoring the evidence, the outcome from their own evaluation into the removal of the cashless debit card. We have 1 in 5 people in the Northern Territory that are on income management, and we have a government right now that is looking at removing income management based on the committee that was just held, where it had a majority saying they recommend the removal of all income management. The report from the Human Rights Commission said not enough money, these is kids' words, for basics like food and clothing. There is an example of Commonwealth, this Labor government, intervening in a way that has had a detrimental effect on all of those indicators, the worst indicator being the real life experience of those families who were impacted by those decisions. What do we actually do to make sure that decisions that are made from Canberra don't have such a drastic implication for people who are just living these experiences every single day?
That is the community voice that tells you what's going to happen. So again, if I go back to the glue, we knew those things were starting to lift. We knew that they were lifting, but where were the things? Where was the conversation with communities onto the ground to say, at this point in time, this is going to happen? What is it that you need? We didn't have rehabilitation services in there. We didn't have people working. We didn't have, Money Matters out there in force saying this is how we're going to work with you. So those sorts of things always go missing, and technically they sit in that 16% of the expenditure that we were referring to. And again, I know this is slightly backtracking, but I missed it, Senator, and it was really important on those remote communities that you're talking about. early education and care is almost missing. We know children who do not have access to early education and care do not access services in the right way and are more likely to come into contact with both child protection and justice systems. So we know that that is a critical investment. What does that look like? Well, there are a couple of opportunities out there that, again, you as federal senators could push in on it, right? So there are jobs in early education and care that look at things differently, that look at things like, could you have a breakfast program that gets all the mums or the dads out there cooking the breakfast, and then you don't have to worry about rounding up the kids, because guess what? There's your breakfast. Now we're going to walk you to school, and while you're at school, we might actually involve ourselves in some learning over here, or maybe it's a micro business. So those sorts of things could hook on to bigger initiatives like the CDP reforms, those types of things. So but those things will only happen if we're actually talking to communities on the ground about what it is that they need at the time that they need. Now, again, if we look at the other side of that story, Senator, and those concerns you're raising are valid, but some of the other concerns about the cashless debit card for the Northern Territory would be that at the time it was brought in, young men went missing, and they never actually applied for Commonwealth funding again. So they went hungry. What are they doing for food? How are they behaving? Are they also ending up? And again, it comes to that bigger story. We weren't ready. No one spoke to the community about what they needed if these reforms were to come in place, and how we make them work effectively so that it is something that so that the rules are explained. And again, if we think about children and things like, we all want children at school, but if we bring in mandatory, you must be at school or else we're going to take money off your parents, and we haven't actually worked and have got individual plans for those children to assess whether or not they've got additional developmental needs. Do they need an ISA? Do they need NDIS support? And we just put a whole heap of children in school that do not have school-ready behaviours. They're going to run away, they're going to be disruptive, that's going to have an impact on the broader community, and off it goes again. Those children then also will end up more than likely going to end up in juvenile detention, and the community is going crazy because what they're seeing is a whole lot of disruption in their schools, and they'll blame the children and they'll blame their parents, but what they won't understand is, in actual fact, we failed to be ready for this as a strategy.
Okay. Senator Ghosh, we've got limited time, but you've been very patient.
I'm cognizant of that. Thank you, Chair, and thank you very much to the witnesses for being here. Can I ask about something that emerged from the last answer, actually, because it is something that I'm interested in, which is what role do you see as the availability and security of quality food as a protective factor in our criminal justice system? And
massive.
How would you think that that is best provided in a way that's going to be most effective to have the impact on incarceration rates and interactions with the justice system?
It's massive, all right. You only have to look at the children who end up in detention, and usually they're skinny. Where those numbers of overrepresentation are the highest, you're probably going to see that they're the skinniest. That's a no-brainer. If you are super skinny, it's not that you've got a fantastic metabolism most of the time, it's usually food security. So it plays a massive role, and I know I often hear stories, again at home, where people will say, so the kids broke into my house and they made a sandwich and they left out the mayonnaise. Even kids want to eat mayonnaise. But if I could share with you a story that I heard out of the APY lands, and it related to children, and the MPY Women's Council did this piece of work, and it went out to the kids, and they're all primary school aged kids, and they said, what are your superheroes? How about we do a superhero project? What do you want? Who should they be? And their very first superhero was May. Food. That's what they wanted their superhero to be. And they said, any other superheroes? They said, love. Why do you need love? Oh, because we love it when we feel safe when we're with our parents. What other superheroes do you need? I need Inma, which is dancing and song. Why do you need that? Because we don't hear good things about us, but this makes us feel strong and it makes us feel happy, and we dance with our mums and our dads. What else do you need? We need Jukapa. We need a lawman that growls. a lawman that speaks up, a lawman that says this is what you've got to do. What else do you need? Because, you know, superheroes out there, most superheroes don't bring you food and love and song. What about Spider-Man? And they said, you know what? Cobweb Girl. What's Cobweb Girl do? Cobweb Girl sends her cobwebs into Alice Springs and brings back the naughty kids to the rest of the superheroes who keep them safe. So they're fed and they're loved and they're learning how to be strong and resilient and fantastic members of society and community. Primary school children in remote communities understood the hierarchy of needs and also what was happening in their environments. And food was the very first thing they identified. Thank you.
Thank you. I've just got one more, but
please feel free to take it. Such an eloquent answer. But
no, and feel free to take this on notice as well, if it's easier to provide it at a subsequent time. One of the things that was identified in your submission was around the priority reforms to do with shared access to data and information at a regional level. Can I ask also about your thoughts on where we are not collecting data at a national level, and in terms of priorities for the topics or types of information we should be aggregating nationally in order to inform policy solutions in this space? And just if there are particular areas that you think we should be collecting data where we're not.
Absolutely. So again, the level of this I'll take on notice, but it is not until you talk to communities that you realise where the community data is missing. So when you tell them what you've got, a couple of things will happen. Communities will tell you what is happening and the story behind the data, because data without the story is useless, much like the story without the data can't actually give you the evidence that you need. They will tell you where those gaps in information are almost without fail, because communities do understand what's happening to them and they do understand what it is that they need. They very rarely get the opportunity to voice that. Again, if I think about some of the meetings I went to relating to when Alice Springs does have those crisis moments, the first thing everyone says, well, who's here? Who are they? Who are their families? What communities have they come from? Is there housing on those communities? Is there housing in town? We genuinely don't know that. We genuinely don't know how many people have moved in from remote communities into Alice Springs and have no intention of going back out to their own homelands. So therefore we can't adequately have the right level of social support available. We can't have the right level of housing available. But if you talk directly to communities, they will tell you exactly what that data and what the data sets are that are needed.
And am I taking from that answer that then it is a regional or it's a very localised response to that type of question rather than perhaps having an overarching set of national data?
Look, there will be similarities in everything that is said. There always is. Any community that you go into will have, almost without fail, very similar themes, and they will emerge in every single community. But the nuance will be around what is missing in their story, which is why there are massive risks when you say this is the only way and these are the only things we're going to invest in and this is how we're going to do it. Without that ability for communities around them to understand what is happening, they can't do it. And again, this doesn't relate to juvenile justice, but I remember it really distinctly when they were talking about putting lights in Hermannsburg, because there was evidence that said the data showed, actually, that if you have lighting, children are less likely to break into homes. And what the mob community in Ndari at that point in time said, well, that might be true somewhere else, but you put lighting here and all the kids are going to hang out because they're not going to be bitten by a snake.
I know we're very close to time, but I'll just add to that I think one of the key areas we need data development is around the support services that children get access to, whether they get access to support services and how that connects to their experiences with justice systems and child protection systems that lead to justice systems. So I think we've got a big gap around there around seeing the connected experience of a child when they have contact with the system and whether they get a response or support and what's the consequence of getting or not getting that response from the service system.
Yeah. I'll just add one more to it too. This one is about the over-collection of data. One of the things, again, that we have heard is that many of these families where children have come into contact with the justice system may have been working with up to 40 different caseworkers from 40 different organisations from any point in time. So the chances are that the gap sat in what John was talking to. None of those 40 caseworkers could do what that family needed or could consolidate.
The glue, you refer to it as the glue.
The glue.
Thanks very much, Ms Liddell and Mr Burton. SNAICC appears before this committee in a number of different contexts, and we always greatly appreciate the submissions and the testimony you give, so thank you very much.
Thank you. Thank you.
I now welcome via video conference representatives from the Coalition of Peaks and First Nations Advocates Against Family Violence. And thank you for your patience. I'm acutely aware that you've been waiting online, and we really do appreciate your patience. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, could you each state your full name and the capacity in which you appear? And I'll go to you first, Ms Turner.
Thank you, Mr Chairman. Patricia Turner, lead convener of the Coalition of Aboriginal and Torres Strait Islander community-controlled organisations.
Yep.
And I'm Lisa Charles. I'm the Executive Director of the Coalition of Peaks Secretariat.
Okay, thank you, Ms Charles. And now I go to the First Nations Advocates Against Family Violence.
Thank you. I'm Priya Devendran, Senior Policy Officer at the First Nations Advocates Against Family Violence.
Thanks very much, Ms Devendran. Ms Turner, do you have an opening statement, or does the Coalition of Peaks have an opening statement? Over to you.
Yes, thank you, Mr Chairman. I'd like to thank the committee for inviting me to appear today on a topic of great significance to my people. I begin by acknowledging the Ngambri and Ngunnawal peoples, the traditional owners of Canberra. I honour their elders and the long history they have on this land. I am the daughter of an Aranda man and a Gaddanji woman and was raised in Alice Springs. I am here today representing the Coalition of Aboriginal and Torres Strait Islander community-controlled peak organisations, or in short, the Coalition of Peaks. The Coalition of Peaks fully supports the submissions and recommendations made by our member organisations to this inquiry. I cannot underscore enough their immense expertise on youth justice and their tremendous work that they do on the ground for our children and families. Aboriginal and Torres Strait Islander children and young people are very precious to their communities and families. Most will grow up in loving and supportive homes and will never come into contact with the criminal justice system or police. Despite what the media portrays, our children are not innately criminal. Those that do come into contact with the criminal justice system are the most vulnerable children in the country. Many have disabilities and mental health issues. These are not the children that are well taken care of, that have food, safe homes and all the things they need to thrive. In the few years that they've been alive, many of them have experienced unimaginable trauma, neglect and some abuse. If this wasn't enough, these children continue to be harmed by the criminal justice system and the conditions they experience in detention, including extended periods of time in isolation in their cells. This is appalling and an ugly stain on our nation. Aboriginal and Torres Strait Islander children and young people being overrepresented in the criminal justice system, and particularly in detention, is sadly not a new issue. The overrepresentation of my people has been a familiar characteristic of the criminal justice systems since they were established by the colonies prior to Federation. The truth is, incarceration, just like the forced removal of our children, was a brutal tool yielded in the dispossession and colonisation of Australia. The overrepresentation we see today is a legacy of that shameful part of our history. Other key drivers leading our children into contact with the criminal justice system include racism, poverty, intergenerational trauma, violence, abuse, homelessness and inadequate health care. The evidence also tells us that there is a causal link between out-of-home care, youth detention and adult incarceration. This does not mean this issue can't be addressed and improved. Indeed, things must change because the lives of our children depend on it. Devastatingly, the continued and systemic failure by governments have resulted in the tragic deaths of 2 Aboriginal children in youth detention in Western Australia in less than 12 months. We cannot stand by and watch more children die and deteriorate in detention. Our communities, organisations and leaders are the fiercest advocates for the well-being of our children. I am particularly proud of the work of SNAICC and NATSLs and their members and what their members do in this regard. Our organisations are out on the ground in every state and territory. We know the children and the families are doing it tough that are in contact with the criminal justice system. We know how to engage and support them in culturally safe and trauma-informed ways. We know that seeing improvements in youth justice is also about supporting our people with better housing, health, education outcomes too. It is all connected and we know what works. We also know that our children in the criminal justice system and detention have multiple complex needs that require immediate support. These children require the therapeutic healing and social and emotional wellbeing, health and education services, and these should be provided by our people and our organisations. On the National Agreement on Closing the Gap, we have been demanding change for decades and have fought tirelessly for our children across all areas, including health, education, justice and child protection. The push by Aboriginal community-controlled organisations to develop a national agreement on closing the gap is a testament to this. It is now time for governments to fulfil their commitments already made under the national agreement to fundamentally change the way things are done. 4 priority reforms are the heart of the national agreement. When applied, they will improve youth justice outcomes because they support Aboriginal and Torres Strait Islander people to sit at the table with governments as equal partners to devise solutions, and they recognise that Aboriginal and Torres Strait Islander community-controlled organisations are best placed to support our people. The Coalition of Peaks acknowledges the efforts by the current government, including funding of the Justice Policy Partnership, Justice Reinvestment and the additional funding that has recently been provided to ATSLs for the provision of legal services for our people. We also acknowledge and commend the commitment by this government to establish a National Commissioner for Aboriginal and Torres Strait Islander children. While these are positive steps in the right direction, far more must be done to address the unmet needs of our children who are at risk of entering or who have entered the criminal justice system. What the Productivity Commission's review has unsurprisingly unearthed is that despite there being pockets of good practice, implementation of the national agreement is not happening at the scale that it needs to, and that governments are not delivering on their commitments, including the priority reforms. As our submission recommends, the National Agreement and the Productivity Commission review recommendations should be fully and urgently implemented, which would mean, 1, that policy, legislative and service system reform is done in genuine partnership with Aboriginal and Torres Strait Islander people and organisations. 2, that investment for Aboriginal and Torres Strait Islander youth justice and wraparound support services is transitioned to Aboriginal community-controlled organisations. 3, significant increases in funding for accessible legal advice, representation and support for Aboriginal and Torres Strait Islander children and young people, and for early intervention, prevention and diversion services, and therapeutic healing and social and emotional wellbeing, health and education services for Aboriginal children when they are in contact with the justice system. In terms of the role of the Commonwealth, we note that the committee's terms of reference significantly refer to the Commonwealth's role in youth justice. The coalition of PEGs recognises that direct administration of youth justice systems is the primary responsibility of states and territories. However, the Commonwealth holds critical levers for change in this space. The Commonwealth holds great political and fiscal power and has the tools to influence significant reform across sectors and jurisdictions. We urge the Commonwealth to use these powers, including the funding provided through Commonwealth state funding agreements, to drive change in line with the national agreement. The Commonwealth has its own criminal laws and powers that affect children, and as our submission recommends, it can drive meaningful change by reforming its own minimum age of criminal responsibility to at least 14, with no exceptions, and lead national action to raise the age of criminal responsibility to at least 14 across all jurisdictions without delay. Finally, the Commonwealth is responsible for the country's compliance with international human rights standards and has the power to legislate stronger protections of human rights, including the provisions of international instruments as they apply to children. The government must take responsibility for monitoring and ensuring the rights of Aboriginal and Torres Strait Islander children in all jurisdictions and ensuring that the rights of Aboriginal children in all jurisdictions are upheld. To work towards this, our submission recommends the Commonwealth reservation to Article 37(c) of the UN Convention on the Rights of the Child be withdrawn to ensure no children are held in prisons designed for adults or incarcerated with adults. Further, our submission also recommends the Commonwealth introduce a comprehensive federal human rights framework which fully incorporates the provisions of international instruments as they apply to Aboriginal and Torres Strait Islander children, including in the legal and incarceration systems. This includes legislating the rights provided in the UN Declaration on the Rights of Indigenous Peoples and the optional protocol to the Convention Against Torture and Other Cruel, Inhuman and Degrading Treatment or Punishment. In conclusion, Outcome and Target 11 of the National Agreement aim to reduce the rate of our children in detention by at least 30% by 2031. Whether this can be achieved very much hangs in the balance. We continue to see a rise on tough on crime politics play out across the country, and deliberate steps taken by some state and territory governments to introduce harsh and punitive youth justice policies, laws and practices. These approaches are completely at odds with the evidence. Countless commissions and inquiries have recommended evidence-based reform. We know what needs to be done. For example, my own organisation, the National Aboriginal Community Controlled Health Organisation, NACCHO, have been working with the Commonwealth Department of Health to develop a proposal to trial extended delivery of community-controlled health services in places of detention. This comes off the back of the recent national review of the First Nations healthcare in prisons, which made 6 ready-to-implement recommendations to improve the outcomes for our people in prisons and youth detention facilities. Now is the time for action. The Coalition of PEGs remain committed to working in partnership with governments on Outcome and Target 11 through the Justice Policy Partnership. But we need all governments to urgently lift effort to realise their our shared ambition for Aboriginal and Torres Strait Islander children and young people to thrive. I welcome any questions from the committee that the committee may have regarding our submission to this inquiry. Thank you, Mr. Chairman.
Thank you, Ms. Turner. I'll now go to Ms. Devendran. Devendran.
Thank you. I want to begin first by acknowledging the traditional owners of the land on which we meet today and pay my respects to elders past and present. I also acknowledge all Aboriginal and Torres Strait Islander people who have been impacted by the justice system and their communities. Thank you so much for the opportunity to speak on behalf of the First Nations Advocates Against Family Violence. FNAV is committed to advocating for justice reform that prioritises culturally safe, community-led solutions to address the over-incarceration of Aboriginal and Torres Strait Islander children. The overrepresentation of Aboriginal and Torres Strait Islander children in the youth justice system is a national crisis. Despite making up only about 6% of the population, Aboriginal and Torres Strait Islander children account for nearly half of all young people in detention. In some jurisdictions, such as the Northern Territory, this figure reaches almost 95%. These numbers do not just represent statistics. They represent the lives of our young people, children who are being failed by a system that was never designed for them. As outlined in our submission, the incarceration of our young people leads to devastating and long-term consequences, including mental health trauma and harm, exacerbated by isolation and culturally unsafe environments, educational disruption, cycles of disengagement and reoffending, and loss of cultural identity and connection, which weakens community ties and diminishes protective factors that support our young people. We also know that the vast majority of Aboriginal and Torres Strait Islander children in the justice system have experienced early childhood disadvantage, intergenerational trauma, and family violence. The system does not address these underlying factors. In fact, it punishes them for it. The treatment of Aboriginal and Torres Strait Islander children in detention often fails to meet basic human rights obligations under the Convention on the Rights of the Child. Solitary confinement, the use of force, and the detention of children as young as 10 years old violate international standards and reinforce systematic discrimination. Raising the minimum age of criminal responsibility to at least 14 is not only an international obligation, it is a moral imperative. Our submission calls for enforceable national minimum standards for youth justice, which must eliminate harmful detention practices such as solitary confinement, strip searches, and restraint on young people, embed culturally appropriate rehabilitation and diversion programs, ensuring community initiatives receive sustained investment, and transform the justice system to align with closing the gap targets, particularly Priority Reform 1 and 2, which calls for formal partnerships with Aboriginal and Torres Strait Islander communities in policy and decision making. Our call to action is clear. Solutions to these issues are already known. We need governments at all levels to commit to long-term investment in Aboriginal community-controlled organisations, youth justice responses, including early intervention and family violence prevention, ensure First Nations voices are at the centre of the youth justice reform. We cannot afford tokenistic consultational programs that ignore the expertise of our communities. And we have to end the reliance on incarceration as the default response and replace it with community-led, trauma-informed, and culturally safe alternatives that give our children the support they need. The reality is this: we cannot imprison our way out of this crisis. If we are serious about reducing the number of Aboriginal and Torres Strait Islander children in detention, then we must commit to transformational change that puts our communities at the heart of the solution. Thank you, and I welcome questions from the committee.
Thank you very much. We'll go to questions. Senator Shoebridge.
Thanks, Chair, and thanks to all of you for your submissions and your ongoing work in the space. And I suppose I might put this question to both, well, in fact, to all three witnesses, and answer as you want. The Commonwealth in their submission refers to the Justice Policy Partnership, and I think the Coalition of Peaks was critical in pulling that Justice Policy Partnership together, and I think it was first published in June of 2023. And I want to be clear, I really support what's in that Justice Policy Partnership, and I think you did great work pulling everyone together, and apparently state and territory governments agreed to it in June 2023. But since then, pretty much every state and territory government has acted totally contrary to it. Instead of reducing the overrepresentation of First Nations kids and adults in jail, they have often quite radically changed their laws to put more First Nations kids in jail, removing the presumption against bail in Queensland, mandatory prison sentences in Queensland, reducing the age of criminal responsibility in the Northern Territory, aggressive backwards laws on bail in my home state of New South Wales. And in fact, I can't think of a state or territory that's come close to even pretending that they're implementing the Justice Policy Partnership. Well, I suppose starting with the Coalition of Peaks, again, I want to commend you in doing the work pulling that document together, but how do you feel looking back over the last 2 years and seeing pretty much every state and territory government, slapping you in the face with it?
Yes, thank you very much for that question. Joint Council is a forum under the National Agreement, co-chaired by myself and the Federal Minister for Aboriginal Affairs, with all the ministers responsible for closing the gap from each state and territory. And we discussed the critical matter regarding youth justice and agreed that Target 11 of the National Agreement is an urgent priority that requires collective action across multiple government portfolios and jurisdictions to deliver in terms on-the-ground results. Target 11, to reduce the rate of Aboriginal and Torres Strait Islander young people in detention by at least 30%, is not on track to be met. Joint Council agreed to escalate this urgent priority to progress work that will achieve improved accountability outcomes, coordinated jurisdictional actions and outcomes. It was agreed by that Joint Council co-chairs write to First Ministers to seek details of how their governments are currently taking steps to meet Target 11, including consideration of remand, alternative accommodation and health and disability care and education of our youth in our people in youth detention justice facilities. We feel terrible when the political imperative of a party running in an election gives credence to bringing in Aboriginal, bringing up the tough on crime and highlighting the extent of Aboriginal and Torres Strait Islander kids and adults, as the villains. And there's very little we can do about that, given our population and our resources. It's up to, and the electorate, just buys all of this by electing these hardline governments. We've reached out, for example, we've had the Minister, Steve Boddington from the Northern Territory involved in Joint Council. We haven't had a Queensland Minister attend yet, and we're in discussions with the senior advisor from her portfolio to try and get the Minister more engaged. I write, as I do in any new government, to the First Minister, and in both cases I got palmed off to the Minister for Responsible, which is fine. Steve Boddington has engaged, but the Queensland Minister has yet to engage. And, so it's very disappointing that they don't recognise the importance and the centrality of the national agreement that's been endorsed by every government across the country. And what's more, they don't follow the provisions of it that they've already signed up to. So what do? I just keep on pressuring.
Well, I mean, you're doing everything you can, trying to get these documents together, try and have an evidence-based framework, listening to your communities, representing that. You produce a document and the Commonwealth sits with you in this process, produces the Justice Policy Partnership, which is based upon those good principles, and then the Commonwealth then says, job done, and washes its hands of it as though somehow producing this document is implementing these changes, and yet we know it's not. And then in their submission, they reference this lovely document and ignore the fact that for the last 2 years, the Commonwealth's lovely document has been breached and ignored and torn to shreds by state and territory governments. I mean, when you're talking to the Commonwealth about their failures in this regard, what do they say to you?
Well, that's questions best put to the Justice Policy Partnership participants directly. I'm not on that committee and neither is Lisa, who's with me. But I guess it's important to point out to you that, political leaders ignore expert advice and prioritise populist tough-on-crime narratives over evidence-based justice reform. Just in the last 6 months, we've seen appalling violations of human rights, including draconian bail laws, targeting our children, reversals of protections, such as lifting the use of spitthoods in the Territory and lowering the age of criminal responsibility. Not that the other states have got great record. New South Wales can still send a child to prison at 10. Excruciating punitive policies. And I'm just not sure, this political opportunism is just being paid more credence than the overwhelming evidence that we have produced year after year after year. And the defying of recommendations from legal and medical experts and human rights bodies, the Justice Policy Partnership is up against it in trying to get, the Minister, for example, the Attorney General has all of his state and territory colleagues. He's outnumbered. He could use more fiscal power if he had it, and they could look more dramatically at legislative measures and international human rights measures, but they've got to balance their way in Parliament too. I mean, we've got an opposition in Peter Dutton and the Nationals who don't even want to stand in front of the Aboriginal flag if they get elected. So you can see that we're getting the wedge issue again of Aboriginal people being demonised coming up in the next federal election. So we despair over this and it's very difficult for us when we try to work on the basis of facts and evidence and impartiality with anybody who's in power. I mean, this national agreement was ushered in by Scott Morrison when he was the Prime Minister. So the Coalition is committed to this national agreement and we expect it to be honoured no matter who wins the next election. But we've had strong support from the Albanese government and we've been appreciative of it. There are so many areas that are intertwined here and it's been very hard to get bureaucracy to move out of their cultural cosiness of their own areas of responsibility and look at the breadth of things through the eyes of an Aboriginal person who can see the interconnectedness between housing and safety and food security and income and poverty and so on. Very hard to convince bureaucrats of their relationship about those things. So I'm sorry I'm not answering your question directly.
No, Ms. Turner, you're doing a great job and I appreciate your evidence. But you You point out rightly that the Federal Attorney-General is outnumbered when sits in that committee. But there's a nice little bit of the Australian Constitution, which is section 109, and it says if the Commonwealth passes a law, then state and territory laws can't be inconsistent with it. So if the Commonwealth wanted to implement the Justice Policy Partnership, it could look to our international obligations, look to what its commitments are, and then could implement laws and compel the states and territories to lift their game. You don't need the numbers on the committee. You just need a government with some principle and guts that's willing to listen to the evidence at a Commonwealth level, don't you?
Yeah.
You need a bit of national leadership.
We do.
Well, we look to the current government, and where do we see the national leadership? They have a document that's breached left, right and centre by states and territories, and they just do nothing. That's not leadership, is it?
Well, they probably think they'll get blocked by the opposition.
Well, the opposition doesn't have the numbers.
Yeah. Well, it'll be up to the federal government to negotiate that make sure they had the numbers to get through Parliament. Priya might want to say something on that.
Thank you, Pat. I was just going to concur, Auntie Turner, with what you were saying about the JPP. I mean, I think what we see, I think this lack of implementation or lack of, I guess, commitment to the JPP, for me, is an example of, just the continued politicization of, of the experiences, the lived experiences and the plight of our Aboriginal and Torres Strait Islander communities. And, at a federal level, I think, you're absolutely right, Senator. Can more be done? More can always be done to ensure that there is an adherence to the commitments made, via mechanisms like the JPP. Just, there's an immense amount of work that goes into the JPP. I mean, you're not just in terms of the sort of, outputs, I guess, but just the sheer amount of manpower that has to go into putting together and organising things like the JPP with already very stretched resources. And I think to see it sometimes, either fall flat or not be committed to at a state level is quite disappointing. And I think, the question remains, how can or what role can, the federal government, regardless of who's in power, ensure stronger alignment and a commitment by the states to do this. And I think if we can ensure that commitment, we will see less of that politicization at a state level in terms of, raising the minimum age, adult time for adult crime, and more sort of focus on concerted evidence-based solutions.
But you see...
Senator Shoebridge, just last question. I need to share the call.
You point out rightly that a huge amount of resources, particularly from First Nations peak bodies, goes together to produce this Justice Policy Partnership, and it reads well. It's great. And then it gets totally ripped up by the states and territories, and then the Commonwealth says, well, look, we did great work. We produced this Justice Policy Partnership. In actual fact, what the Commonwealth has done is misdirect a whole bunch of First Nations resources to a document that they're not willing to enforce, that they're not willing to implement. In fact, it's almost a dangerous course of government from the Commonwealth to misdirect scarce First Nations community resources to a document that they're unwilling to back in. It's a dangerous misdirect in some ways, isn't it? I mean, surely your organisations want to be involved in meaningful change. And if you've got a partner that's not genuine in the form of the Commonwealth government, that's pretty dangerous when we're talking about kids' lives, community safety.
I mean, I think, sorry, I'll just quickly chime in before, because I see Auntie Pat Turner has unmuted. But if do you want to go first, Auntie Pat? I can pause.
No, you go ahead, please.
Yes, I was just going to say, I think to say, just, you're right. The federal government has an obligation, but yes, but states and territories also have an obligation, right? And I think this sort of buck passing between states, between the states and sometimes, in terms of who's responsible for Aboriginal Torres Strait Islander issues or who should take the lead on Aboriginal Torres Strait Islander issues is not helpful. I think what needs to happen is a sort of, and I guess the JPP was an attempt at this, a cohesive, collaborative approach that puts, issues of child protection, issues of, youth imprisonment and incarceration beyond politics. What that would look like is, to me, actions or activities that, see not just the federal government, ensuring alignment, but also the states contributing, to these initiatives in addition to whatever else they might already be undertaking. Sure, can the Commonwealth government do more? Absolutely, but I think the states and territories can also do a lot more. And it doesn't. And I think that's the beauty of federation. The beauty of federation is that when the Commonwealth falls back or falls behind,
in terms of reference,
when the Commonwealth falls behind, federation, when the Commonwealth falls behind, the states and territories can pick up. But what we're seeing is that is not happening, or rather, it's happening very inconsistently across jurisdictions.
Okay, Ms. Turner.
Yeah, well, I agree with you. The Commonwealth should do it. We're sick of waiting around. Should there be a hung parliament after the next election, it may be an opportunity to influence that more strongly.
All right. We'll get stuck into that.
Okay. Thank you, Senator Shoebridge. Senator Little.
Hello, and thank you for making the submissions that you have. I want to ask a question probably of Ms Turner around your submission in relation to the references to Commonwealth holding the critical levers, including fiscal and political power, and specifically the tools. Given the breadth of your experience in senior leadership roles in bureaucracy and also in Aboriginal community-controlled organisations, I'm interested in understanding when you're talking about tools, what tools are necessary to actually influence Commonwealth, state and even local government engagement in this, as well as the challenge of Aboriginal community-controlled organisations and community-controlled organisations, not-for-profits, in this space to actually deliver different outcomes faster?
Well, money speaks all languages, and fiscal control is very important. So, for example, there are significant intergovernmental agreements like the housing and homelessness, the National Skills Agreement, the new education one, and we've had a lot of input into those intergovernmental agreements, and we've been very keen to ask for money to be quarantined within them to fulfil the commitments that are made under the national agreement, or towards that. And the National Skills Agreement is the only national agreement that's actually done that. So we're very pleased about that and the work that Minister Giles is leading in that regard. But we haven't had the same allocation for housing, which is our absolute number one priority. So while the intergovernmental agreements, Senator, reflect the priority reforms in the national agreement, they don't reflect the fiscal power where money can be agreed and quarantined for Aboriginal programs. And it's very important that that happens across the board. The education intergovernmental agreement, on the other hand, is very well developed and has been done in consultation with us and the education peak. and so we're very pleased with the way that's heading. So that's one of the tools that the Coalition of Peaks took the initiative on, not governments, and decided that we would intervene. And I signalled that about 3 years ago to National Cabinet when I met them, that we would be looking at intergovernmental agreements and we would be expecting, the priority reforms to be reflected, but especially for all First Ministers to insist on the quarantining of money for our people.
Can I ask, you've outlined national agreements across a range of cross-portfolio across a range of cross-portfolio areas. What about the inconsistency in timeframe deliveries for some of those? How does that impact you meeting targets?
Well, that's the same with other arrangements, of course. It's a 10-year agreement, and I'm saying to all governments now, we're now into the implementation phase. We've had all the, looking at processes and setting up arrangements and whatever. Now you've got to, this is where the rubber hits the road, and you've really got to start investing and working in true partnership with our people. And, do the data collection and reform the cultures of your bureaucracies to be safe places for our people to engage. I've spoken to, for example, the broader NGO sector, and I've made it clear that, their funding should be transitioning to community control, but before they do that, they should be working in partnership with our community-controlled organisations to pass over the skills and the expertise and the in terms of the submission writing and the service delivery and what tools and resources they use. So, so that when funding is handed over, it's done to an organisation that's competent and capable of delivery. I'm not sure whether I've answered all of your questions. There are so many tools that you have to lever, and we keep on pointing out to government, you could do it this way, or you could do it that way, and that's in direct conversations at the state and territory level. We have a peak in each state and territory that works with the state government, a peak, made up of representative bodies, and I often go with them to meet with their senior bureaucrats and point out how they could leverage towards better outcomes. So we're doing that all the time, Senator. It's often it's the political will or lack of political will, and like I say, look at New South Wales, the imprisonment age of 10. They've done bugger all.
So can I just talk specifically about some of the Close the Gap targets and the focus of this hearing on youth? If you talk about incarceration of adults, which is, is going in the wrong direction, and we've just heard evidence about the number of children who are in custodial settings now who had a parent who was also in custody, children in out-of-home care. We know residential kids do worse in terms of ending up in custodial settings, early suicide and harm, that whole trauma, people dying earlier, early childhood development. We've also heard recently in the APY lands, only 2 to 3% of children are actually attending school regularly. My question goes to, given those are the targets currently identified now on an aggregate level going backwards, how do we actually focus on those key areas which, we have heard evidence have a direct impact on children in custody?
Yeah. We've got so many battles, so many fronts that we're battling with every day Senator Little. You know, for example, I think it was something like 80+% of our children are being held on remand. They haven't even been charged. And we've had some, you know, really needy young people in those situations where they haven't had a proper health assessment and they haven't had the health treatment. And they're sitting in these places for months and months and months on remand, let alone getting charged and sentenced. So that's a major, major concern of ours across the board. The resourcing of organisations that can provide support systems, like, you know, we've only got a trial in relation to what we're doing with the health system, with the health department in terms of prison health services. But we'd certainly like to be funded to do work, and the agreement of the state corrections and so on, and other health experts to work with us to provide better services to our children in detention or on remand, and in out-of-home care. You see, I've always believed that a child who comes into contact with the system, one of the first things that has to be done is a proper health check to determine the health status of that child, both physically and emotionally and cognitively. But that doesn't happen.
Can I ask, I just want to finish up on two things that have been brought to my attention, and both the First Nations advocates against family violence and yourself could answer this. There is the opportunity in some places, and particularly in the Northern Territory, for people who are, whether they're held in remand or in custody, to participate in activities for behaviour change in relation to violence. And we know the numbers of people that are in there for family violence, intimate partner violence, are horrific in terms of the numbers. What I'm really interested in understanding is, it's really clear in talking to the legal profession that there's this tension between people actually participating, and if they're on remand, particularly, the potential for an admission of guilt in relation to that if they participate on a voluntary basis. So there you've got a situation where, regardless of the outcome, you could actually capture somebody. So I just want you to give me give some thought to where there might be a breakthrough solution there. But also, in terms of frontline services, I've also become aware that some frontline services won't take children, particularly Aboriginal children, who are over 10 years of age. Can you tell me also, in you thinking through that, what's the implications and what's the breakthrough we can identify to ameliorate what is the outcomes of those things?
Well, I think every child should be assessed on the basis of need rather than age. And I just don't understand organisations that can't treat kids under 10 or over 10. Ridiculous. On what was the first part of your question? Sorry,
it was in relation to the behaviour change programs that are available and the legal profession's tensions.
Yeah. So I think that if they're having a behavioural change program, it should be totally discreet and protected from the court case. I mean, you know, there's just got to be some safety guards, rails put around people's participation. But I also think that the use of First Nations interpreters and language is equally important in those courses, because quite often the concepts are very foreign. So they need more First Nations language speakers involved in those. So that's my view, Senator. Priya, did you want to add to that?
Yes. So I, in terms of the second question you asked, I completely agree. I think children need to be assessed in terms of need and not something quite as arbitrary as age. So, you know, I think services, you know, have to be funded to be able to, take in or help children based on their needs, because we know that I think needs can be quite substantial and quite complex, more complex than, say, admitting someone based on age. In terms of the first question, now I've drawn a blank. Sorry, Senator, could you repeat the first question again?
So it's in relation to people participating in,
yes,
and I'm saying this because I'm in mind to think about victim survivors, witnesses, and perpetrators.
Perpetrators, absolutely.
You could be all of those things at once.
Absolutely. You might be a perpetrator in terms of your, whether it's domestic violence or whatever the crime, but we have to look at the crime in the context of your life course, of your life experience. And what we know, for example, is that, Aboriginal and Torres Strait Islander individuals have a very complex life course. And, there are multiple experiences of disadvantage that have no doubt put an individual at risk of perpetration. But I think, having said that, in terms of programs, I mean, absolutely, there is a lot of, general research on the efficacy of, behavioural change programs or perpetrator programs. But yes, they should be kept quite separate from the court processes and shouldn't be sort of attuned to or sort of associated with or contingent upon, if you complete this, then this might be, this is how it could affect your outcome in terms of a positive and negative court outcome. But what we also know is that there is actually a dearth of research and, in fact, a dearth of practice on what culturally appropriate programs look like. We know that, a lot of the, for example, desistance research or research around, future desistance on behaviour is very, has been undertaken in contexts that is not culturally appropriate. And what we do know is, programs or activities that might work for, a cohort of, say, generally Australian people might not work for Aboriginal and Torres Strait Islander communities and individuals. So absolutely, I mean, I think there is something to be said about these programs, about how they're conducted, how they're funded. The evidence base behind these programs needs to be aligned and appropriate to the individuals at hand.
It's more about the roadblock that currently exists for people to even participate in that while they are in a custodial setting, whether they're on remand or otherwise.
Yeah, I mean, I think I'd be interested to understand why that roadblock exists, because ultimately, if someone's post-custodial or post-justice interaction outcome can be enhanced by or can be made positive by behavioural change programs, then there should be no reason, I think, in my opinion, that they should be denied that. Having said that, I think that the types of programs really makes a huge difference. And in fact, research has shown that the wrong programs can have an adverse impact. And what we don't want is it's a compounding of this sort of adversity.
Thank you.
Thank you very much, Senator Little, and thank you to the witnesses for appearing today. Thank you for your submissions. It's greatly appreciated, and we thank you for taking the time to give evidence today. Thank you very much, Ms Turner and Ms Davendran. Thank you.
Thank you.
Thank you.
Thanks. Bye.
Thank you. Bye.
Right, I now welcome, and I'll start reading my blurb as you come forward. I now welcome representatives from the National Commission for Aboriginal and Torres Strait Islander Children and Young People. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. So, sorry, that's a bit of a blurb I've got to go through.
If you could just repeat it back to us, that'd be great.
Yeah, no worries.
So if I can ask our witnesses to please each state your full name and the capacity in which you appear. Ms Gordon, to you first.
Lillian Gordon. I am currently the Acting National Commissioner for Aboriginal and Torres Strait Islander Children and Young People.
Excellent. And is this the first time you've appeared in that capacity?
It is,
before
yes.
a committee, so welcome. Thank you.
And congratulations.
Thank you.
And Mrs Ranagi.
Stella Ranagi, Director for Aboriginal and Torres Strait Islander Children and Young People.
Excellent. So welcome to the committee. Do you have an opening statement?
I do, thank you,
Okay.
and appreciate the opportunity to be here today, absolutely, and hear from just about everybody, so it's what they said. I certainly acknowledge the Ngunnawal and Ngambri people as the traditional custodians on the land on which we meet, and I pay my respects to elders past and present. I acknowledge the continued courage, unwavering commitment, insight and determination and pure grit of Aboriginal and Torres Strait Islander people and communities who continue to advocate for their children and young people to flourish. I'm a Niambar woman from Brewarrina in New South Wales, and I'm the Acting National Commissioner for Aboriginal and Torres Strait Islander children and young people. Representation matters, and I'm absolutely honoured to work in this role and embrace the opportunities gifted to me at this time to walk alongside our Aboriginal and Torres Strait Islander children and young people, their families and communities. A bit about the Commission. The National Commission was established as an executive agency and commenced operations on the 13th of January 2025 as an independent entity within the social services portfolio. 13th of January, I just want to remind everybody. The National Commission is dedicated to protecting and promoting the rights, interests and well-being of Aboriginal and Torres Strait Islander children and young people. At the heart of the National Commission is a commitment to fostering trust, collaboration and meaningful dialogue, centring the voices and lived experience of Aboriginal and Torres Strait Islander children and young people, ensuring they have a direct and empowered platform to share their experiences, priorities and solutions. The National Commission, along with my appointment as Acting National Commissioner, is in its very early days. Our most immediate work is to firmly establish the administrative and corporate functions of a functioning independent non-corporate Commonwealth entity. Alongside this work, we are planning engagement with a diverse range of stakeholders to consider the actions that align to the functions as outlined in the executive orders in the establishment of the executive agency. These include promoting and protecting the rights of Aboriginal and Torres Strait Islander children and young people, providing strategic policy advice and reports to government on matters affecting Aboriginal and Torres Strait Islander children and young people and their families, promoting and enhancing coordination across Commonwealth, state and territory governments, collaborating with Aboriginal and Torres Strait Islander children and young people and their families, Aboriginal and Torres Strait Islander leaders, commissioners, guardians, advocates, relevant Commonwealth and state and territory governments and non-government organisations. I know that this is foundational work, but important early work. It is clear from the evidence presented here and at numerous inquiries, royal commissions and reports that the role of the National Commission and the National Commissioner will need to be strengthened to pursue with rigour and give effect to the rights of our children and young people. The current state of affairs in youth incarceration, and particularly for Aboriginal and Torres Strait Islander young people, is hard to fathom, but heartbreakingly true. Stan Grant, in his talk about Jumbunna, to live with dignity in a world of catastrophe, says, in our world today, humans have become expendable. There is a loss of trust in each other and institutions of democracy. The National Commission, while focused on issues such as unacceptable out-of-home care and youth incarceration rates, will also amplify the opportunities, goals and aspirations of our Aboriginal and Torres Strait Islander children and young people. This resonates very much with this year's NAIDOC theme, the next generation, strength, vision and legacy. The National Committee expresses that the theme celebrates not only the achievements of the past, but the bright future ahead, empowered by strength of our young leaders, the vision of our communities and the legacy of our ancestors. They also indicate that they look forward, honouring the next generation who will carry the torch, shaping the future with courage, insight and deep respect for our roots. In closing, I consider the words of Aunty Lilla Watson, If you've come here to help me, you're wasting your time. But if you've come here because your liberation is bound up with mine, then let's work together. We look forward to collaborating with Aboriginal and Torres Strait Islander children and young people and their families, Aboriginal and Torres Strait Islander leaders, commissioners, guardians and advocates, relevant Commonwealth and state and territory governments and non-government organisations. Thank you.
Thanks, Ms Gordon. And we appreciate early days, and I can't imagine all the things you've got on your to-do list at this at early stage, but really appreciate you taking the time to appear today. Senator Shoebridge.
Yeah, and I echo the Chair's thoughts in that regard, Ms Gordon. You know your way around bureaucracy. I know that because I've seen you in multiple roles, and you've got those connections to community. How do we go from producing something like the Justice Partner, the JPP, this partnership document which has got all the right bureaucratic words in it, to actually making meaningful change? That's what's missing here. How do we stop, for example, state and territory governments making things worse to start?
Look, it's a great question, and absolutely understand where the Justice Policy Partnership is coming from, and some of those elements that you talked to is absolutely critical. Look, and in this case, I do absolutely want to pay my respects to Auntie Pat Turner, particularly, when you see Auntie Pat and the way that she keeps turning up and keeps doing these things. That's kind of what we need from a government perspective. Let's keep turning up. Let's keep being in front of things. Let's keep making the commitments and standing by those. I think for me, a big part of this role particularly is about how do we think about this from the national landscape. What is it? And most often you've talked about Commonwealth levers on many levels. In that space for this role, it's having a look at those Commonwealth levers and understanding how they can be pursued in order to do some of those things, most definitely. As I mentioned, we're in early days. Currently, our focus is around our executive orders and those aspects that I've outlined earlier. And is there a need to consider future legislation that looks at a greater depth in terms of what this role can do in terms of oversight and accountability in those places?
Is that part of your remit? You were talking about the executive orders. I think a lot of that is standing up the agency, the sort of bureaucratic fundamentals, and you need to do that. Mm-hmm. But do you have a specific sort of limited direction from the government, or are you able to establish your own direction? How's it going to work in terms of autonomy?
Yeah, absolutely, and it's a great question from that perspective, and I think we're still working our way through that. Obviously, we've been in operations for 3 weeks now, and part of that is we have to be clear that we do have to set it up in a way that it's critically has those administrative functions and all of those things in place that stand it in good stead in that way in the first instance. The second part of that is then thinking against those particular orders, what is the work and the action that needs to be done? And if some of that action is then the next phase of that is looking at maybe, thinking about legislation into the future, then I would absolutely agree that this is part of the remit for this role. Understanding that I'm the acting commissioner at the moment, I'm not sure in terms of obviously the length of time before the ongoing commissioner comes into play. That would be a question for the Department of Social Services, of course.
Yeah, but does your remit extend, for example, to having a look at what the Commonwealth says and then what it does, and if you have a critical reflection on that, saying it loudly and clearly and trying to bridge the gap, so to speak?
Absolutely. I mean, look, it talks to, one of the actual roles or aspects in terms of the executive orders is exactly that, is how do we make sure that, number one, that the voices of our Aboriginal children and young people are heard, but secondly, how do we look at and enhance the coordination across Commonwealth, state and territory governments? That's going to be a critical part of this. And how do we ask the hard questions? That's going to need to be an important part of this role.
I mean, you said your opening statement was effectively what they said, which I appreciate the brevity, and I think picking up on what we've heard this morning seems to be a great starting point. We had the National Children's Commissioner here earlier. I think she'll be returning later this afternoon. Her report, Help Way Earlier, you could kind of pick that up, couldn't you, and whack the government on the head with it until it does it.
Well, you know, I
in a peaceful and non-violent way.
Yes. Look, I mean, I think you talked earlier about the stick and the carrot. I think it's really important about how we form those strong relationships. But I also think another part of that is when I talk to Auntie Lilla Watson's quote about that liberation piece, what is it about anybody that works in this space? What is it about the people that work in this space? We talk about a systems reform, we talk about a systems approach, but there's people that work in those systems. So in terms of holding that to account, but who are those people? What do they come to us with in the first instance? Catherine Little talked a lot about what's kind of flowing around the landscape at the moment. You know, the way that, you know, we are seen in the social media space, the way that our kids are talked about. I mean, how can we put that in terms of politics? That shouldn't be something that politics takes on board. We've got to understand the insides of people. This has got to be a hearts, mind and spirit conversation. This can't just be about a hard line on a piece of paper to make it a difference.
Yeah, 100%, that's essential work. But at the end of the day, parliaments do a couple of things well and a couple of things, you know, plenty of things badly. One thing they do is they pass laws, and the other thing is they direct money. So why don't we look at those two very practical things about passing laws and directing money and look at the Commonwealth's role in that regard. But what do you see?
Well, look, I think you're right. In first instance, when we look at the National Children's Commissioner report and her help way earlier, there is certainly a roadmap of all of the things that have been mentioned certainly today and probably will be mentioned further down the track, along with previous multiple inquiries, multiple reports, multiple royal commissions, and the concept of how much evidence is needed. But it gives us some practical approach to what that looks like. In terms of this role, we'll need further diving into that in terms of understanding that, and I am sure very much so that this role will work very closely with the National Children's Commissioner as we can work through those.
Yeah, I suppose one of my fears is, despite your best endeavours, what we end up getting from the Commonwealth is another lovely PDF, or maybe a great brochure, or maybe a short YouTube video, all of which look nice and say the right things, but don't stop a 12-year-old girl being put in a Queensland adult prison cell for a week. That's my concern. How do you respond to that?
I absolutely appreciate your concerns. And really, as we've continued to hear evidence today, I'll be honest, it's difficult to sit and listen to that. Yeah. It provokes emotional responses. It promotes and provokes a need for something that's much deeper and needed for us to happen. And it takes a practical approach to that. But yeah, I think there is a role for government in this space to be able to work with our states and territories in a way that brings accountability to the basic human rights that we need.
So when the Commonwealth is silent in the face of the Northern Territory wanting to reinstitute spit hoods on 10-year-old kids, what does that say about the Commonwealth's commitment in the space? I mean, I personally think that's torture of First Nations kids. I think that's pretty well documented torture. And when the Commonwealth does nothing in the face of a territory government saying they want to torture 10-year-old Indigenous kids, what does that say about the Commonwealth's real commitment?
Look, and I take on board that that's definitely your opinion in this space. I mean, I would have to say that in my experience, and certainly working much more recently in this space, that the Commonwealth isn't quiet necessarily.
Well, can you point me to a single moment where the Commonwealth has, or the AG has said, actually, I support this powerful Indigenous voice here opposing spit hoods. I want to give this voice more power.
Look, I would have to take that on notice in terms of being able to find that specifically for you, and certainly we'll do that. I think that it would be a misrepresentation for me to say nothing is being said and nothing is being done, but whether that's a case of it's being done in the relationship space, you know, in talking to each other and then being able to promote what they feel is the right thing to do, I think those conversations are happening.
Well, can you give me an example, Ms Gordon?
Not right at this occasion, so I'll take that on notice.
Well, you see, when you have a territory government or a state government running that kind of narrative and there's no public pushback from the Commonwealth, it creates those negative narratives. It allows those negative narratives about First Nations kids and families to get traction. Surely there's an obligation to engage in the public narrative as well, rather than just if it is happening, and you might give me examples, private chats?
Yeah, look, absolutely. I think there is a need to have a strengthened approach and a visible approach in terms of the Commonwealth role in this place. Absolutely.
Well, when we have UN subcommittee on torture calling out Australian child prisons, and we have no substantive response from the Commonwealth. You know, last time I checked, the Commonwealth is the government agent level that interacts with the UN. What does that say about the Commonwealth's commitment?
And yes, that is a role for the Commonwealth, particularly when we think about the UN and the Convention on the Rights of the Child, Human Rights Act's mandates. So there's a fair bit in the space that we can still consider and get done.
So I'll come back to the first question I asked you about, because I appreciate the knowledge and the experience you bring. You know about bureaucracies and, you know, and I'm sure it's hard-learned, sort of brutally learned knowledge. How do we turn PDFs into actions? How do we turn shiny brochure into actions? How do we get the Commonwealth, because we're a Senate inquiry, how do we get the Commonwealth to pick up its game here?
We have to be able to listen to those who are on the ground. Catherine Little said it very well, so did Auntie Pat Turner. When we think about our communities on the ground, investing in our communities on the ground, investing in our organisations that make a difference on the ground is the important piece that we need to look at. And listening to their voices in a way then that makes change.
But you see, that kind of did happen in the Justice Policy Partnership. That document did come from the ground, listened, heard, saw what was needed. But then state and territory governments have done the exact opposite, and the Commonwealth hasn't lifted a finger to stop it happening. So the listening kind of has been done. What's missing is the action, isn't it?
It is the action, and like you said earlier, there are definitely many things in place, including the Help Way Earlier, the national agreement in terms of closing the gap. All of those mechanisms are there, but how we make sure that we hold that into account is probably one of the roles that this will have, along with the other commissioners, advocates and guardians, in a strengthened and collective way, will be incredibly important.
Yeah, Help Way Earlier is great, right? Produced by a National Children's Commissioner after consulting and talking with kids, and that's the language that's coming from kids. But where's it being picked up by executive government? Where's it being picked up by the Commonwealth government and its legislation? You know, where's the embracing of that from the current Attorney General, for example? Can you point me to anything?
Yeah, so I mean,
I'm not holding you to account for.
No, I absolutely get that, and I appreciate your questions. Yeah. And to be, you know, probably fairly blunt in terms of this inquiry, certainly helps this National Commission and the National Commissioner consider the work that needs to be done into the future in this space, most definitely. So from that perspective, you do have a number of plans, a number of things happen. Catherine Little talked to the Safe and Supported plan that was in play and talked positively about that plan and what is happening in that space. So I think from the role from this point of view is to really find those things that are working, understand where they're at and present those in a way that are fairly strong and hold people to account for those.
Can I ask your question, Paul?
Well, Senator Little has some questions. Are you nearly...
Well, I mean, I can't remember if the Chair's asked the question that the Chair's asked of every other witness, which is, do you have a response to the Commonwealth Department's submission? Did you ask that, Paul? Chair?
I was waiting for it, so...
Yeah.
Well, it wasn't a surprise. The only thing I was going to add to it, Ms Gordon, was we're probably going to adopt, we haven't yet, but we'll probably adopt 14 February as the time to respond to questions on notice. The other thing, apart from giving a response to the Attorney General's Department submission, was also if you had anything else to add, because you've just been stood up, please, if you've got any other thoughts or anything to add in terms of that time frame. I know it's not long and you've got other priorities, but the invitation's there.
And that feels hard. That feels hard on this role, to not be able to come forward with the gusto that I'd hoped that we could, given the very short time frame since we've stood up. So for me, you know, it's definitely important, and we will have to take time to consider it and certainly provide that on notice.
And also, Ms Gordon, before I go to Senator Little, also appreciate that the committee has, and I think this is public, we're looking to produce an interim report. Oh, sorry.
But I think it's fine.
Okay, good.
Subject of ongoing committee discussion.
Okay, sorry.
We've now agreed to make public.
Thank you for your indulgence, Deputy Chair. I'm flushing red. But so we are looking, we know it's an abbreviated timetable. Just before I go to Senator Little, one of the points that Catherine Little made was, in the term used was glue,
yes.
a lack of glue between...
Yes, I noted that down.
You noted that down. It was a phrase that struck me in terms of the glue between the different functions and services that were provided. So I just wanted to give you an opportunity to give your reflections on that lack of glue, or we need more glue in terms of connecting different functions in terms of coherent whole. So if you had any comment on that.
And look, Catherine talked to it along with a number of others around the ecosystem that is out there in terms of those supports, the things that are there in order for us to have prevention for these things to happen. Think about restorative justice, think about what our Aboriginal community controlled organisations can do, think about what our governments are doing. So there's a whole ecosystem that was talked about. And the glue, for me, is exactly that coordinated approach and understanding each of those things that are happening, what's working, what's not, but also how does the glue remain the glue? I think one of the points that was made and throughout the time is that the glue seems to be able to be undone fairly quickly, even when that glue's been in place for a long period of time, or the evidence has pointed to that glue being the glue that has worked so long. So I think for me, it's part of this role is thinking about how do we keep that glue intact long enough to be able to make sure that our children and young people are safe, that they are protected, that their rights are at the very core of these things. So for me, there's more thinking around the glue. I think it's a great starting point. And I do think we have a lot of glue, but that glue is built by our communities. They are built by Aboriginal community organisations. And more of that glue needs to come into place from the perspective of government, most definitely.
Thanks very much. Senator Little.
Thank you. Well, this question kind of goes to more glue, less glue. Given that, Ms Gordon, you're acting in the role and it's a very new role, I'm wanting to ask, there are a number of commissioners that exist across a range of different areas that the government has put in place. I'm interested to hear your views on the independence of your understanding of independence to talk about what is a critical issue right in front of us right now in terms of those 4 targets going backwards, and your capacity to speak up on Commonwealth, state matters, even ACOs and their performance and not-for-profits and their performance, and in the context of your ability to just speak out as opposed to having meetings organised, diary entries made for you. What do you understand about the independence of your work in being able to raise issues in all of those areas?
Yeah, and look, and as I mentioned earlier, that this is part of the work that we're doing now, is to ensure that we're establishing the administrative and corporate functions of a functioning independent non-corporate Commonwealth entity, which includes the accountability systems, the processes to ensure that we're compliant as this particular body in the first instance. We'll have accountabilities through corporate plans, annual reports and financial statements, of course. In terms of the independence, I do think that's a work in progress right now. As I mentioned, we've been 3 weeks since we've been operational in this space. As you understand, it sits in the portfolio of social services. So there is a bit of work to be undertaken to understand what that independence really looks like and can really then take on. And whether that's future work around future legislation may be part of that. But at the moment, it's starting to take its shape, and I do feel confident enough to say things that are from an independent point of view right now, even as the acting commissioner. And that's certainly been, promoted to me as something that I'm able to do. It's not something that I've been held to account to be within the Department of Social Services. So I can honestly say that for me, currently in the acting role, is something that I can do.
So given that across the states and territories there have been commissioners in place with pretty similar titles and pretty similar responsibilities as this new National Commissioner role, and over that time we haven't seen a change in the trajectory in the direction we would want, what is going to be the critical ingredients for a national role are actually being able to make a difference?
Yeah, look, I think for me it's a great question and one that I think we've grappled with for a little while, and will give me an opportunity to talk to those commissioners across those states and territories. We haven't had that opportunity yet to be able to come together to really do that. So for me, I want to be able to understand for each of them, what has it led to? Like, what's their space? What does it look like in terms of their own independence and their ability to be able to enact what they need to in their space, which can inform what this role needs to do. I think we'll have a greater space in being able to bring and coordinate not only those across those spaces in national commissions, commissioners, advocates and guardians, but more so how are we collectively moving to be able to get some of those things changed where they're needed to, support the rights of our children and young people in that space.
Given there's been so much focus recently on an age, and I just want to ask the question about, there's a tendency of people coming into new roles to go and do their own report, go and do their own assessment of what's been done, despite the fact we've heard Help Way Forward is in there, it's current. It certainly gave voice to so many children, which was different to, say, the report into the cashless debit card, the ending of that, where not a single voice was heard from a child in that report. So I've just wanted to ask about, I guess, how do you make sure that what we don't end up with is another report that takes time, that then takes implementation when there's already a plethora of information and recommendations around, and children, we can't wait another 3 years for a child to become developmentally challenged by the time they're 3 years old, and therefore on that trajectory.
Absolutely. I think one of the core aspects of what I would like to see happen in this role is definitely that, is understanding what's already out there and what are the ones that will make a difference. We often know that all of our people are, engaged in on a regular basis consistently, and they repeat the same answers over and over again. So it's important for us to look at what's already been said, but making sure, though, we're testing that is true and valid now. We're post things like COVID, for example. We're post things like the referendum. So there are things now that have more of an impact on our children and young people that may not have in some form at other times. When we think about social media, Catherine talked to what our children and young people are hearing and feeling and understanding who they are. So for me, it's important not to re-prosecute and re-traumatise by continually going to people. So part of this role, I think, should work through the commissioners and the guardians and those who are already there, through the Coalition of the Peaks, through places like SNAICC that are already doing and done the work, and be able to bring that all together.
Okay, thank you.
Just quickly,
yeah, sure, Deputy Chair.
Continuing on from that line of questioning, I understand it's very early days. I just want to understand the scope of the role. It's broader than child protection matters and broader than some of those state-based commissioners. Can you tell me some of the other areas that the Commission will focus on?
Yeah, and I think one of the things that I talked about before, there's this element of being certainly focused on, out-of-home care rates, incarceration rates, and some of those areas, and a lot of those areas that are, absolutely distressing, bring about so many things that they don't need to in this space. But I think the other part of the role is about how do we elevate these aspirations? How do we see our young people in the positive light? How are we celebrating our young people in a way that they are seeing what's possible for them? What are the opportunities that they are wanting to bring to us in a way that keeps moving in a positive direction as much as when we consider the other things? It's important that we understand the truth of what's happening, but it's also important that we understand the truth of opportunity and what our young people can achieve.
And I think you possibly touched on this when I was out of the room, unfortunately. Sorry. I just want to understand what discussions you've had so far to prepare for engagement with young people. What does that look like to the Commission? Obviously, you haven't had time to do that yet, but I imagine it's part of your forward program.
Yeah, and as I've mentioned before, it's important that we consider what's already been done so that we're not going into communities, we're not doing the same things over and over again and hearing the same messages. Yeah. So that's an important piece of the work. And then it's understanding what may be already set up out there in terms of mechanisms that our young people have that we're not setting up something else. We're not asking more from our people to be able to advise or give advice. It's really important to use what's already there in terms of hearing the voices of our young people and children in terms of what their aspirations are and what their visions for the future look like. But also what are the things that they believe can change in some of the things that we've already talked about to the depth of what's a lot of despair in this space as well.
And sorry, Chair, just if I can quickly, and is part of that because the sharing or telling of some of these experiences may be quite traumatic, and you don't want to re-traumatise particularly children. I imagine there's a sensitivity about that.
Absolutely, and any research, any engagement needs to have an ethical approach, and that's a core part. Definitely a core part, and our people understand that, and also our kids they're pretty resilient, pretty strong, but we don't want to keep doing that to them. We know what's there. It's been said. The evidence is there. The research is there. There's so many commissions. There's so many inquiries. It's the doing, as what's mentioned before.
Yeah. Okay, thanks, Chair. I'll leave it there.
Excellent. Thank you, Deputy Chair, and thank you, Ms Gordon.
Thank you. I feel it's a little bit hard with 3 weeks in, but
no, look, I think you. To be frank, I think speaking for myself, your passion, your energy, the thought you put into your evidence, the fact that you came along today and obviously sat in to hear the previous witnesses, very, very impressive. So thank you.
Thank you. I appreciate
Thank you very much, Ms Gordon and Mrs Ranagi. So. We will now leave it there. So thank you for taking the time to give evidence today, and good luck to the agency. Thank you. We will now suspend for lunch until 2:10 p.m. I now welcome representatives from the National Justice Project and Jumbunna Institute for Indigenous Education and Research. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, could you each please state your full name and the capacity in which you appear? And Dr. Bofils, can you hear us?
Yes,
you can.
Thank you.
Okay, I'll go to Professor Newhouse first.
Thank you. I'm George Newhouse. I'm the CEO of the National Justice Project, and I'll let Dr. Bofils provide his details.
James Bofils, Senior Researcher at Jumbunna Institute.
Excellent. Do you have an opening statement, Professor Newhouse? Over to you.
Thank you, Senators, for inviting us to speak today. I make this statement having spent decades fighting for improved conditions for people in detention and in prison. I'm hoping to cover lived experience, the lived experience of those in detention and prisons, and Dr. Bofils will cover the data and his research. The issue of youth justice is critical to our nation's future, and the success of all our children is a source of hope for a better Australia and a better world. The children who come in contact with the police, child protection services and the legal system are our most vulnerable. One study found that 90% of children in Banksia Hill Youth Detention Centre in WA had a neuropsychological disorder. That's 90%. Instead of meeting their needs and supporting them and their families, First Nations children are disproportionately taken from their families and communities and then criminalised and punished, often brutally. Their vulnerabilities, which should be addressed with care, are instead systematically used to punish them even further, such as by the use of solitary confinement, which is a form of torture, particularly for people with anxiety or personality disorders. If a child has the misfortune to be incarcerated, they have no effective protections, no effective advocates, and they receive virtually no care. In most states, it's my observation that there is no therapeutic treatment provided to children, no disability support, no education, virtually no education, just brutality and punishment. Children in detention are treated as outcasts from society. They are systematically disbelieved, just as children in the care of religious orders and orphanages were in the past. The Royal Commission into Child Sexual Abuse described these organisations as total institutions because they controlled all aspects of a child's life and they were not open or transparent and there was no independent oversight. The youth justice system is a total institution. It's just as controlling and is just as abusive as religious orders once were. The rates of abuse and violence in youth detention and in child protection are frightening, but the total institutions deny the existence of abuse and violence and simply blame the children, the victims of the abuse. These organisations rally around their staff and their structures, using the law and spin to protect themselves and not the children. Just as the church once did. And I'll just make this final comment about total institutions. Unfortunately, the police and protective services unions actively contribute to these horrors by protecting their membership above the needs of children. Now, you've heard a lot today. There's been a lot of discussion today about inaction on closing the gap targets, the Coalition of Peaks recommendations and other reports. But what about the Royal Commission into Aboriginal Deaths in Custody recommendations handed down 35 years ago? They set out a way forward. You're complaining about the Coalition of Peaks, but 35 years ago, the roadmap forward was handed down by the Royal Commission and they still haven't been implemented. I'm not going to recite the sections, but the Royal Commission made a recommendation 62 regarding young Aboriginal people in the juvenile justice system. It's worth reading. The Royal Commission recommended consultation with appropriate Aboriginal organisations to make use of the services of Aboriginal organisations and to consult with local Aboriginal organisations about implementation of policies. And they also recommended to establish an Aboriginal Justice Advisory Committee in each state to provide the state with information on the views of Aboriginal people. It recommended imprisonment as a last resort, that's recommendation 92, that governments legislate to enforce the principle that imprisonment should only be used as a sanction of last resort. Our governments have done exactly the opposite. It made recommendations about improving custodial healthcare, sections 127, recommendations, 127, 150, 151, 152 and others about Aboriginal health services providing care and psychological support to Aboriginal people in custody. There is much more there, and I'm not going to simply recite extracts from the Royal Commission. I'm happy to answer questions after Dr. Bofus has spoken.
Dr. Bofus.
Yuridimarang Mujigalan, Kiwindu, James Bofus, Baladu, Gandagara Gipir, Yinjamara, Nati, Mayambu, Narambang. Thanks for everyone for having me here. I want to acknowledge country. I'm coming from Wiradjuri country, and thank you for listening. The overrepresentation in terms of youth justice is not something new. However, in the last few years, in terms of supervision and detention, it has seemingly decreased over a period. More recently has increased specifically for First Nations young people. I would like to acknowledge Ani Pat's commentary around remand. I think remand is a very underutilised research area in terms of why young people are there, what is happening when they are on remand, the ability to, as Aunt said, seek health and assessment and what is happening in those prolonged periods of time on remand for our young people. Trends over the last few years have increased, specifically for young women. Less focus and funding specifically on our young women is cause for concern in terms of government funding around our young women, and what is happening is an area to draw attention to in terms of earlier. There was a discussion around what's happening in terms of early intervention and what's happening from the address from the Commissioner around we need to start earlier with our young people and engage them. And it's been seen that in terms of education systems and what Professor Newhouse was talking around in terms of institutionalising, these are colonial institutions where community and young people and families still and continue to feel unsafe, and why that is in those institutions needs to be addressed. Voices of community, we heard that there is evidence and there is research out there. However, attention has to be drawn to who's doing the research and who's providing the evidence. There are a lot of non-Indigenous people researching Indigenous or First Nations matters and understandings. However, is this coming from community addressing what is happening in those areas and stopping government cycles of funding is critical to allow continued improvement within communities. I think it's quite difficult with the cycles of government. We talk about ACCOs or we talk about Aboriginal agencies. It's quite difficult to perform to a level or a service when you are looking to continuing the funding and the longevity. And that funding and longevity is never established, and it is difficult to attain continued and decent funding. So I think there's a number of areas to look at. What's been said already covers a lot. The numbers aren't new. I think and feel in terms of remand, we're comparative, specifically in New South Wales, in terms of our First Nations young people on remand, and in terms of disproportionately our population. So why is that happening, and what is specifically happening within remand?
Okay, thank you very much. Senator Shibridge.
Thanks both for your submissions. And again, look, I just want to credit the work Jumbunna and the National Justice Project have been doing over many years and how critically important it is. Professor Newhouse, the concept of a total institution that is effectively free from external restraints, tends to be unobserved and wants to retain that power to be unobserved and free from external constraints. It really came to the fore in the Royal Commission Against Institutional Abuse, where particularly church-run orphanages and other institutions were permitted to engage in decades of ongoing abuse. Is it really able to be translated into the child protection system?
I think it's a fair comparison. You're talking about, and thank you, Dr. Bofus, for reminding me, we are talking about colonial institutions, so they instill fear in themselves, but the institutions run around themselves. Whenever there's a problem, it's not the staff who are the problem, it's only the children inside. If there's a riot, the children are evil. No one looks at the reason why there may have been a riot. These children have been locked up for 23 hours a day, denied basic education, denied healthcare, denied sport, the ability to run around, do anything that a normal child might do. And yet, through the use of the law, which may suppress names, may suppress identities, suppresses what happens, and the fact that very few independent people go into youth detention centres and are able to reveal what goes on, they are total institutions. These children are totally at the behest and beck and call of the guards. And children with severe anxiety, I've had cases ending up in suicide. I mean, a lot of the work we do at the National Justice Project, unfortunately, is in inquests. Children with suicide are locked up in solitary confinement, which makes their anxiety worse. So they either lie about what's going on to the guards and then take their own lives, or if they tell the guards what's going on, they get punished. Also, behavioural issues are punished, not dealt with by therapeutic care. There is no therapeutic care in youth detention. Can I just raise one point that came up in Auntie Pat's evidence, and that was about remand. A lot of the children that are in youth detention are on remand. And we heard at the Royal Commission into People with Disabilities that the authorities responsible for the children, say at Banksia Hill, they would not send a child on remand to a FASD assessment because they cost $8,000. And by the time they got an appointment, the child might be out. So we talk about properly assessing children. This is an opportunity to properly assess children and work out their circumstances medically, but they're not getting that opportunity if they're in remand.
Can I, sorry to interrupt there, with your indulgence, Senator Shibridge, a FASD assessment?
Fetal alcohol syndrome disorder.
Okay.
Now, I think the President of the Children's Court in Western Australia has every child assessed for FASD, before they are sentenced. 36% of the children are diagnosed with fetal alcohol syndrome disorder. When they get into youth detention, they get no support. And once again, this total institution, no one cares. No one, if they complain, no one's listening. So it is a total institution, and it is abusive.
Yeah, Dr. Bofels, do you have I suppose particularly from your work at Jumbunna, talking with First Nations communities, when they see their kids disappear into these institutions, Professor Newhouse calls them total institutions, which are free from external scrutiny, in total control of particularly in this case, the children in there. From Jumbunna's perspective, how do you respond to that?
So I can speak from my perspective. I can't speak for the entirety of Jumbunna, but within the research, I think when a young person or family is engaged with an institution, it is very difficult because in terms of the wording and language used, the issues are generally steeped or pushed onto the young person or their family, as in there is an issue, it's behavioural management, there is a need for change. They're not living to a specific standard. However, it's not understood what the pressures or constraints or parameters that are set upon that young person or the families or the situation that they're dealing with is fully understood. I think it is critical, as Aunty Pat said and Professor Newhouse has reiterated, that time on remand needs to be effective. In terms of work currently underdone in a jurisdiction within Australia, what is happening with that remand process in terms of programs are not education. Education and improvement needs to be addressed of what specifically is happening for our young people within their learning and understanding when they are taken from community. In terms of the Banksia Hill example, the neuro psychology and what was happening with those people, this is a specific opportunity where the resources should realistically be there to assess or assist with that young person of what is happening and what has happened. And I think it is missed in terms of, from a disability framework or standpoint, what is happening for our young people? Is there something that has been overdiagnosed, misdiagnosed, or not even addressed or understood? Specific neurodivergencies, which I think are very underdone for our people in terms of the ability to feel safe when going or addressing possible symptoms or understanding of that, what will happen in terms of child protection if our families are approaching these services in good faith to get that understanding. And these are the difficulties that we're facing in terms of the funding and assessment and longevity of this and the possibility of this would better be suited within communities.
Yeah, thanks, Doctor. To one or both of you, one of the matters covered in your submission is about Banksia Hill, and I suppose when we're talking about Banksia Hill, which is a Western Australian child prison, we also need to talk about Unit 18, which is a unit in an adult prison, a nearby adult prison in WA, where kids were sent who should have been, well, if they were held in detention in a child prison, were sent into an adult prison because of the appalling conditions in Banksia Hill. Can you talk us through some of the failed accountability measures in WA? Because there's been independent reports, there's been Supreme Court decisions, there's been multiple ringing of the bell about the torture-like and appalling conditions in those two facilities, and yet the WA government persists. Can you talk us through that?
Doctor, are you happy for me to cover that issue, or would you like to?
I can just start on that. I think within those circumstances with WA, I think within remand, the number of young people that are on remand in those situations is quite high and dramatically high. I think remand should be philosophically kept for the most extreme circumstances, yet it's not. The presumption, and I put it to the panel, that the presumption should be in the favour of the bail to support the community and the child and the family. However, that is not happening, and the larger numbers are increasing. And the use of the services is because there is an increase in what's happening in terms of our young people getting picked up, misunderstood, or not thoroughly investigated, or this understanding isn't there. And there's a swell of our people going into these colonial institutions who aren't looked after, who, as Professor Newhouse has said, who are continued in terms of the trauma or re-traumatised or abused, possibly. And why is this happening? Was it for an extreme circumstance or the most extreme circumstance that they were put in there? That's not what we're seeing. And when we're talking about our young people, how is this the case? Professor?
Yeah, thank you. I want to take up one of the points that doctors raised. It costs $3,000. The Productivity Commission found just last week it costs $3,300 a day to house one of these children. Can you imagine? You could put them up at the Hilton in Perth for that amount, but because there isn't bail housing in WA, or there's no one that can receive these children, they are going into prison at a cost of over $1 million a year. Surely we can do better than that. You ask why not? I think there's probably two reasons. First of all, in WA, they don't want to spend the money on alternative solutions and supports for children to divert them away from the prison system and the youth detention system. Yes, it costs money, but when you work out $3,000 a day to have them in there, there's got to be a saving to the community by diverting children. It was one of the recommendations of the Royal Commission into Aboriginal deaths in custody, and we must see more of that. And also, before he retired or resigned, the former Premier of WA, just in the weeks before he retired, described these children as hardened criminals. There is a prejudiced attitude over in WA about these children. They need support, they need diversion, they need housing, they need healthcare and education, not punishment. So I think there's a punish now attitude, and they're not listening.
But, I mean, it isn't as though this was unobserved. In this case, the Supreme Court, I think, when it comes to Banksia Hill and Unit 19, there was a finding in the middle of 2023 by the WA Supreme Court that 3 children at Banksia Hill and Unit 18 were subjected to a total of 167 days of unlawful solitary confinement. Mm-hmm. And that was just that 3-month period they looked at between September and December 2022. And one child was held in solitary confinement for 133 days. There was an injunction granted to try and prevent that from happening. But the WA government largely has ignored the Supreme Court. Banksia Hill and Unit 19 continue. Solitary detention is still being used. This lack of accountability is one of the extreme case studies, isn't it?
Yes. Look, I can actually speak from experience. I ran a case against the movement of children into an adult prison in 2012 in WA, and the Supreme Court there were reluctant to interfere because there was no other place in WA that they said that children could go. So I've been fighting this fight for over a decade. You also mentioned children being locked up for 167 days. I'm fighting for 2 children that were locked up for 365 days in solitary confinement. The government of Western Australia has been fighting for 5 years. They're using every tactic in the book to delay. They do not want the public. This is part of the total institution. They don't want the public to know what happened to these children, and they will fight tooth and nail to defend themselves. But a Supreme Court judge, as you rightly pointed out, has already found that method of holding children in solitary unlawful. They will lose in the end, but they will fight for years to hide the horrors of what's going on in that institution.
So when we have a state government, in this case, not even complying with its own laws, being found to be in breach by its own Supreme Court, and then ignoring the rulings of the court, maintaining these abusive institutions, do we just at a Commonwealth level say, oh, well, it's a state matter, we'll leave it to the states? Because that's what the Attorney-General's submission says. Oh, well, it's a state matter. That seems to me to be a betrayal of WA kids, which are Australian kids as much as they're WA kids. Doctor, do you have a view on that?
I think it comes down to, and there's been a lot of analogy used around glue, and what is this glue to hold X and Y together, or to improve child protection, or to improve youth justice. What is that glue? I think it really does come down to the accessibility and assistance in accessing funding for community organisations, assessment groups, whether that be for what we talked about in terms of accessing these institutions when on remand, funding to that in a longevity of that to allow communities to assist their young people and to assist themselves. Again, in terms of the glue and the evidence should be from communities. There's an incredible example of within child protection around the Menaditja care model, a community caring for their young people in child protection. That's a research project that's come through Jumbunna that has been incredibly well received. Additionally, in terms of what's happening in other jurisdictions, the ability to engage or to have engagement with detention centres and the ability to access them by community, they are seen to be in and of themselves, which again is unapproachable, not able to engage or access the young people of what's actually happening. Why that is needs to be addressed. And it needs to be understood around how to go about the access and understanding. So I think the idea of the glue, it is coming from communities and having that funding over a period of time rather than a 4-year cycle. And I think there has to be some accountability, as you say. So, you look at the end of last year with other jurisdictions and what was happening in terms of within politics or the political realm. You have this media hysteria around young people. You have this understanding that people or communities are not safe. You're talking about the increase in stolen cars, assaults. They're increasing by, 282%. However, what's actually happening for those young people? What's happening for the funding within those communities to allow those young people to not possibly commit or be a part of because of boredom or necessity? What's happening with that? So there's not a lot spoken about either side. I think there needs to be the accountability as to if someone's going to say something for a political purpose, what's happening on the other end. And in terms of the racialising, then it does come down to either black or brown or youth gains is the wording that would be used. And why are they allowed to put this out there with little retort from those young people or communities who they're focusing that on?
Well, talking about the lack of accountability, I'll go back to just this one abusive institution, two, Banksia and Unit 18. 3 months after the Supreme Court handed down its decision about torture-like conditions in those institutions, we had the tragic death of Cleveland Dodd, who took his life in a prison cell, a badly damaged, inappropriate prison cell in Unit 18. 3 months after the Supreme Court handed down its rulings, which the state government did nothing to implement, we then have the tragic loss of Cleveland Dodd's life, obscenely foreseeable that those circumstances would lead to that kind of loss. And then 9 months later, after a behind closed doors investigation by the state's Corruption and Crime Commission, they hand down a report saying nothing to see here. No recommendations, nothing to see here into Cleveland Dodd's death, tragic death. Is that the definition of a total institution, Professor Newhouse? Is that kind of one in action?
Yep. It's a protection racket. Unfortunately, the systems that... and Dr. Bofus wants to answer this too, but I'll just answer your question. All the systems within the state are designed to protect that institution. That is a total institution. And the government are free to get away with it. I'll hand over to you, Doctor. You've had your hand up.
Yeah, no, thank you. I think, as you said, in terms of federal government, how they should sit, it should always be the role for the federal government in their matters. this is a federal government that signs up to human rights instruments that are actively or available to be used. If the states aren't complying, then yes, the federal government should exert any influence it can to ensure these states and territories are complying with their human rights responsibilities. And it was said quite well from the National Children's Commissioner, Anne Hollands, in terms of if they're not addressing them, then what is actually happening in terms of the Help Way Earlier project?
If we were going to look for a blueprint to fix this broken federal model where kids just keep falling through the cracks between states and territories and the Commonwealth, is that where we look for a blueprint, the Help Way Earlier, Doctor?
I think it's quite hard when someone's looking for a blueprint or when someone's going to look for glue. I mean, it's very difficult to, if I was to provide you with a blueprint, your interpretation from your own standpoint. I think it does come down to these communities and their ability to understand and be actively, but also drivers or self-determining of what's happening within this. I mean, there are, and people keep saying, and we have heard that there is evidence and research. However, if we look critically at it, that evidence and research or blueprint construction or glue manufacturing is not coming from our communities who are the people who are under-resourced and underfunded and underserved.
Well, pretty much all the recommendations say fund, invest in and empower those communities. Don't impose your solution and get the community to implement it, but fund, invest and empower in those communities themselves. Is that a way of looking at the glue?
It could be. And, you know, I think in terms of what Ms Gordon was saying previously and how things in terms of evidence and research and things should be happening, you know, we've had 200 odd years of colonialism and it's not working. So things do take time, and being understanding of that within the communities and allowing that slow going if necessary. You know, the situation really can't get much worse, but it probably will if we continue on this trajectory.
Well, it turns out that some things don't take time. Queensland rushed through an aggressive patch of laws that wound back children's rights. They suspended their own Human Rights Act. They did that in a matter of weeks. That didn't take time. Doesn't take time to take away kids' rights or to put kids in prison, yet it always seems to take decades to try and do the opposite. Should we be learning from our opponents in this regard and demanding rapid action?
I see where you're going, and I completely agree in terms of, you know, within New South Wales, in terms of guardianship orders, they got pushed through at a rapid rate, and I know you were one of the persons that did stand to that in terms of the guardianship, yet that went through quite swiftly. However, we're looking at interest. We're not looking at First Nations interest in either of those examples that you're talking about, whether it be Queensland or whether it be New South Wales. So how is this to act swiftly? You know, I do put it to having people like Little sitting on this at the moment and engaging and having access for First Nations communities at senior levels to have the say and to be heard and to come from communities and talk about experience and be funded and invested for that.
Well, I mean, just last year we had this theatre that illustrates how little states and territories are willing to listen, even to voices they established in Queensland. Literally, as the Queensland Parliament was passing its laws, suspending the Human Rights Act, reversing presumptions for bail against kids, putting in place that suite of packages that has led to more First Nations kids going into jail, literally at the same time, we had the Eric D. Rule Youth Parliament, 42 First Nations kids in the adjoining chamber debating what they saw as a youth justice package of reforms that would actually work and coming up with their own answers. And at the exact same time, the Queensland government legislated the total opposite package in the chamber next door. I suppose, Professor and Doctor, you know, when you have the answers being given in one chamber and then the exact opposite being done right next door, how can we trust state and territory governments?
Well, you raise a good point. And the state and territory governments are failing children, but they're particularly failing First Nations children. And maybe it is time for the federal government to use their powers, either the race power or the treaty's power. You know, we're signed up to the Convention of the Rights of the Child to actually pass laws to set minimum standards, to engage with local communities and save these children from the abuse that they're experiencing. It's just appalling. They know what there's, as you heard Auntie Pat say, there's evidence-based solutions, but they are being ignored for Get Tough on Crime.
Senator Shibridge, I've got a few questions. We're right at the end of our time.
I'd put Auntie Pat in charge, by the way, just for the record. But,
okay, thank you. Professor Newhouse, you mentioned in relation to fetal alcohol syndrome disorder, one particular agency that didn't want to send someone to a FASD assessment because it would cost $8,000 and that child was on remand. Can you just, who was that? Which agency was that? And what's the thinking? What's the twisted thinking that leads to that?
That was evidence that it's freely available to the Royal Commission into people with disabilities.
Right.
It was I think it was the superintendent of Banksia Hill Prison. So he would be employed by the Department of Corrective Services in WA. And they were saying, I don't know whether it was financial. I think their constraints were financial and also temporal. Oh, we've only got these kids for a short time. It's not worth it, was essentially the nub of the evidence. And the Royal Commission was quite critical of that too. But it was interesting to hear it vocalised. So that was evidence given to the Royal Commission.
Because isn't it I would have thought if you have the opportunity to undertake perhaps not even just a FASD assessment, but a holistic assessment of someone's health, both mental and physical, to look at the family unit and see what's happening there, you should take advantage of that at the first opportunity. That's what common sense would indicate to me.
Me too, Senator. But look, there is one thing that I'd like you to understand. I see Mr McIntyre speaking next. Mr McIntyre's a barrister who's represented many First Nations families at inquests. When we look at what happens to children after they die in custody, you realise how shockingly appalling the level of care is. On any day, there is a risk assessment about whether that child is going to kill themselves. And if they're not going to kill themselves, they're left to their own devices. There is really no ongoing assessment, therapeutic care, all the things that you were just talking about. Let's look at their home environment. Let's look at their education. Dr. Bofus raised that. Let's look at their situation, try and understand it, and support them when they leave. None of that happens. And yet we spend $3,000 a day on them.
Well, I was $3,300 a day, I think he said, was the latest figures, which aggregates to approximately 1.2 million a year for each child in detention. And that's only part of the equation, isn't it? I mean, each human being has their own innate value as a human being, their own potential to be realised, but also the difference between having a productive member of society from a society point of view who's developed skills, contributing to society, raising their own family in a safe environment. The 1.2 million a year is only part of the equation, isn't it?
That's right. And look, the statistics, the evidence shows that providing that level of support, particularly post-release, can reduce recidivism by 60%.
Yeah.
We need to support these young people. They are our future, and we're not. We're failing them. They come out worse than they go in, and the impact is multi-generational.
And my last question is just on this issue of remand. What are the driving factors behind that? Is one that the justice system itself is under-resourced, or what are the driving factors behind, in particular, children spending such long periods in remand?
I have some, but Doctor, do you want to answer that first, or?
I just think on that as well. Children aren't being properly assessed within these institutions as well, whether that be out-of-home care or juvenile justice. They're scrambling to get these assessments done. However, if communities were available and assisted too within their own resourcing and by their own people to have these done and provide these and engage with these services, this may have been mitigated. However, it's not happening and the children are already in crisis. And so when it is coming to the remand, it's a number of issues and a number of reasons. A lot can stem from bail law reforms or lack of information within and of those young people. So we're not doing the work and we're not triaging once it's at that critical point. We're holding, and they are holding positions for our people that aren't receiving the support necessary.
Yeah, I'll just agree with that. The bail laws are shifting the burden onto the children so that it's more difficult to get bail. Second of all, lack of housing, lack of bail hostels, lack of places for these children to go to is an issue.
Okay, understood. Okay, thank you very much for your evidence, and thank you for all the work you do. It's greatly appreciated.
Thanks, Senator.
We'll see you next time. Okay.
Yeah, we'll fix it in the meantime.
I now welcome representatives from the Law Council of Australia via video conference. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, I'll ask each witness to please state their full name and the capacity in which they appear. And we'll start with you, Mr. McAvoy.
Thank you. My name is Tony McAvoy. I'm a barrister, senior counsel at New South Wales Bar, and I appear as the chair of the Indigenous Legal Issues Committee of the Law Council of Australia.
Excellent. Thank you. Mr. McIntyre.
Yes, my name is Greg McIntyre, and I'm appearing today in my capacity as the Law Council's a member of the Law Council's National Human Rights Committee and its Indigenous Legal Issues Committee.
We're used to seeing you in your previous capacity, Mr. McIntyre, so thank you for all the work you did as President too.
Thank you.
Dr. Fletcher.
Yes, hello, my name's Adam Fletcher and I'm a senior policy lawyer in the Law Council Secretariat.
Thank you. Mr. McAvoy, do you have an opening statement?
Thank you. That will be Mr. McIntyre.
Mr. McIntyre.
Yes. So if I can do that opening statement, the Law Council acknowledges the traditional custodians of country throughout Australia and their connections to land, sea and community. We pay our respects to their elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples participating in this hearing today. In the context of the present inquiry, this acknowledgement is particularly relevant. The overrepresentation of First Nations children in detention in this country is a cause for national shame. The Law Council has been a strong and consistent advocate for reform in the youth or child justice space for many years. Time and time again, we hear of justice systems in every state and territory failing our most vulnerable children, even fatally in the worst cases. We acknowledge that children can and do commit crimes. We do not in any way wish to minimise the effects of those crimes on victims. However, evidence-based policy responses are sadly lacking, which means we'll continue to experience a repetitive cycle of crackdowns that are only limited or temporary effect in reducing or preventing children's offending. As the Attorney-General's Department's submission to this inquiry notes, criminal justice is primarily the responsibility of the states and territories, but the very existence of this inquiry speaks to the need for national action and coordination on child justice. There are several common denominators between jurisdictions, including tough on crime policies purporting to promote community safety that underpin the approach of the nation as a whole to criminalising and punishing the behaviour of children. We also argue that jurisdictions need to work together to implement Australia's international obligations. Prevention, early intervention and diversion responses rely upon a whole of government system design occurring well before the criminal justice system. Multiple jurisdictions and portfolios need to be engaged. The National Children's Commissioner Anne Holland has observed in her recent compelling report, held way earlier, that Australia has international obligations, including under the Convention on the Rights of the Child to all under 18s. That treaty, to which Australia has been a party for more than 30 years, requires us to formulate policies that affect children with special safeguards and care in accordance with the child's best interests. It also stipulates that detention should only be used as a last resort for children. These principles, amply demonstrated by the Commissioner's report, are not being respected in most Australian jurisdictions today. As set out in our written submission, there are criminal justice policies and practices across the nation that are leading and may lead to outcomes that are inconsistent with Australia's international human rights obligations and undermine the fundamental rule of law principles, including presumptions against bail for children and young offenders, extension to children of serious offences, including national security offences, attracting penalties of extended terms of imprisonment, inappropriately low minimum ages of criminal responsibility, detention of children in adult facilities, including watch houses and maximum security facilities, and solitary confinement of children for 20 more hours per day. We make several recommendations in our written submission, which we commend to you, but key among them are that the Commonwealth, State and Territory governments implement the recommendations of the National Children's Commissioner's Helpway earlier report, especially the overarching recommendations for a national task force, a Cabinet Minister for Children, a Ministerial Council for Child Wellbeing reporting to National Cabinet, and the implementation of treaty obligations concerning children into domestic law. Child detention in Australia be reformed according to expert evidence and therapeutic jurisprudence principles. The recently announced National Commission for Aboriginal and Torres Strait Islander Children and Young People should be empowered and adequately funded to fulfil its mission, protecting the rights of First Nations children, and First Nations leaders must be afforded a clear and authoritative voice in this process. The minimum age of criminal responsibility should be raised to 14 across the country, in line with international standards and previous Law Council recommendations. The Commonwealth should take the lead in implementing Australia's commitments under the optional protocol to the Convention Against Torture by fostering and contributing to the Intergovernmental Agreement on Funding with States and Territories in relation to a national preventative mechanism. Having said all that, the Law Council appreciates the opportunity to work with the Parliament on this inquiry and would be pleased to respond to any questions which the committee may have.
Thank you very much. Senator Shoebridge.
Thanks all of you for your ongoing work in the space, and I also wanted to acknowledge your work in your previous capacity, Ms McIntyre. But one of the things that your report, your submission addresses is Australia failing to implement measures that would live up to our commitments, particularly under Article 37 of the CRC. And that would be our international obligations to prevent children being tortured, to prevent arbitrary detention, and also to ensure that detention is used as a last resort. Do any of you want to sort of talk to that international commitment that's been honoured in the breach?
Yes, well, I mean, it's very clear, particularly with recent amendments to legislation and announced positions of the Northern Territory government that they are just not even recognising that those obligations exist. It therefore means that the Commonwealth has to do some more to ensure that states and territories do comply with obligations which the Commonwealth has undertaken on behalf of the whole community.
Well, it's not just the Northern Territory, of course. We saw New South Wales amend its bail laws to remove the presumption for bail for kids. We've seen Queensland do some quite radical changes, removing a bunch of fundamental rights for children in that jurisdiction. There are now multiple states and territories that have been aggressively legislating in breach of our international obligations. So what should the Commonwealth do?
Well, it should set up a national task force, as Commissioner Holland's suggested, and engage with the states and territories. I mean, if they don't seem to understand their obligations, and the Commonwealth has an obligation to deal with that. I mean, ultimately, the Commonwealth has constitutional power to override the way in which the states and territories are dealing with these matters, effectively under its external affairs power, having signed up to the Convention on the Rights of Children and the other international conventions on civil and political rights. The Commonwealth has an obligation to ensure that those conventions are complied with. And it's not popular for the Commonwealth to intervene with states and territories. And so, obviously, in a diplomatic way in a federal structure, you would start, I suppose, attempting to encourage and educate the states and territories about the obligations which the Commonwealth has, and they, as part of the Commonwealth, have. And if education fails, then you do have legislative options.
Well, but that...
If I might, Senator
Schubert, please do.
Sorry. I'd just also add that the Law Council has constituent bodies in each of these states and territories, and part of their role has been to remind governments, most recently NT and Queensland governments, about their international obligations. If you have a look at the media releases of the Law Society of the NT and the Queensland Law Society, they have been quite active in this space, commenting on the recent amendments, which, for example, lower the minimum age. So that's a process that works at multiple levels. The Law Council is mindful of the need to work at the state level and the Commonwealth level so that solutions can be found working together.
Well, I know in my home jurisdiction of New South Wales, the New South Wales Bar Association, the Law Society, inevitably points out these international obligations to the states, but they just get ignored, and that they were ignored as recently in my home state as May of last year, when, despite being told that it was in breach of international obligations, the New South Wales Parliament legislated to remove bail rights for kids. And in fact, my memory is if you read the Queensland legislation, they contained a statement about whether or not it was compatible with human rights. And there's a long list in the Queensland government's own statement about breaches of human rights. And at the end of it, there's a statement saying, we're going to do it anyhow.
The only other advocacy approach we can take is and I see that most of those who've appeared before you and the submissions they've made have been making this point, that it's actually cheaper and more effective to do it the other way around. And I don't know what else we can do to convince these various state and territory governments that is the case. I should say, of course, when I'm speaking of territories, the ACT does seem to be adopting a more appropriate approach. But as you pointed out, I only used the one example, but Queensland, the Northern Territory, even Victoria has decided that its current government is likely to reduce the age of criminal responsibility. So we're faced with a multitude of different states adopting measures which are inconsistent with our international obligations.
Mr McAvoy, as chair of the Indigenous Legal Issues Committee, I know for a fact you've been observing, and not just in the criminal justice space, but in other spaces, a bunch of state and territory laws that are inconsistent with Australia's international obligations, particularly for First Nations rights. Do you see a way in which the Commonwealth could use its levers to sort of bring the states and territories in line?
Thank you, Senator. I would say that there are a number of ways in which the Commonwealth might respond, and I should preface that those comments by saying, having been an advocate in this space since my early days as an article clerk in Brisbane in the 1980s, and going through the Royal Commission process and seeing members of my community die in prison, and then having been involved in the Dondale Royal Commission, these problems are not new. And the Commonwealth is now in a position where states appear to be openly abandoning our country's international human rights obligations. And it seems to me that unless there is some Commonwealth action, that will continue to be the case. So it's not a question of whether the Commonwealth should act, it's what it should do. And the Commonwealth has a range of portfolio responsibilities. On top of the external affairs powers, it has responsibilities with respect to remote housing and health and education and training and employment. And we know from the various royal commissions and inquiries that have been undertaken, and some that I've been involved in, that we have to address all of these issues. It can't be simply putting a different band-aid at the tail end of it after the wound's been created. And so the recommendation from the Australian, the National Commission for Children, as to the need for a national task force, I think is appropriate in that it needs a collective cross-portfolio, multidisciplinary approach if people are serious about this. The Commonwealth could legislate. The Commonwealth could legislate. The Commonwealth could develop policy. The Commonwealth could direct funding towards activities which promote and facilitate observation of Australia's international human rights obligations. There are many things that the Commonwealth could do, and I don't know that there needs to be a lengthy delay. Everybody here, everybody that's appeared before this commission of this inquiry has given evidence and submissions and been through this many times and said the same things. We know that it has to be community based, that it has to be family oriented, and unless there is some, it seems to me, unless there is some Commonwealth intervention, nothing's going to change.
Well, see, this is the first time that I'm aware of where there's been a specific spotlight being put on what the Commonwealth is or isn't doing and what the Commonwealth should or shouldn't do. We've had, as you point out, royal commissions, investigations at a state level repeatedly. Often their recommendations are ignored. This is the first time we've just squarely put the spotlight on the Commonwealth, and from my observations, from what we've seen from the submissions and the witnesses, It's showing the Commonwealth pretty much asleep at the wheel, or even just not in the vehicle, even though they've got an obligation there.
With respect, Senator, the Dondale Royal Commission was a Royal Commission commissioned by the Commonwealth Government. And there were recommendations directed to the Commonwealth Government. There was also an inquiry under the Inquiries Act in the Northern Territory, so it was jointly commissioned. But it's not the case that this Commonwealth has not been put on notice that there are international obligations that are likely to and were being breached. And that was in 2017, so that's 7 years ago.
Well, so let's reflect upon the Dondale Royal Commission. Dondale's still operating. It's still abusing kids' rights. It's still a notorious institution, and indeed more kids are now being sent there because of what the Northern Territory government has recently legislated. You're involved in that Royal Commission. How do you look back on the 7 years of political action at a federal level? You've gone back on mute.
You're on mute.
My apologies. What I can say is from discussing the recent regression, if I can put it that way, with my colleagues who work in this space all the time, is that we wonder whether there is going to be any change that makes a difference, or whether we are consigning a generation of young Aboriginal and Torres Strait Islander people to a life in the criminal justice system.
You see, sorry, you go, Tony.
Sorry.
You see, even if what the Commonwealth had done 7 years ago was legislate and say, well, it's a horror show what's happening in Dondale, it's terrible what's happening to First Nations kids, we'll just pass a law that, even if it doesn't fix things, even if they just said no state or territory can make things worse. Like if the Commonwealth just passed a law and said you can only ratchet one way, you can't make things worse. And that would put an institutional pressure to only ratchet in a way that enhances and promotes kids' rights. That'd be some kind of fail-safe in it, wouldn't it?
I think it would be. It's not something that I've considered, but answering you now, I think it would be. The reality is, as we know, that fear sells newspapers, and Aboriginal people and Torres Strait Islander people are the fodder for that.
Senator, if I could just add to that, I mean, it's one thing to declare something in legislation, it's another thing to actually make it happen. And the Commonwealth would have to then follow that up with appropriate funding. I mean, you can just hear a territory or state government saying, well, you've told us we have to do this, but how are we going to do it? We need Commonwealth backup. Now, the Commonwealth, I mean, I see that the Attorney General's Department are suggesting, oh, well, it's a state and territory matter. The Commonwealth has had no hesitation and appropriately going into dealing with domestic violence at a national level, dealing with health, dealing with education, dealing with medical assistance, all of those things. You don't see a specific paragraph in Section 51 which gives the Commonwealth that power, but it has found ways of acting as a national legislature and a national government in taking responsibility for those matters which are of national significance. It can do it, and it needs to do it both with these appropriate declarations and the resources.
Yeah, I'm reminded that, in fact, Dondale's now only taking adults, and the Northern Territory government is investing money in yet another child prison in Darwin, apart from Dondale. Sorry,
Senator. I might just say that one of the recommendations from the Dondale report was that there not be a warehouse-style youth detention centre created, and that the appropriate ways of dealing with young people was to have small-scale, community-controlled, secure facilities where they were needed. Because one of the great tragedies in the Northern Territory is people for whom English is only a second language being removed from country and being placed in a large facility in Darwin or Alice Springs causes greater isolation and the other problems that you've heard about. So that the decision to build a large facility was in breach of or non-compliant with the recommendations of Dondale anyway. And then we also have the advances, limited as they were, that have come in recent years in the Northern Territory with the proposals to raise the minimum age of criminal responsibility and the removal of mandatory sentencing and the winding back of those advances with the present government.
Yep, sorry, Chair.
I just had a number of particular questions, but in the first instance, could I ask you to take on notice to review the submission from the Attorney General's Department? And Mr McIntyre, you made some comments with respect to some of the statements. I think you're referring to some of the statements in that submission, but it would be useful from my perspective as Chair of the Committee to have something formal in terms of responding to the issues raised by the Attorney General's Department. That'd be very useful. Is that something you could do?
Yes, we noted that from your comments earlier during the day to other witnesses, and we have already that in mind, that we'll do that by the deadline that you've set. Yes.
Excellent, thank you.
Senator Scott, might I just add that this issue of what might be appropriate in terms of Commonwealth legislative intervention is something we'd also like to consider further and take on notice if possible, the matter that Senator Schubert raised.
Absolutely happy for you to take that on notice, and in that context, you might well have noticed I've asked some of the other witnesses to comment on Section D of your submission, where you refer to this responsibility dilemma in the context where a federal government enters into international treaty obligations, but the individual states are the ones with, in many cases, jurisdiction over the area which is the subject of the treaty, and how to resolve those issues. So anything you want to add in that regard in terms of your response would be most useful. I'll take you to a few... Oh, sorry, go on.
Just very quickly on that.
Anything else you want me to ask you to take on notice?
One clear policy that we do have, and this is not taking something further on notice at this point, is just that the Law Council supports a federal human rights charter, and the introduction of a Human Rights Act would be one concrete way in which the Commonwealth could move forward on the implementation of its international obligations and show leadership.
Yep, understood.
One of the other things which we will take on notice, we've done a little bit of research since our written submission on the costs of incarceration and detention, and so we can probably provide you with a summary of that material. I noticed that's come up as one of the topics you've had with other witnesses.
Absolutely, very important topic. Paragraph 20 refers to the new facility which is quoted as being state-of-the-art security features being constructed in the Northern Territory. And I quote, despite the 1994 Royal Commission into Aboriginal deaths in custody recommending 32 years ago that padded cells cease to be used for at-risk people in custodial settings, the new facility comes with a 3 by 2 metre room with padded walls called a, quote, low stimulation room, end quote. How can it be that 30 years ago we've had a Royal Commission in particular looking at the best practice for a facility, and 3 decades later a facility is being proposed which contains elements which were specifically the subject of a recommendation to the contrary in a Royal Commission. What's driving that? That's something which people may not be aware generally of the existence of that particular sort of room, if you like. So what's driving that methodology, if you like? So 3 decades later, still that concept of a 3 by 2 metre room with padded walls called a low stimulation room. Do you have any insight? Do any of the witnesses have any insight into that?
Not really, but what I can add is that one of the other recommendations, that there be no ligature points in any cell, has not yet been complied with. I mean, one of the tragic deaths in a juvenile detention centre in Western Australia was as a result of a ligature point in a cell. So they haven't. I mean, I would have thought that was even more obvious as a recommendation from that Royal Commission. That doesn't seem to have been able to be comprehensively dealt with this many years later. So it's probably in that same context. I don't know, but you'd think that somebody, an architect, and on instructions from a government department, have decided to put a padded cell into this institution. And I don't know, maybe they don't read Royal Commissions or short-term memories, short-term governments.
Mr McAvoy, do you have any insight into that?
No, I'm sorry, Chair.
No, okay. Okay, I'll move to another paragraph of the report or your submission that really stood out to me, and this actually dovetails with something that Professor Newhouse raised in the previous panel, in relation to research conducted in Western Australia's only youth detention centre at the time, Banksia Hill, found that 9 out of 10 people in Western Australian youth detention were severely impaired in at least one area of brain function, including memory, language, attention and executive function. That research also found that 1 in 3 young people assessed had fetal alcohol spectrum disorder, which is a lifelong and severe disorder of brain development that occurs as a result of exposure to alcohol in the womb, end quote. So that was in 2018. We're now in 2025. Are you aware of anything that was done to try and increase therapeutic assistance being provided to young people in detention at the youth centre to, I guess in the first instance, just try and obtain a holistic assessment as to the young person's health, mental and physical, as a matter of priority?
I can probably provide some light on that. I mean, we know that it even went further backwards in Western Australia in that Banksia Hill Detention Centre, where for a number of years, as I think I heard you asking one of the witnesses earlier about the solitary confinement which was going on in that detention centre. The government said due to lack of staffing and riots which occurred and a range of other factors. So it certainly went backwards for a long time. I was involved in a meeting with the Department of Communities and the Department of Justice and the Department of Corrections of Western Australia in the last 2 months, and they were telling us that they have tried to turn around that they do now have adequate staffing, and that they are trying to adopt a more educational therapeutic approach where the children in detention in that facility at least now do have some education happening and they're not being kept in solitary confinement. But they still haven't really got to the bottom of the problem that you pointed out, Senator, of adequate medical assessment. I think that the current administration do have an intention to deal with that. I'm just not sure that they've actually got there.
Okay, thank you. Paragraph 70, you refer to, I'll quote, since its establishment in 2021, this is in relation to the Justice Policy Partnership, the Law Council has received disappointing feedback from First Nations legal and justice experts who participate in the JPP, who say that it is not being effectively used by state and territory government participants and that there has been a real lack of broader commitment to changing how government operates in this area. And then the last sentence of that paragraph, feedback provided to us, however, is that the JPP is not operating the way envisaged when it first came to fruition as a lever for open dialogue and evidence-based change, end quote. I understand the thrust of the argument when one looks at the legal situation and recent legal amendments in this space in a number of states and territories. Is there anything else that is troubling legal and justice experts with respect to the operation of this Justice Policy Partnership? It's mechanics. Is it not meeting often enough? Is it not getting high level enough buy-in? I'm just wondering if you can give a better, also expand on the observation that's made there. And happy for you to take that on notice if you want to.
I think we'll take it on notice unless any other participant had anything to add.
I might thanks, Greg. I might just say that anecdotally, because none of us are on that committee, Chair.
Okay.
But anecdotally, the observations of the Productivity Commission in terms of commitment to the notions of the targets and commitment to taking action appear to be lacking in many respects, and that the complaints that I'm aware of are that they, in particular, that the JPP meetings will occur, and there will be policy and legislative developments in the wings with some of the JPP participants from the states and territories, but they're not disclosed or discussed, and then there's an announcement the next day of some new piece of law or some new piece of policy. So it's not performing the function that it's intended to perform, which is one where the policy is developed according to some national framework.
Got it. That's very useful evidence. Thank you, Mr McAvoy. I'll now go to paragraph 99. The Law Council's constituent bodies have informed us that legal practitioners have witnessed some recent examples of non-compliant detention incarceration practices, the most troubling of which include, and then there's a list of 3 examples, and I just want to drill down into these three examples. Feel free, if you wish to take on notice, providing further information in relation to these examples for whatever reason. I don't want to put you in a difficult position, but I found some of the examples, well, the examples are troubling, to be frank. The first one, a child in adult custody who'd been subject to truly appalling human rights abuses, having had a spit hood placed on him, was placed in solitary confinement for an extended duration and had the water to his cell cut off, end quote. And the way I read that, it's almost suggesting that the water to the cell was cut off as a punishment or as some means of trying to bring about a change in behaviour or whatever it is. So I was interested in any further details you could provide in relation to that example as to jurisdiction, how recent it was, and what the thinking was behind the water to the cell being cut off.
Adam, are we able to say anything about the detail at the moment or not?
Look, no, we are going to have to seek to get further detail on that and take it on notice, I'm afraid, Senator. But I would just say in this context that the optional protocol to the Convention Against Torture, which is the focus of one of our recommendations with its national preventive mechanism that is supposed to be fully established by now in every state and territory, is directly aimed at maintaining minimum standards in places of detention, including for children, but not just for children. And reports of these, the monitoring mechanisms under the OPCAT, they detail lapses in standards, things that don't meet minimum standards, these sorts of things. I mean, I've done OPCAT work in other countries and seen examples time and again of monitoring mechanisms uncovering issues like these, which we just shouldn't be seeing, especially in a country like Australia. But on these specific examples, I'm going to have to seek further details from the relevant constituent body, I'm afraid.
Okay. The next one, and I'll just go through each of these because I think it's important to put it on the record. A young boy whose psychological needs went unaddressed in youth detention when he was actively self-harming and suicidal because treatment in custody is not confidential in the same way as it is for children in the community, end quote. So I was trying to get a understanding as to the reason, the connection between the lack of treatment and the lack of confidentiality.
Yeah, we'll take that on notice. Thanks,
okay.
Senator.
And then the last one, and I note in this context we have the Disability Discrimination Commissioner appearing in a subsequent panel. I'll quote, "A young boy who has a severe intellectual disability and was placed in a unit alone in custody, preventing him from being able to properly engage with his lawyer, treatment and education," end quote. Now, it would have appeared to me that the obligations with respect to a young person in detention with severe intellectual disability are heightened in terms of mobilisation of resources and services. But this would indicate to me that we have a perverse situation where it's to the contrary. Can you provide any further information in that regard?
Again, I think it's a matter for a supplementary submission.
I would just say, although these specific cases will have to provide further information and notice, that it points to something that pretty much has been said in every session of this hearing, which is that coordination between portfolios with Commonwealth leadership. We're focusing on the AGD submission because it's the leading submission from a Commonwealth agency to this inquiry, but the Attorney General's department only do so much. There are other departments, as Mr. McIntyre mentioned earlier in our evidence, that need to be involved in the coordination in health, education, and show Commonwealth leadership so that these cases where, for example, there's overrepresentation of persons with disabilities in these custodial settings, need to be addressed not only by justice authorities, but also by coordinated health authorities.
Okay, thank you. That's all the questions I have. Senator Liddell has a number of questions.
Thank you. I've just got one question. I've asked a few people in recent times who've had to go away and think about an answer, so you might want to put this on notice. But people who are legal representatives acting in the obviously best legal interests of a person in custody, whether it be an adult or a child, I've been told that where there is access to behaviour change programs for people who are currently in custodial settings, they're encouraged not to participate because of fear of potential for guilt, like assumptions of guilt. And I'm just interested in where there might be an opportunity to remove that roadblock, given that particularly in custodial settings like the Northern Territory, children and adults are in custody quite often for domestic and family violence related incidents, whether they are a victim survivor, a perpetrator or a witness or all of those things. And I'm just interested in, from a legal perspective, what might remove that roadblock? So whether somebody's on remand or they're actually have been sentenced, there is potential for them to participate in that process for the greater good when they're no longer in a custodial setting.
My understanding is that those on remand don't have the benefit of those sorts of programs in any event because they're on remand. And so if that is generally the situation, then that dilemma doesn't, in a sense, arise because they're not going to incriminate themselves prior to any determination of the result. Is that consistent with your understanding, Tony?
Yes, there was a significant amount of evidence about that particular issue in the Don Dale Royal Commission as well. I should also say that there have been numerous inquiries conducted by states and territories following on from the Don Dale inquiry about youth justice inadequacies, and a lot of that evidence can be found in those reports too, I believe.
So from your perspective, it's not a legal issue, it's more a access to those resources or where they are in that legal process?
It may be the case that the view amongst the detainees is that they can't trust the people that they're working with, and they're reluctant to engage with health or allied health services and say anything because they fear that it's all part of the system and it might be involved, might somehow affect their outcome. But my experience is that they just don't get access to that, and the high number of people who are remanded in custody speaks to that. And I think once people are out of custody, they don't want to have anything to do with the system.
Sorry, Senator Little, if I might just add, draw attention to our recommendation that presumptions against bail, in a number of jurisdictions have increasingly in recent years, but not just in recent years, led to overuse of remand around the country, which puts people in this position you're describing, whereas especially for persons under 14, the Law Council recommends that the minimum age for even being involved in the criminal justice system be 14, and that younger children be diverted, and that older children have the opportunity to be diverted if that's a more appropriate path, and that lowering the use of remand would put fewer people in the position where they feel they can't access these services.
I should add, Senator, as well, that we know that a very high proportion of the youth detainees have neurocognitive development issues, FASD, early childhood trauma, trauma-related post-traumatic stress disorders, and those disorders may contribute significantly to their willingness to talk to people.
Thank you.
Thank you very much. Deputy Chair, did you have anything else you wanted to put on notice? Or
My question was about the presumption against bail. Perhaps I'll put on notice some more detailed questions about that and the Law Council's position and I guess the impact which you've gone to in some detail, but that would be better to get on the record. And the other questions I'll put on notice as well, just conscious of time, Chair.
Thank you, Deputy Chair. And if I can just put one more question on notice as well, and that is if you could expand on paragraph 19, you might well have already you've looked at this in different contexts, so if you could just provide us anything you've previously provided. That's the operation of the rebuttable legal presumption known as Dolly Incapax. That would be interesting just to understand how that works in practice, how that's working in practice in our courts at the moment in the context of assessing capacity.
We refer to a policy that we have with the AMA from 2019 on the minimum age of criminal responsibility, and that policy and its quite detailed addendum have information on how Dolly Incapax operates and why we consider it to be, a less desirable solution than actually raising the age.
So apologies if you've already sent that through, but if you haven't, if you could just flick that to us,
sure.
That would be very useful. So as always, thank you to the Law Council of Australia for taking the time to give evidence today. Very good to see you again, Mr McIntyre, and thanks for taking on notice those questions. Greatly appreciated. Thank you very much.
Thank you. Thank you, Chair.
Thank you.
I now welcome representatives from National Legal Aid via video conference and from NATSLs also via video conference. So I'll just... Okay. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, could I ask each of you to please state your full name and the capacity in which you appear? And we might start with National Legal Aid if we can. And I've got, as my first witness, I've got Ms Lumsden.
Thank you, Chair and Senators. My name is Anne-Marie Lumsden. I'm a Director of National Legal Aid and also the CEO of Legal Services South Australia.
Excellent. Thank you very much. Mr Espy?
Thank you. Yes, my name is Nick Espy. I'm the Associate Director of Legal Services at Legal Aid Northern Territory, also a member of the National Legal Aid's First Nations Advisory Network.
Excellent. Ms Irwin?
Yes, thank you, Senator. Jane Irwin, I'm the Associate Director of Criminal Law at Legal Aid NT, and I'm also a member of the Criminal Law Network of National Legal Aid.
Excellent, thank you. And I'll now go to NATSLs. Ms Waite?
Yes. Thank you. My name is Narita Waite. I am the Deputy Chair of NATSLs, which is the National Aboriginal and Strait Islander Legal Services, also the CEO of the Victorian Aboriginal Legal Service, co-chair of Ngawing Maru, which is the closer gap partner for the Commonwealth in Victoria, and co-convener for treaty in Victoria as well. Just a few hats.
Quite a few hats. You've got a, I don't know, what do you store hats in? I don't know. But you've got a cupboard full of hats. Thank you very much for taking the time to speak to us today. If I could ask National Legal Aid first, do you have an opening statement?
Yes, I do, Chair.
Okay. Over to you, Ms Lumsden.
Thank you very much. Good afternoon, Chair and Senators. Thank you for the opportunity to make the submission and to appear before the committee today. At the outset, we would like to acknowledge that National Legal Aid is giving evidence alongside our First Nations colleagues, the National Aboriginal and Torres Strait Islander Legal Service. We would like to acknowledge the expertise of Aboriginal community-controlled organisations and First Nations people with lived experience contributing to this inquiry. Before we focus on the recommendations from our submission, we would like to highlight the plethora of evidence, research and reports already available on Australia's youth justice and incarceration system and express our concern about what appears to be willful ignorance of the impact of current approaches on the human rights of children and young people, particularly in the Northern Territory, Western Australia and Queensland. We know it works. What we need is bipartisan commitment to direct resources to address the systemic abuse that's occurring and is disproportionately affecting First Nations children, children with disabilities, children in state care and children of colour. Australia's youth justice system is in crisis and requires urgent federal intervention that is effective in changing the system. Steps to date have not been effective. For example, the Standing Council of Attorneys General made raising the minimum age of criminal responsibility a priority for their collaboration and review. However, since this commitment, several jurisdictions have made policy changes that undermine this priority and have moved further away from a national agreement to raise the age. We believe it's time to implement the Closing the Gap targets and to tie this to jurisdictional resourcing, so there are consequences for states and territories where targets are not met. In addition, the Commonwealth needs to take a leadership role to address the current human rights abuses in the youth justice system in a way that ensures change and better outcomes for children and young people, and particularly First Nations children and young people. Turning to the substance of our submission, our first recommendation is that we focus on closing the gap target 11. We know that the overrepresentation of First Nations children in the Australian youth justice system is driven by socioeconomic disadvantage and the legacy of colonialism, which has left First Nations communities grappling with intergenerational trauma and disconnection from culture. Achieving this closing the gap target requires comprehensive reforms that address these root causes of overrepresentation and over-incarceration, such as poverty, inadequate access to education and healthcare, and the breakdown of cultural and family structures. In Victoria, the Yurruk Justice Commission found that various forms of systemic racism, including discriminatory police practices, were a core reason driving the overrepresentation of First Nations children and children of colour in the criminal justice system. As indicated earlier, we believe that related obligations of state governments should be linked to, or should be embedded, and closing the gap targets should be embedded in legislation. Should be embedded in intergovernmental agreements, including those related to funding. Our second recommendation is that detention must be a last resort. To ensure children and young people are only given custodial sentences as a last resort, NLA urges governments to commit to a number of key reforms. The first is a national coordinated approach to raising the minimum age of criminal responsibility to at least 14 years old. In all jurisdictions except the ACT, children as young as 10 can be apprehended, prosecuted and detained. This is despite many compelling reasons for raising the minimum age of criminal responsibility to at least 14, which have no doubt been repeated to this inquiry. NLA is disappointed to note that despite this evidence, several jurisdictions have moved in the wrong direction on the minimum age of criminal responsibility. And notably in December 2024, the Queensland Government passed legislation to subject children and young people to the same sentencing as adults for serious offences, as well as removing detention as the last resort in the youth justice system. We need to change our thinking. Children are not many adults. They are people with the cognitive and emotional development and the behaviour of children. NLA also supports the increased use of diversionary programs and a focus on reducing the number of children and young people on remand. National and international research provides evidence of the immediate and lasting negative effect of detention for any period of time on children's wellbeing and rehabilitative prospects. NLA recommends the implementation of holistic legislated bail support programs that provide intensive case management for children and young people at risk of being remanded in custody. Our third recommendation is improved operation of youth justice detention systems. To prevent additional harm to children and young people who are given custodial sentences, NLA recommends that governments commit to initiatives to improve the operation of the youth detention system, in particular, measures to prevent the use of harmful isolation and restraint practices, including prohibiting solitary confinement. We strongly support a total ban on the use of spit hoods, which create a significant risk of injury or death. Staff in detention centres need to be adequately trained and supervised. Given the complex needs of children and young people in detention, appropriate training of youth officers is crucial to ensure the safety of both children and young people and staff. Finally, we need adequate resourcing of the legal assistance sector. Access to legal assistance is crucial to reducing the number of children and young people in the youth justice system and in detention, and to preventing and addressing the breaches of children and young people's human rights. As such, NLA continues to advocate for increases in funding to ensure ongoing and improved access to justice for the most marginalised in our community. We welcome the finalisation of the National Access to Justice Partnership in November 2022 and the significant increased investment to provide more sustainable service delivery. However, due to ongoing demand, this funding will not address critical funding pressures within the legal assistance sector. We also note that ATSL services are funded by the Commonwealth under the NAJP, but Legal Aid Commission's Youth Justice and Child Protection Services are funded by state and territory governments, which are outside the National Access to Justice Partnership. We would welcome a review of all funding of legal assistance services for the youth justice system, and a commitment across the Commonwealth and states and territories to providing an adequate level of funding. We would also welcome a commitment by the Commonwealth to establish a mechanism which requires a collaborative approach and one which ensures self-determination and culturally safe services and identifies and fills service gaps. Given the critical and urgent need to improve outcomes for all children and young people around the country in Australia's youth justice and incarceration system, NLA supports the recent recommendation of the National Children's Commissioner for a nationally consistent approach to reforming the youth justice system. As the Commissioner has recently observed, national leadership is required to reimagine a new approach to youth detention and lift it out of the political tough-on-crime cycle. Thank you, Senators. We are very happy to take questions.
Thank you. I'll go to you, Ms White. Did you have an opening statement?
I do, if that's okay.
It's more than okay. Over to you.
First, I want to thank the committee for the opportunity to speak about this important issue on behalf of councils, and I certainly appreciate the ability to set the scene before opening for questions. I also acknowledge the Wurundjeri people, traditional owners of the lands that I'm on today, and pay my respect to the elders past and present. I also acknowledge all of the Aboriginal people present at the hearings today. NATSLS advocates on behalf of our members, the 7 Aboriginal Strait Islander legal services providing critical, culturally safe and holistic legal assistance and support to communities across the country. The mass criminalisation and incarceration of Aboriginal Strait Islander children in the youth justice system is the most significant human rights issue in this country. Our children have been targeted by the state since early colonisation in an unbroken chain of harmful interventions that have removed them from their families, imprisoned them, subjected them to state-sanctioned violence and denied them their culture, freedom and humanity. Australia's current youth justice systems are grounded in violence, racism, the lie of terra nullius and the denial of Aboriginal self-determination. They're established with the purpose of criminalising and controlling our children and their families in order to destroy the oldest continuous culture on earth. It certainly hasn't finished pursuing that goal. 40 years ago, well before I was born, 16-year-old John Pratt died in a police lockup in Western Australia. His death was a catalyst for the landmark Royal Commission into Aboriginal deaths in custody. A litany of reports on youth justice has followed since, with many echoing the findings and recommendations of the Royal Commission. Most have still not been implemented or even properly responded to by governments, including the recommendation of the Royal Commission itself, the recommendations of the Australian Law Reform Commission's 2018 Pathways to Justice report, and the recently released report the National Children's Commissioner, Help Way Earlier. Now, all these reports say the same thing. The evidence is overwhelmingly clear that not only are governments criminalising our most vulnerable children, but that contact with the criminal legal system is itself criminologic. It leads to more interaction with the criminal legal system, and it does not make communities safer, now or in the long term. The inextricable link between criminalisation and the out-of-home care system has also never been more clear, particularly for our young people in residential care. The state should be held accountable for children who experience living in out-of-home care and then enter the youth justice system. They have been failed by the state. They have not kept them safe, and instead have been traumatised by the system itself. Yet despite these recommendations, these inquiries and continued advocacy from Aboriginal and Islander communities, youth justice systems continue to be focused on punitive and crisis-driven responses, often enacted in the response to a reactionary tough on crime political agendas. They would rather spend $3,320.46 a day to lock up a young person than do the work to implement innovative solutions that provide a pathway to long-term change and keep everyone safe. Those agendas that I spoke to achieve children being spit-footed, assaulted, strip-searched routinely and inappropriately, subjected to solitary confinement, denied healthcare, and has been documented nationally, subjected to sexual abuse. Prison traumatises children. It compounds mental illness, it disrupts their development, and it leaves our children more likely to die early and from preventable causes. We have seen the impact of these continuing and systemic failures by governments in the devastating deaths by suicide of 2 Aboriginal children in youth detention in the space of less than 12 months in Western Australia. Within that same period, we have also seen the death by suicide of a 10-year-old Aboriginal boy in state care. We have legislative changes in Queensland which have caused the numbers of children on remand to skyrocket, along with devastating laws allowing children to be held in adult police watch houses, which require the suspension of Queensland Human Rights Act. Politicians love to talk about community safety, but they regularly fail to acknowledge that the best way to strengthen communities is through healing and support. All of us here know that Australia's current approach to youth justice is at odds with the evidence, which supports holistic, child-focused, trauma-informed and dignity-affirming preventative practice and early intervention responses. Ms Little from SNAICC referred to the absence of glue in holding the service sector together for people who need help. And this is something we see across the country each and every day. ATSLs want to play their part in this. We have connectivity with communities and kids being drawn to the system, but instead of being able to effectively work with governments to support work with communities and young people to develop those innovative solutions they need, we are often confronted with slamming doors, dwindling funds, and endless tough on crime narratives. Now more than ever, governments must work in partnership with Aboriginal and Islander people and communities in line with the commitments they espouse under the National Agreement of Closing the Gap to ensure that Aboriginal children and their families and communities are receiving holistic, wraparound and culturally safe supports and services. So that one day, my child, who's now 7, isn't here telling another future inquiry the same thing I'm telling you now. We also need needs-based sustainable funding for ATSLs and other ACOs to provide community-controlled, culturally safe and holistic legal assistance and support, because it's an essential pillar of the change that is required. I know here in Victoria, it has meant that children have been deterred from engaging in the criminal legal system. We can't ignore that states and territory governments have an obvious and critical role in this policy area, but youth justice is not an issue which can be cast off to the states and territories. There is a clear and demonstrable need for the Commonwealth to play a leadership role here, and I believe they can do that. NATSLs and our members have made a number of recommendations to the review, which I look forward to discussing today. Thank you.
Thank you very much, Senator Shoebridge.
Well, thank you all for your submissions and your ongoing work. One of the issues that National Legal Aid raised was the Commonwealth actually using the levers of Commonwealth funding to encourage good behaviour and I assume in part punish bad behaviour by states and territories when it comes, for example, to living up to the commitments they've signed up to in the JPP. Other witnesses have pointed to those exact same mechanisms in health funding and education funding. Do any of you have an explanation for why those mechanisms are not being used in justice funding? I might go to you first, to LSA.
I don't really have an explanation. I could guess that it could be because of the financial agreement between the Commonwealth and the states in relation to the independence of financial arrangements as states and territories in relation to national agreements. But that's the only explanation that I could think of. I don't know why.
Because, I mean, to the extent that your submission references those kinds of mechanisms, there are some off-the-shelf examples, aren't there, in health and education funding, where the Commonwealth says to states and territories, well, we're going to fund you, but we're only going to fund you on the basis that you actually live up to these commitments for state and territory funding, for deliver on certain standards. I mean, that seems to me almost like an off-the-shelf solution to some of this in terms of putting some pressures on states and territories to live up to their commitments and for the Commonwealth to enforce its international obligations. Is that what the... Yeah. Go, Mr. Espy.
Sorry, Senator. It certainly could create not so much an enforceability mechanism, but an incentive mechanism. But it really does require the Commonwealth, I think, to take the lead by example and create, as we've said in our submission, a coordinated national response, which could look something like national standards or the Commonwealth taking the lead in national legislative minimum standards for youth justice in things like the age of criminal responsibility, bail and diversion legislation, arrest of the last resort, a bunch of the things that, as others have said, have been repeated time and time again. Certainly, the Commonwealth taking the lead is the first step. What's also needed is all the support programs and services that support the alternatives to kids being dragged through the criminal justice system. And one way is to incentivise states and territories by creating, meeting those minimum standards with the requirement or with the incentive of funding should they meet those standards. That certainly is one suggestion that's been thrown around by a number of people.
Senator.
Yeah, go.
Sorry, another matter that we're considering in relation to the Commonwealth leading by example is the Commonwealth increasing the age of criminal responsibility to 14 years for children charged with Commonwealth crimes. We know in particular that Aboriginal children are overrepresented in relation to those children under 14, so the 10, 11, 12, 13-year-olds coming before the criminal justice system across Australia. And speaking from a Northern Territory's perspective, particularly in the Northern Territory. And we know that the UN Committee on the Rights of the Child has recommended 14. Many countries across the world have legislated so that the age of criminal responsibility is 14. One of the issues that we say the Commonwealth can do to lead by example is for those Commonwealth crimes, so we talk about the Commonwealth Criminal Code, why not increase the age of responsibility in relation to those matters?
Ms. Waite.
Hi. Just from a NATSL's perspective, we have often come across the narrative from the Commonwealth that youth justice is a state and territory issue, and I believe I alluded to this in my opening remarks. I believe that is a reason why you have not seen them take a strong leadership role in this space. For us, in order for them to take up that leadership role, we agree with the comments around raising the age of criminal responsibility without exception in the Commonwealth criminal jurisdiction, and that you should work with states and territories to raise the minimum age for 14 years without exceptions across all jurisdictions, that we should see the Commonwealth actually compel states and territories to act in accordance with Australia's international obligations and introduce consequences for states who actively breach international obligations. They could also utilise their funding levers to provide more needs-based sustainable funding for diversionary early intervention and community-led alternatives in the criminal justice system, because those are the gaps in which these children are falling through, that are designed and developed in partnership with ATSLs. And we also know that the Commonwealth has the ability to use external affairs power under the Constitution to protect kids, and they've done this in terms of the sex discrimination laws.
Yeah. Well, you see, states and territories aren't even pretending that they're being compliant with international laws. And I'll give you one example, which is the statement of compatibility that was lodged together with the Queensland Strengthening Community Safety Bill in 2023. It says, you can read from pages 2 to 3 of it. The government acknowledges this proposed amendment is incompatible with the rights of children to protection in their best interests. The amendment will make it more likely that children will be detained pending trial, and for that reason is inconsistent with international standards, and it then starts listing them. Rule 13 of the UN Standard Minimum Rules for the Administration of Juvenile Justice, Part 3 of the UN Rules for the Protection of Juveniles Deprived of Their Liberty. It then says the proposal may also tend to limit the ability to divert children away from formal criminal process. That's breach of Rule 11 of the UN rules. And then it says this: the purpose of the proposal is to ensure that young people comply with bail conditions. That's an important and legitimate purpose. However, because it appears that less restrictive options are available to achieve the same purpose, the proposal limits human rights in a way which is not justified. That's direct reading from the Queensland Government's own statement of compatibility with human rights, and then they did it anyhow, literally thumbing their nose at Australia's international obligations and saying to the Commonwealth, come and bite me, we're just going to do it. If the Commonwealth doesn't intervene then, what is the purpose of signing international agreements when states literally just thumb their nose at it like this?
I think from NATSL's perspective, states such as Queensland acting with impunity, it's not surprising. It's an everyday occurrence in the justice space. And that is why in our submission, we've really focused on the need to implement accountably and oversight, because it's long overdue. And that's why, for us, the establishment of a well-resourced independent statutory mechanism which monitors and reports directly to Parliament on youth justice systems, with a particular focus on Aboriginal and Islander children, is incredibly important, because it can be statutorily independent of government and report directly to Parliament. It can have strong teeth, legislative functions and powers capable of holding government to account on their obligations, commitments and promises, because they certainly require that, be resourced adequately to perform its duties, and it can actually be, it can be new or leverage an existing independent mechanism, noting that we do have an Aboriginal and Islander Social Justice Commissioner in place. But I couldn't agree with your statements more.
Senator, the same.
And consistent with the comments of Ms Waite, we support the recommendations of the Children's Commission in her most recent report, her Help Way Earlier, in relation to governance mechanisms, a National Taskforce for Child Justice Reform, a National Cabinet Minister for Children, a Ministerial Council for Child Wellbeing reporting to the National Cabinet, and legislation to protect the human rights of children. And the mechanisms to do that are set out in that report. I would also commend the submission of the Aboriginal Legal Service Western Australia, which has an in-depth analysis of the human rights framework and how implementation of international conventions might be achieved.
Thank you for that. There's obviously more questions, but I note the time, Chair, so I'll hand it back.
Thank you. Senator Little.
I'm just wanting to ask a question about your thoughts on what should be done with children where there is no responsible adult or carer available around or in their circle who have committed serious crime or are thought to have committed serious crime. We heard earlier in the committee that an Aboriginal community-controlled detention facility, home, rather than an institutional detention setting could be an option. What are your thoughts on what could be options for children that fall into that category?
I think, Senator, there's a lot to be said for resourcing programs in various community settings. In relation to responsible parenting, it's a reminder that a huge number of children in the criminal justice system, their responsible parenting is the state and territory governments because they're often children in care, and it's quite often those children that are falling through the gaps even further, and those programs and support services are simply inadequate. So I think the answer to that is building those supports and those programs, is resourcing and funding the Aboriginal community controlled sector, certainly in the territory, and I'd say in most other jurisdictions. But that's simply something we don't see enough of. And what often happens, for example, in the territory, since our new government, we've just seen the current youth justice or youth support program Back on Track coming to an end next month, and then the unknown new programs, which are commonly referred to as boot camps, which have elements that are contrary to the Northern Territory Royal Commission. So we see funding shifting and changing and being disbanded due to a new political regime. But what generally happens is courts and other services are looking around for adequate supports. The cost then gets shifted to Aboriginal community controlled sector to retrofit their programs to support the significant gaps that exist. And not only community controlled organisations, but those costs often shift to Aboriginal communities themselves, who often community members, distant relatives, etc., will utilise their own resources, supports, for example, funding for fuel or picking up children to take them back to an outstation and looking after them and feeding them, not because it's their parental responsibility, but because it's a community member. That's what happens, is the costs of funding inadequately or funding inappropriate programs and organisations, that the cost just gets shifted to the community. So that's where we need family support programs with additional funding. As Ms White said, that sort of approach is in the long term cheaper than whatever it is, $300 and something a day to lock a kid up, which is what happens.
If I could just build on.
This is why I'm trying to play this out, and Ms White, you might even want to hold that thought and contribute to this. But we are seeing increasingly less and less people taking up foster caring. And if you add to that children who have experienced access in the system, then you're probably going to have, you're asking carers to take on additional responsibility for those children. I'm just interested to understand where the opportunity is to care for these children, given where they are, given what their options are right now. Is there somewhere else?
If I may, from our perspective and what we've raised in our submission is that there is a distinct lack of options for the situation in which you laid out, other than the child either remains in a residential care facility or they remain in a custodial setting. Successful programs that existed in the past, such as family therapeutic settings, no longer exist because they are no longer funded. Instead, the funding has turned to the youth justice custodial setting. We know where more therapeutic options such as Bunjilwarra exists, where children are treated and young people are treated through a therapeutic lens and provided a place in which to be safe, in which to live and build connections into external services, whether it be education and training or opportunities are successful, but they lack funding to expand. There is no magic tree growing at the back with money for capital expenditure, for expansion of workforce. Those things don't exist. And it is a limitation. We also know that one of the limitations that exists is in developing innovative solutions. There is a great amount of evidence out there through the Productivity Commission, even through Dr. Mundy's report on Aboriginal legal services, that when you put resources into community, develop resources that meet their needs, they are successful both in the short and long term. But this just isn't what the Commonwealth does.
So currently residential care, that's obviously, it's recognised as being a faster pathway to children entering the system again, particularly the custodial setting again. Can I just ask, is there something that could be done with residential care? Might be a hotel, might be, there's all sorts of examples of what they are depending on the jurisdiction you're actually in. Is there an example that you can point to in your jurisdictions where you would say, actually, if we did this in what is currently identified as residential care setting, because they are the most, they are there because they either can't find a carer, there's not enough carers, or their journey into that situation is a lot more detailed and complex than other children. Is there a setting that if you did something else could be better, could get better outcomes, that is currently a residential setting or not? I'm just trying to understand where they fall. If it's not in a custodial setting and it's not in out-of-home care, where is it?
Sorry, Senator. Probably 2 points to raise. One is that I think the answer is not necessarily in the residential care facilities. Certainly in the Territory, the challenge is to really build the kinship carer network. In recent years, I think it was Tungadera in Central Australia that were working on kinship carer mapping and finding, proactively building the numbers of kinship carers that could take children, really building on the strengths or strengths-based approach to Aboriginal kinship, Aboriginal family and cultural networks, and actually harnessing that rather than thinking about residential facilities. So that's probably the first point, to focus on those things. But the second point is, and saying this cautiously, the difference between, or the alternative between detention and something else is, a best practice secured care facility for the absolutely, as an absolute last resort for children. And I do say that cautiously because there are good and bad examples of that. But those are two very different extremes that I'll just make the point of noting.
Senator, I think also you might be thinking, when you talk about bail, often these children, particularly we know that children who have care backgrounds are overrepresented in the criminal justice system, particularly Aboriginal children. What they tend to, a place they tend to be able to go if they're eligible, are supported bail accommodation facilities. But they are not resourced properly in our experience, particularly in the Northern Territory where we are. We have a facility called First Steps in Darwin. There's only 10 beds at First Steps. It's the only supported bail accommodation in Darwin, and there's no access to girls, so young women or girls who have allegedly offended. There's Saltbush in Alice Springs, but again, only 10 beds. It's currently full. There's Bushmob in Alice Springs for 10 beds as well. Nothing in Katherine, and there's a new facility that's just started in Tennant Creek with 6 beds, so not many beds at all. Where we have the Darwin Holtz Detention Centre, the new facility, that has 52 beds as a capacity, and they're building the capacity to double that, and they're doing that by putting beds in single cells effectively. And that partly has come out of them closing the Alice Springs Youth Detention Centre because of the surge in custody numbers in terms of adults. So closing that detention centre for children, opening it for women in Alice Springs, and moving all the children from Alice Springs and the Barkly 1,500 kilometres away from traditional lands, community, family, to the Darwin Holtz Youth Detention Centre.
Okay, thank you.
Okay, thank you very much. Deputy Chair.
Thanks very much, Chair. And this might cover off similar ground, but I wanted to ask NATSLs particularly around, in your submission you raise the rates of Aboriginal and Torres Strait Islander children in out-of-home care and how that can essentially be a pipeline to criminal justice system. I just wondered whether, even on notice, given the time, or briefly, if you can provide the committee with more information about that, and what those rates of out-of-home care, how they relate to the rate of incarceration.
Given the time, we can, of course, give you a jurisdiction by jurisdiction data capture of that pathway of care to custody. What I think for us is just a pressing issue is that solutions for this have been posited time and time again. It doesn't just include raise the age, it obviously includes funding appropriate therapeutic community determined solutions, but we just can't seem to get over that barrier. We also know that there are very successful approaches of partnering Aboriginal-led legal services for children with holistic supports that have been successful in breaking that link between care and incarceration.
Thank you. If there is any additional information you want to provide on notice, that would be fantastic. I wanted to ask as well about the Justice Policy Partnerships. Ms Warner, you're the co-chair, I believe. Oh, no.
I'm not Ms Warner, I'm Ms
sorry.
Wade. He's our chair, but I am on the JPP as an independent member, so I could probably still help you out.
Okay, thank you. That would be excellent. We've had the issue of the Justice Policy Partnerships come up a few times today in different contexts. Obviously, a lot of the stakeholders that have appeared and given evidence are part of the partnership. From NATSL's point of view, what's the work of the partnership? How is that important to the work in this space, and what are some of the things that the partnership is doing right now that you want to see continued on pursued by government?
Thank you. Certainly, I understand the JPP has been a topic of conversation. Certainly, I think it's important to remember that the JPP doesn't operate in a vacuum. Political leaders continue to ignore expert advice and prioritise populist tough-on-crime narratives over evidence-based justice reform. And with the absence of political will and genuine partnership and the disregard for Aboriginal and Torres Strait Islander expertise in favour of short-term electoral gains and problematic policy platforms, we continue to face hurdle after hurdle. And continuing on that path really only encourages regression against the purposes of the National Agreement on Close the Gap and JPP. We would hope that political leaders would take this as an opportunity to listen and act on the reform agenda and solutions that it has provided, because until that point, the crisis in Australia's youth justice system will continue to worsen. And look, to be more pointed around solutions to the barriers, that have been holding the GP back for the last 3 years. And the GPP have done some incredible work, particularly around bail and remand, particularly on how you tackle racism in the system, particularly on what the alternative pathway is for raising the age of criminal responsibility, looking at introducing statements of compatibility to ensure that before parliaments across this country introduce justice-related legislation, they think about the impact on our communities, on our people. And I would love to see government, both the Commonwealth Government, states and territories, act in partnership, respect Aboriginal expertise, and get going on the work that needs to be done.
I just have one more question, Chair. I know this isn't your area of policy expertise, but we've had a discussion with some other witnesses about the media landscape and how that impacts, I guess, policy reform. I think without me making comments about the policy changes in Queensland, it's clear that those changes occurred after an election victory by the current government that was based really solely on changing the laws in the complete opposite direction of what you and your colleagues are advocating for. I was just wondering whether you have a reflection on the media landscape and how that is impacting, I guess, policy reform in this space. It's a context that I think is important as part of the discussion. It does affect public support one way or the other for the changes that you're advocating.
And let's be frank, media influences community perception, which then influences what politicians prioritise. It's a cycle. If I can point to 2 examples to kind of illustrate how problematic media narratives are. We saw, for example, in my home state in Victoria, that in response to frankly alarmist and racist media reporting, in 2024, the Victorian government backtracked on commitments to raise the age of responsibility from 10 to 14 years, expanded the use of isolation and youth justice detention facilities, maintained reverse onus provisions in bail applications for children, contrary to international human rights law, and expanded the community surveillance of children through novel deployment of electronic monitoring. That happened without notice or consultation with VALs or other ACOs, and in the face of longitudinal research indicating that youth crime had actually decreased over the past decade in Victoria due to therapeutic responses and a reversal of tough on crime approaches. And there was no crisis. The data was very clear on this. Approaches that the government implemented were working because they were in consultation and determined by ACOs. But rather than maintain their policy positions, they backtracked simply because the media manufactured a crisis. We also saw this occur in relation to New South Wales, where we saw bail laws imposing harsher tests for children than adults. And that was in response to media and public intention on a short-term, localised spike in certain types of offences, which then saw an enactment of new bail laws that apply statewide and make it more difficult for children to get bail than adults charged with equivalent offences. So until we tackle the way that media reports crime, particularly youth crime, I just think we will not break the cycle of the way that politicians approach it.
Very succinct. Thank you very much.
Just adding to that, other examples, Senator, in Northern Territory, which is a case of, I suppose, media kind of emboldening what I would call often racist ideology. Essentially our recent election, the government came in on promising to lower the age of criminal responsibility. Another election promise was reintroducing spit hoods, which if you're a child in the police station or in youth detention is not going to stop your house having just been broken into. But the media amplifies racist attitudes towards Aboriginal people and emboldens politics to respond with I suppose, fear-based tough on crime narrative that's just self-defeating and contrary to all the evidence of best practice.
So just to add to that, most children at the moment who are alleged to have committed offences in the Northern Territory, most of them are refused bail by police because of the changes to the Bail Act that have been introduced. That means that some children who might get bail in court, if they're arrested on the weekend, they're taken all the way to usually up to Holtz. If they're in Alice Springs or the Barclay, they spend 2 days in detention before they get before the court. So arrest as a last resort is not happening in the Northern Territory. Arrest is a first resort when it comes to children, and it's in direct response, in our view, to the new bail changes that have been introduced following a law and order election in the Northern Territory. The other issue I just want to raise so the committee's aware is that the average condition of bail for a child in the Northern Territory, particularly now since the bail changes, is to wear an ankle bracelet, an electronic monitoring device. An example I can give is a young 13-year-old girl who was arrested recently. She has no criminal history. Dolly Incapax is an issue, so there's a real live issue about whether or not the prosecution can prove that she understood the conduct was seriously wrong. At the time, she was with a 23-year-old. This 13-year-old with no criminal history is subject to a curfew and is wearing an electronic monitoring device. If she breaches her curfew, if she tampers with her device, it's a breach of bail. It's now an offence because of the changes to the law, the recent changes to the law, and there's a presumption against bail despite this young girl having no criminal history. Another thing I'd just like to raise for the committee's awareness in terms of electronic monitoring device, we had a 14-year-old client last year whose device caught fire on his ankle. He received third-degree burns. He was hospitalised. It said that he tampered with the EMD, but he was a 14-year-old. EMDs aren't tamper-proof. That was extremely traumatic. I mean, looking at the injuries which we were shown was really extremely concerning. So EMDs in the Northern Territory are imposed as your average condition of bail against children.
Disproportionate.
Thank you.
Okay, thank you, Senator Green. Thank you to the witnesses for appearing today. It's greatly appreciated. The committee will now suspend for afternoon tea until 4:40 p.m. Thank you very much.
Thank you.
Thank you.
Okay. So I've got to read my blurb, which you've all heard about 20 times during the course of the day.
Almost recite it back to you now.
Good. I now welcome representatives from the Australian Human Rights Commission. Thank you for taking the time to speak with the committee today, and also thank you for the submission and also for all the work you've been doing on this area. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked to the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, could I ask you each to please state your full name and the capacity in which you appear? Ms Hollands.
Thank you, Chair. Anne Hollands, National Children's Commissioner.
Excellent, thank you. Ms Cayas.
Chair. Rosemary Kayes, Disability Discrimination Commissioner.
Excellent, thank you. And I've noted your attendance during the course of today's proceedings. Would either of you like to make a brief opening statement before we go to questions? Ms Hollands.
Yes, thank you, Chair. I will be doing an opening statement for both of us.
Okay.
So my name's Anne Hollands, as I've just said. I'm Australia's National Children's Commissioner, and I'm joined by my colleague Rosemary Kayes, the Disability Discrimination Commissioner, and I'd like to acknowledge the traditional owners of the land on which we're meeting today, the Ngunnawal and Ngambri people. As you have heard throughout the day, since the tabling of my report titled Helpway earlier, How Australia Can Transform Child Justice to Improve Safety and Wellbeing, in August 2024, the situation in Australia has deteriorated further. The facts are that decisions to make the justice systems harsher and more punitive by some states and territories are not based on the evidence of what will prevent crime by children and make the community safer. Australia is lagging the rest of the developed world in failing to implement evidence-based reforms, and the ongoing breaches of human rights are causing widespread and increasing concern, including internationally. The passing of the Making Queensland Safer Bill last year is deeply concerning, as we've heard. By the Queensland Government's own admission, the legislation directly breaches human rights, including the UN Convention on the Rights of the Child, which Australia ratified a long time ago in 1990. The Queensland Government officially admits that the Act treats children less favourably than adults in the same circumstances, I'm quoting now, and therefore directly discriminates on the basis of age. The Queensland Government officially admits that the Act creates a sentencing system where adults are better protected than children, and that more children will be held in police watchhouses for extended periods and will not be protected from cruel, inhumane and degrading treatment. Chair, I have personally witnessed the conditions in some of these Queensland watchhouses, where children are incarcerated for many weeks at a time. I was frankly appalled. No windows or fresh air and completely bare concrete cells, no visits from family, no activities, no education, no rehabilitation. I was told that some Queensland watchhouses do not even have shower facilities. But above all, probably the thing that worried me the most was that the police, who are meant to be looking after these kids, they have no training to care for children, let alone for children with complex needs like neurodevelopmental and intellectual disability, health conditions including mental health disorders and trauma. The Queensland Act has been condemned internationally, including by the United Nations, and I'll quote, a flagrant breach of human rights and international law. In particular, Australia has been called out for the removal of the principle of detention as a last resort for children. I'm advised that no other country in the world has done this. This convention requires Australia to ensure that its criminal justice responses for children are age appropriate, focused on their needs and on rehabilitation and reintegration. Mandatory sentences of any kind, and particularly detention, contravene the Convention on the Rights of the Child and have a disproportionate impact on First Nations children, a fact acknowledged by the Queensland Government. Therefore, this Act is potentially in breach of the Racial Discrimination Act of 1975. The Convention states that detention should only be used as a last resort and for the shortest appropriate period of time. Many children enter detention with pre-existing disability and health conditions that are often undiagnosed and untreated because of the lack of services in their communities. Punitive sentencing and treatment in detention, such as solitary confinement, are likely to compound trauma for these children. The Royal Commission into Violence, Abuse, Neglect and Exploitation of People with Disability found that detention settings exacerbate the vulnerabilities of children with disability who frequently lack access to that therapeutic support and trauma-informed care. The failure of the basic health, education and other systems to provide for the needs of these children makes them a highly vulnerable group. We are criminalising, therefore, our most vulnerable children because the support systems that should be helping them are fragmented, uncoordinated, and it's a postcode lottery that determines if you get any help at all. The United Nations Committee on the Rights of the Child has urged nations to urgently reduce reliance on detention of children. That's the direction that the rest of the developed world is going, and we are going in the opposite direction. To do that, it requires effective and accessible community-based supports such as drug and alcohol and mental health services, and schools that can support children with learning problems. It includes alternatives to detention, which are also discussed in my Helpway Earlier report. As we've heard earlier, the Human Rights Watch World Report 2025 noted that Australia's human rights record is marred by its treatment of children in the criminal justice system, and this report noted in particular the lowering of the age in the Northern Territory and the 2 suicides of children in detention in less than a year, including a child that had endured long periods in solitary confinement. That should never be happening. The title of my report tabled in Parliament is Helpway Earlier, and it comes from what I heard from over 150 children around the country who I met in the criminal justice systems. They said, we need help way earlier. This project was initiated because of evidence that children in detention are subject to the most egregious breaches of human rights. The findings of our report indicate, in fact, that we have misunderstood the nature of the problem we're trying to solve. Evidence shows that we cannot prevent crime by children and make communities safer by making the justice systems harsher and more punitive. It doesn't work as a deterrent for children. Criminalising children with complex disability and unmet needs only makes it more likely that they will go on to commit more serious crimes. That's what the evidence is showing. Crime by children is a symptom of underlying needs that we are failing to address. As recommended in my Helpway Earlier report, we need a laser-like focus on implementing evidence-based systems reform. This requires to redesign and improve coordination in our basic service systems, including health and education, so that they are fit for purpose and able to address the complex needs of these children much earlier. Improved capability of frontline child protection and justice systems, and that would include training on child development, neurodiversity, mental health, and domestic, family and sexual violence. We also need to address disadvantage, including poverty, lack of housing and food insecurity. We've heard about these today. We need better public transport and access to affordable sport and cultural activities. Sounds simple, actually not that expensive, can be done, and these are things that children have told me are missing from their communities and out of reach for their families. The journey for these children in the most vulnerable circumstances often includes, firstly, the child protection system. Firstly, we ignore them, and then they enter the child protection system, and then the next station on the train line for them is often the youth justice system. But our findings indicate that this trajectory is both predictable and it is preventable. This is a national crisis requiring governments to pull together across the Federation to work on a reform roadmap based on the evidence of what will work. However, currently there is no national meeting of youth justice ministers. They do not meet. Currently, the word children does not appear anywhere on the list of key priorities for National Cabinet. That means there is no there's no eyes on children from the top. There's no accountability, and the well-being of children is not a national priority in this country. In the Help Way Earlier report, we make several recommendations about working together across the Federation, as with other critical issues like domestic, family and sexual violence. Child wellbeing must be made a key priority for National Cabinet if we're serious about preventing crime by children and making communities safer. Otherwise, Chair, we will still be here having the same conversation in 10 years' time. The federal government has a responsibility for the human rights and wellbeing of Australia's children. While the federal government doesn't run the child protection or youth justice systems, it should play an important leadership role in bringing states and territories together to work on a reform roadmap, just as we are doing for other issues like domestic and family violence and housing, which were both previously considered state and territory issues alone. It's notable that when it comes to youth radicalisation, another form of youth crime, we already have a national architecture in place to work together on evidence-based prevention and responses. The underlying risk factors for youth radicalisation, and this is, I've met with the ASIO and AFP and Home Affairs, they all agree that the risk factors are the same. Things like neurodiversity, mental health issues, disengagement from school, etc. The fact that the federal government is already working together with the states and territories to prevent that form of crime is in stark contrast to the fragmented approaches and lack of collaboration for the much larger group of children that we've been hearing about today. In fact, there's a growing divide in Australia in the approaches taken by different states and territories. And overall, we're going backwards because we are not working together. I noted on Friday there was an example of what can be done at the national level when the Minister for Health announced a national review of best practices for healthcare for trans and gender diverse youth in order to, quote, ensure national consistency and evidence-based practices. In the same way, our Help Way Earlier report recommends a national task force for reform of child justice systems, a cabinet minister for children and a ministerial council for child wellbeing reporting to National Cabinet, and legislative accountability for the human rights of children. We note the Help Way Earlier report is specifically referenced in about half of the submissions to your inquiry, and it provides evidence-based foundations for a national reform roadmap. Thank you, and we welcome your questions.
Thank you very much, Commissioner, and I deeply acknowledge the work that's gone into your report that was released just last year. I'll open up just with a few questions, and there are a few matters you raised in your opening statement I want to touch upon, and then I have a question for the Disability Commissioner. In terms of, you mentioned that you actually had a tour, you had the opportunity to go and visit the Queensland watch houses, and this has been an issue that's been going on for, I think, quite some time in terms of children being placed in or staying in watch houses because of a lack of capacity in the system. I was just interested to know, I'm impressed by that. I'm impressed you're given access. How did that come about? And were you given similar access to other youth detention centres around the country? This is your opportunity to tell us to what extent are states and territories cooperating with the discharge of your obligations, and to what extent did they cooperate more generally with respect to the preparation of your Help Way Earlier report?
So just on the watch houses first, Chair, so I was assisted by the Queensland Human Rights Commission to make the contacts in Queensland, but I found that the police were very cooperative. So the police are running these, and so I was able to visit several of them, and And I cannot stress more strongly how appalling they were. I mean, I'd seen a lot of children's prisons by that point. I felt warmly towards them after I'd seen these watch houses. No child, I don't think, should be in those, at all. We shouldn't have them in there at all, and yet I was told they were often there for like 6 weeks at a time. It's not acceptable in a country as rich as Australia.
And to what extent have you had access to other facilities around the country?
So as part of the project, we visited children's detention centres in most jurisdictions. We didn't go to Tasmania because they had just had their Commission of Inquiry, and we didn't want to... we went into them to talk to children, so we didn't want to over-consult kids in Tasmania, but we engaged with Tasmania in other ways. Most states allowed us to do it, but not all.
Which states didn't allow you to do it? You knew that was going to be the next question.
So Victoria, we weren't able to visit the youth detention facilities in Victoria.
And what was the reason for that? What was the reason you were given?
I wasn't really given a reason.
Okay. The next question I had in relation to preparation of the report, to what extent did other commissioners have input, human rights commissioners have input into the report, including Ms. Caius?
I think Rosemary wasn't around at the time we were working on it. A lot of the commissioners, as you're probably aware, are new, but certainly I engaged with the previous ones, and as also the children's commissioners who you met this morning, and I think we conducted something like 200 expert interviews. It was quite a large group of experts we met with, as well as their submissions that we received.
Okay. In one of the submissions we received mentioned this categorisation of youth as opposed to children. So we talk about youth justice instead of child justice or children justice. Right. And perhaps if you use the word youth, you're not necessarily thinking of a 10 or 11-year-old. Perhaps, I don't know, but I'm interested in your views in terms of terminology.
Yeah, so we chose the child justice language because that's consistent with the convention, the Committee on the Convention on the Rights of the Child, who right now are actually developing a new general comment on access to justice for children. But it is often, language is quite an important thing. You hear often these children referred to as offenders or just as people who offend. And indeed, the term youth is a bit vague and often refers to that upper end, even into early 20s often. So they are children. My report is about children under the age of 18.
Okay, understood. Ms. Caius, I think you were present when I read an example which was given in the Law Council of Australia's report, and I'll just read it again for the benefit of Hansard and those listening. So the Law Council referred to matters which had been raised or witnessed, they actually said, by legal practitioners in the detention incarceration environment, and referred to, I quote, a young boy who has a severe intellectual disability and was placed in a unit alone in custody, preventing him from being able to properly engage with his lawyer, treatment and education, end quote. I just want to give you an opportunity to give your thoughts to that sort of issue arising in our youth detention centres.
Unfortunately, it's not an uncommon situation. Solitary confinement and seclusion is used a lot for kids with disability when they're in the criminal justice system. A lot of it is used to respond to behaviour. Behaviour is a direct response or an exacerbation of their disability in engagement with their environment, and it becomes a bit of a catch-22 situation. They endure restrictive practices as a way to try and to get them to submit in terms of their behaviour, but those restrictive practices exacerbate that particular behaviour. And so it becomes a situation where restrictive practices are increased in use, but it's not going to change the behaviour because it's contributing to the traumatic response.
So it becomes effectively
Yep.
A vicious circle in some respects. It can actually worsen the conditions. Is that correct?
Yes, and the environments, I mean, the nature of disability, many of these disabilities, is it's the interaction of the physical manifestation of the impairment with the environment that creates the disability, and that behaviour is an intrinsic aspect of it. And so unless the underlying trauma or condition is being supported in some way or treated in some way that has a true therapeutic response, then you're not going to deal with it. And a justice system is not the place to try and deal with it.
Why? I'm just perplexed in the sense that no doubt there's, if I was to look for the research in relation to best practice, the most recent research with respect to how to deal with someone with a disability, especially in the context of this environment, why is there this disconnect between what is actually happening in some cases compared with best practice? Is it a lack of resourcing? Is it a lack of knowledge? What's the driver, do you think?
I would say it's a combination of all those things. It is a lack of resources. You will see restrictive practices and things like isolation and seclusion are used in response to low staffing numbers. I mean, people with disability, like children with disability, are overrepresented within criminal justice systems. So you would have heard the Law Council earlier make that statement, and a lot of it is around the criminalisation of disability, as was discussed by the Disability Royal Commission. So what they talked about was the fact that kids with disability come to the attention of the police because of their actions and behaviours, and then that contributes to being highly visual to workers within the criminal justice system, and so they're much more likely to be then the recipients of criminal justice custodian.
Could I just add?
You've got something to
could
add?
I just add to that, you know, I visited a lot of prisons for this project, and the staff were very clear that they didn't have the skills to deal with the kids that were coming in with very complex needs, and it was very clear early on that often these kids were coming in on remand, as you've heard about, and then they were let off, and they'd go back out, and then they'd come back again. And these staff were seeing the same kids cycling back in and out. And so what that tells you is that the systems outside the criminal justice system are failing. So in a way, we're burdening, in an inappropriate way, the criminal justice system to try to provide care for kids, then they're not equipped to do it. And they shouldn't be in there, right? Yeah. So that's why the report, the Help Way Early report, tries to shine a light on the other systems, that the justice system cannot solve this problem. We've got to look at the health and the education systems, the other social services systems that are failing to meet the needs of these kids.
Okay, Senator Little has a follow-up question, then I'll go to Senator Shoebridge.
What you're talking about here, and that is children with reduced cognitive development, FASD, or other disabilities. I just want to get some insight from you on the potential for exploitation of those children by other children or by criminals, and how that impacts, their disability and their experiences even before they actually, say, get picked up by the police and enter into a custodial setting. I'm interested in what that part of a child's experience and what that does to them, because somebody hasn't identified that heightened risk for those children.
Well, yes, they are at heightened risk of exploitation, and I mean, that's one of the areas that the Disability Royal Commission looked at in terms of, so that vulnerability can happen prior to incarceration, but also it happens with incarceration. And what happens is that once they get into juvenile justice systems, it's generally a fairly good indicator that they're never going to get out of criminal justice systems. And so it literally does become a pathway. I don't know whether we have any great data or understanding of where the exploitation starts, but it is rife within criminal justice systems for kids with disabilities. And it's literally can be, in many ways, the only sense of belonging they get is once they enter the criminal justice system.
Yes, so I'll just throw in there that, I mean, we know from child development research that particularly between the ages of about 8 and 14, those middle years which have really been ignored in many ways in policy, that that's when all kids have a heightened sense of a need for belonging. We all have that, but at that age group, it's particularly strong. And so kids who aren't getting that sense of belonging from school because it's not fit for purpose, or they've been pushed out, or they've disengaged, or have learning problems, if they're not getting it at home because of family dysfunction or whatever, they'll go looking for that sense of belonging. And some kids will get it, they'll stay in their room online and they'll become radicalised because they're targeted by criminals, right? So that's, some kids do that. Other kids, and the ones we've been talking about today, they go out and find it out on the streets, through stealing cars or whatever, increasing sorts of crime. But it's about finding that sense of belonging. We just don't have a good understanding that this, in a way, is a normal child development trajectory, and we can actually prevent the crimes if we meet the needs of these kids.
Okay. And when you get the political rhetoric that is that if they do an adult crime, they do the adult time, that presupposes there's that cognitive and that lack of exploitation that is drawing kids into that criminal activity. And the deterrent mechanism just isn't there.
Okay. Cinda Shubrick.
Thank you both for your work, and Ms. Hollins, thank you in particular for the report that you delivered and the work that underpinned that. I think you spoke to about 150 children.
Over 150.
Over 150. And in fact, the title of the report, Help Way Earlier, is one of the cries for help, really, that came for one of the kids you spoke to.
A lot of the kids.
Yeah. Do you want to... These aren't kids who are rejecting help or refusing to engage with programs. These are kids for which there is no help and there are no programs, even though they desperately want it. That's one of the things that came out from your report. Do you want to tell the committee what kids are asking for?
Well, they're really asking for the sorts of things that all kids need, your kids need, my kids need, and that is, the basics of a good childhood, like food, somewhere safe to live, good sense of connection with their family and school and their peers, stuff to do like sport. A lot of these kids talked about the fact that in their communities there either isn't sport or cultural activities they can do, or they can't. The parents can't afford it. I think I mentioned that in the intro. So there are some simple fixes here where we could address these things, but a lot of them are relatively simple. Kids also told me that they want to go to school. This is important. Senator Little, you've been asking about this today. They want to go to school, but they don't feel they belong there, a lot of these kids. Some of them said they don't feel safe there. right? They feel discriminated against, pushed out, or their schooling model is not fit for purpose for their needs. And the really ironic thing is some of them really get their education when they go to jail, right? This is the really bad part of the story, because they're able to, in the better facilities, and there are some that are better, some that are worse, but I'll mention one that I would describe as the best one in the country that I've seen. Small facility, 24 kids, really great school, and they got really intensive one-on-one learning support. When I asked the principal, well, what happens when the kids leave? She goes, oh, well, when they go back to their community and they try to enrol in their school, often the school doesn't want them because they've been in detention. So there's this sort of subtle, don't come here. Or the school isn't able to provide the one-on-one intensive learning support that they need, right? So, so they drop out eventually, back on the streets, and they come back into detention. Right? This is the cycle that we're seeing again and again. So what we're doing isn't helping these kids. In many cases, it's harming them because of their pre-existing needs, and it's not keeping communities safer. And it's costing 1.2, 1.3 million a year to lock up a kid, money we're throwing away, right? It doesn't make any sense on any logical level.
So instead of spending $500 on a day on a teacher's aide to help kids engage with school, keep them, keep them feeling safe, and it may even cost less than that if you spread it across a number of kids in a class. Instead of spending, say, $500 a day on a teacher's aide to engage, we spend $3,300 a day keeping that child in a detention facility.
And training them for a life of crime later on.
For some of those children, it's indefinite.
And can I just say also about schools, if I can throw it in there, that schools really could be a hub in the community for a range of health and social supports. That a school could be a very dynamic place, could be providing not just teachers' aides, but actually, holistic support for these kids, and be a place where kids and families feel they belong. We need to pull them in and ensure that they're getting a range of their needs met. Currently, our service systems are so fragmented, and my report's not the only one that's pointed this out. Any number of reports has pointed this out, that we make it hard for people who really need the help to get the help they need. We're making it harder for them. So, if we want kids to go to school, there's a lot we could do with the school in connected with the other government-funded services that are in that area that are not working together.
You see, Ms Hollins, one of the things that struck me when I read your report was instead of reading about children as being, as you might if you read the front page of the Courier Mail or the Daily Telegraph or the West Australian as, professional criminals. When I read your report, these kids are actually just desperately asking for help. And if the supports were offered to them, they'd grab it with both hands and seek to engage with it. I think that was one of the most compelling parts of your report. These kids are desperate for this parliament, for other parliaments to do something.
And they know what's needed. We ask them about what it is that causes kids to get into trouble with the justice system and what is it that helps other kids to stay out of the justice system. They know. They talked about help for their families. They worried that the adults in their families couldn't get drug and alcohol, mental health support, domestic family violence support. They wanted help for their families, because they understood that the family is really important to children's development, right? These are just basic things. They're things that we all know, but these kids are missing out on them.
Well, we had evidence earlier today saying that if you look at First Nations kids in particular going into child detention, they're skinny kids because they haven't got enough to eat. They're being sent to jail because they break into a home to make a sandwich. Was that lack of access to food something that came up?
Absolutely. I remember one consultation I did where I asked these teenage boys who weren't very articulate, I said, why do you reckon young fellas are stealing? Think back to when you were young. Why are young fellas stealing? And this one quite lanky, tall boy said, they're hungry, and he rubbed his stomach. They're hungry. That's how it starts, right? And then it progresses from there. And police I spoke to in regional areas in particular, they knew if a 5-year-old was walking around the streets, they knew where that child would be in the years to come. This is all so predictable. We know what's happening, we know where these kids are heading, and we're allowing it to happen.
So you made reference, I think, to the most recent statement of compatibility delivered by the Queensland government, the current government, when it was ramming through its, I forget the Orwellian name of the most recent, Making Queensland Safer Bill, 2024, where they openly said that they're breaching multiple international human rights, the rights of the child, basic rights about juvenile justice and minimum rules for juvenile justice. And in relation to removing detention as a last resort, they said, and I'll just quote it from here, this will in essence create a sentencing system where adults are better protected from arbitrary detention than children. And yet the Queensland Parliament read that, well, maybe some of them read it, and then they made it law. What does that say as an example about what states and territories are willing to do with the Commonwealth's international obligations?
Well, I think the obvious conclusion is they're ignoring our international obligations.
Well, they're not, though. They reference them all. They're very aware of them.
They're aware. Well, then they're choosing to not abide by those requirements. And yeah, I think you're right. Sometimes this is references they're ignoring them, but actually they're doing it in plain daylight. They're naming all the international obligations that the Commonwealth has signed on to, and these formal signatures and this adoption by the Commonwealth about the rights of the child, maybe UNDRIP, critical international minimum standards that we would expect other countries to comply with about detention. They name them all, and then they say they're breaching them all. And in this case, they're saying they're treating children worse than adults and they're doing it deliberately and consciously. But nothing happened. There's no consequences. States and territories seem to be able to do this at will. Do either of you have a response to that?
Sorry, I was just going to say that they're also agreeing to those ratifications through the Council of Treaties. I mean, there is a mechanism that is established through Prime Minister and Cabinet that brings together each of the states. Each of the states contribute to the briefs that go to the negotiations at the United Nations. I'll just put my other hat on as the Vice Chair of the Committee on the Rights of Persons with Disabilities. The Council of Treaties is held up as the mechanism that ensures federalism works in Australia for our international obligations. Now, when I'm sitting in Geneva and I have a federal state, say Germany, in front of me, well, Germany is as federated as we are, and yet I can have a far less frustrating conversation with them because they have human rights protections within their domestic laws. We don't have that missing element. And that is the missing element to hold states accountable to domestic standards and a national leadership in human rights. So it begs the question why the Council of Treaties exists if it isn't a place where the states agree and are held to those agreements for the international standards that we hold. And this was a classic example when the subcommittee against torture, which would have been looking at juvenile justice facilities, was not allowed to do their visit for OPCAT and the program of states visits, that the ratification of OPCAT ensures the subcommittee on the prevention of torture. The whole reason you sign and ratify that treaty is to allow state visits from the subcommittee on the prevention of torture, and New South Wales and Queensland refused.
Senator Shibridge, I've got to give the call to Senator Ghosh. Senator Ghosh.
Thank you, Chair, and thank you to the witnesses for being here. One of the things that was in the Help Way Earlier report, one of the outcomes of the survey was that more than 2/3 of the children you surveyed said that they regarded getting a job as protective against getting into trouble, I think is the word that, or the phrase that was used.
The older kids would have said that,
yeah. In terms of, and looking at some of the determinants of social justice model or the Capricorn model that was in the report as well, did you get a sense from them as to what other things that would assist them, be it in terms of employment support or specific opportunities to get jobs? And let me put that question at that level, and then also ask particularly about whether there was or whether there was a regional aspect to that, or whether there was some regional feedback on that question as well.
Jobs was a very important issue. These kids understood that families where they have jobs, they can buy stuff. Kids said to me, when I asked them, one child I remember in jail, I asked him, well, why do you reckon kids steal cars? And he goes, because they know they'll never have the money to buy one. They'll never have the money to buy one. So the most chilling thing about these, and they weren't just surveys, they were face-to-face consultations in the prisons, was the most chilling thing was where kids had no hope. They had lost all hope of anything other than progressing to the adult jail, right? That to me was the hardest to hear. So the kids knew that a job was important. They knew that they needed education, then they needed training for a job. But when they were in these children's prisons, often they were not getting any kind of training for a job, right? They're just languishing there, right? They might do, look, a lot of them now do like a barista course or, few little courses along the way, but again, it's a missed opportunity. If a kid's in there, we should be putting them through proper certificates and they should be coming out better off, and then we should be supporting them properly once they leave. I appeared before the Queensland inquiry that was about a year or so ago, and a witness from the government talked about they were giving tents to kids when they left detention. Tents, because there was no housing, right? No wonder the recidivism rates, like over 90% up there. So, all the way along, Senator, we need to be addressing these needs. These are children growing up who we want them to be functional adults at the other end. We know what they need. We need to make it possible for them to get what they need, including and perhaps even especially once they leave detention, because then if we haven't equipped them, if we're not supporting them, if we haven't provided proper housing and psychosocial support, they will just come back. That's what we now know, well evidenced, that the progression to detention it's this revolving door.
Ms Hollands, can I just clarify that? So you're saying you were told by someone in Queensland Corrections that they're giving children?
Yeah, so this was evidence at the inquiry. It'll be on the inquiry transcript. Another witness said, and I hadn't heard this before, that kids were, well, it wasn't all the time, but sometimes given tents when they left detention. And I think at that time the youth justice officials were only allowed to work with them for something like 72 hours or something like, a very short time. That's just one example. There are many examples around the country where really we're not providing the very basic levels of support that, everyone needs, but these highly vulnerable kids particularly need.
Thanks very much.
I think you've touched on some of these already, but again, from that survey, I think nearly 2/3 of the people you surveyed and spoke to indicated that they needed support services to keep them out of trouble or out of contact with the criminal justice system. What were those support services that they identified, or what was missing?
Well, drug and alcohol services is one, but it, mental health, educational support, all of those supports, housing. Housing is a key thing, of course. But just on the drug and alcohol, can I mention that it was after this report was out that I visited the Kimberley, and I found that there are high rates of drug abuse in the Kimberley, but no drug rehabilitation it was in Broome, no drug rehabilitation support for children. And I was told by the youth justice officials there that in order to get help for their drug addictions, the children they had to commit a crime and be sent down to Banksia Hill where they might get some health care. Right? So again, it doesn't make sense. Let's provide those services in the communities. Let's try and help these kids to avoid doing crime, to avoid going down that trajectory. Let's look at the basic infrastructure that's needed everywhere.
This may be a policy design question, but in terms of the work you've done, did you get a sense of what the best way in an immediate or kind of speedy way is to remove that food insecurity? Is it through food programs at schools? Is it a household-based targeting? What's the best way to achieve that in the situation where kids are currently going hungry and therefore kind of interacting with the criminal justice system?
Well, it would very much depend on where they are. Obviously, Australia is a very large, complex geography, but school is a really good example. If there's food provided at school, then that's very much a pull factor. If there's other things, if the educational model is also fit for purpose, if the kids feel a sense of connection when they get there, as well as getting food, then you're multiplying the positive effects, right? So definitely that. But I guess there are also issues with families, the family problems, and why there's food insecurity in the families that needs a deeper examination. And that's where I think the child protection systems really they're overwhelmed by need. They're overwhelmed. And that's why we need to get the systems working better together, because I used to be a frontline child protection worker myself, so I can speak directly about that. There will never be enough child protection workers. They're the ambulances at the bottom of the cliff, but they do get close to the families, and if they can work well with the other services in the area and meet all the needs of the family in a comprehensive way, listen to what the family needs and really be that conduit for getting in this. You're asking about food. If food is an issue, then they can help problem solve how to address those needs.
Okay,
Thank you, Jeff. Thank you.
Thank you very much for your testimony and for all the work that you're doing in this space. It's greatly admired.
Thank you.
Thank you. We'll now call our last panel. Our friends from the Attorney General's Department. We got the thing. Sorry. I would now welcome representatives from the Attorney General's Department, Department of Social Services and the National Indigenous Australians Agency. Thank you for taking the time to speak with the committee today. I'll just read my blurb as you're getting settled. Information on parliamentary privilege and protection of witnesses and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. So I'll now ask each of you, and there's quite a number of you, to please state your full name and the capacity in which you appear. And I'll start with the Attorney-General's Department. Ms Bogart.
Thank you, Senator. Esther Bogart, the First Assistant Secretary of the First Nations and Justice Policy Division in the Attorney-General's Department.
Excellent. Ms Sheehan.
Thank you, Chair. Anne Sheehan, First Assistant Secretary, International Law and Human Rights Division.
Thank you. Ms Nawaz.
Thank you, Chair. Aisha Nawaz, I'm the Assistant Secretary of the Human Rights Branch.
Excellent. And Ms Dodd.
Thank you, Chair. Amy Dye, Acting Assistant Secretary, Criminal Law Policy Branch.
Excellent. And then we'll move to the Department of Social Services. Ms Hope.
Thank you, Chair. Chintu everyone. Letitia Hope, Deputy Secretary, Families and Communities, Department of Social Services.
Excellent. Thank you. And Ms Sastamonen.
Taria Sastamonen, Group Manager, Children and Families, Department of Social Services.
Excellent. Thank you. Ms Guevara.
Julianne Guevara, I'm the Deputy CEO of Policies and Programs at NIAA.
Ms Jenkins, lucky last.
Yep. Ali Jenkins, Group Manager for Social Policy at NIAA.
Okay. Do any of the departments or agencies have an opening statement?
Not for us.
Not from the Department of Attorney General's Department, Department of Social Services? No. NIAA?
Thank you, Chair.
Okay. We'll go straight to questions. Senator Little, do you? Yep.
I'm interested, you were in here while we were hearing some evidence of the children who are in detention settings who have disability or cognitive impairment of some type. When a child who is in custody who clearly has articulated issues with their parents and the provision of their basic needs by their parents, what is available to that child when they come out of that custodial setting if the basic needs weren't being met before they went into that setting? How do we respond to that right now?
So I can talk in the broad around perhaps some of the things that have been agreed under Australia's disability strategy. So the strategy does include an outcome area for safety, rights and justice, which specifies that the rights of people with disability are promoted, upheld and protected, and people with disability feel safe and enjoy equality before the law. So there's a new safety, rights and justice targeted action plan. It was launched on the 28th of January this year, so only a few days ago really, and it commits governments to specific actions. So some of the examples of the commitments include ensuring young people with disability who are involved in Justice New South Wales, so this is obviously a New South Wales state government commitment, that they're provided with timely, targeted, youth-centric and culturally appropriate interventions and supports. In Queensland, they have committed to the development of a neurodevelopmental practice framework across Queensland Youth Justice Service delivery by 2026, and increasing the youth justice staff knowledge, skills and confidence in understanding and responding to youth people in contact with the South Australian... and then there's... the youth justice staff knowledge and skills development is a commitment by the South Australian government to ensure that they have trauma and disability-related needs training as well. We are in the midst of responding to the recommendations, or progressing our response to the recommendations that were as a result of the Royal Commission, the Disability Royal Commission, and as you'd probably be aware, Volume 8 of the Royal Commission's final report was dedicated to investigating the criminal justice system and its interaction with people with disability. So as part of the Australian Government's response, disability liaison officers are increasingly being introduced into police settings to improve the police responses to people with disability and to strengthen the disability community confidence. So Justice liaison officers have also been introduced in justice settings to increase awareness of the needs of people with disability and clarify roles and responsibilities at the interface between social service systems and justice services. Disability, I should add, is not within my space, but we are working across the department to ensure that there are those connections between the disability space and areas such as mine which look after children and families.
So I'm interested that you went to that Australia's disability strategy, that's the one you're talking about. But what about those children who haven't yet had a disability formally diagnosed?
And you're asking about the exit from...
I'm asking how they are captured by this.
I'd probably have to take that on notice because I don't have the detail of that, but certainly some of the things that I know that we're interested in from my space, for example, from the children and family space, is how do we actually support parents and children to access the wide range of services that are available to them. So as an example, underneath some of the children and parenting support services funding that I deliver, it is around increasing some of the ways in which parents are confident to interact with service systems, including some of those systems that you're talking about, which might be around diagnosis, earlier diagnosis and intervention around perhaps some of the needs that children may have in order to thrive. That's not, I know, specific to exit from the justice system, but I'm happy to take that on notice in terms of some of the things that we could come back to the committee on that might be available.
So if a child isn't captured by the disability, what supports are you aware of that are available to them to ensure they're not one of the 75% that just comes back around again and ends up back in the system, probably with more complex charges against them than they previously went into?
I'd probably prefer, as I said, to take that on notice because I'm not aware of the interactions, for example, with some of the state and territory systems as well, but I'm certainly happy to come back to the committee on what might be available, as you say, to stop the cycle of recidivism or entry back into the youth justice systems. I just don't have that information from me again because it's not particularly an area of expertise that I'm managing at the moment. But
so, Senator, there would be obviously some that are specifically First Nations focused. So you're familiar, of course, that we do run through care programs for youth in the Northern Territory, and they're designed, of course, to provide wraparound services to youth who are within the justice system and coming out to help them to avoid reoffending. So that is one of the examples of an activity. Obviously, from a legal perspective, there are, of course, the First Nations, the Aboriginal Torres Strait Islander legal services, of course, that are providing supports to, from a legal perspective. And you would have seen recently, of course, under the new National Access for Justice partnership, they've received new funding for that.
Ms. Guevara, I think I've traversed this question before in a different setting. But it's come up in media reports recently, another program that has a bus service that runs in the Territory, funded by NIAA, that operates until 4 a.m. in the morning, including the service that's in Alice Springs. We've talked in here about applying a different standard to Aboriginal children as other children. How is it that we don't say to a provider, it is simply just not acceptable for a child to be wandering the streets at 4 a.m. in the morning waiting to catch the last bus home? I'm just trying to understand how we actually, because walking around Alice Springs and just asking people about that, even people who are involved in the care of those children, they're going, yeah, they don't go to school because they're too tired, because they're hanging around with their mates until 4 a.m. in the morning. Regardless of the reason they might be hanging around, the bus still picks them up at that time of the morning and takes them home.
So, Senator, there are two bus services that operate in Alice Springs. One is operated obviously by Luratipa, That is a 5-day-a-week service that actually concludes its service at 11 p.m. in the evening. The other is run by Tangier Council. That one does actually run through till 3 a.m. in the morning. It's a 5-day service. There was an additional 2 days, but that was provided by the Northern Territory Government, who've recently withdrawn their funding. On the 3 a.m. Service, there is YORITs, so the Youth Outreach and Re-engagement Officers that are there to actually support children at risk. So while it's not ideal, as you have suggested, that children are sort of on the streets at 3 a.m, trying to provide them with supports if they are at risk, those YORITs are there to actually help provide that assistance.
So in Katherine, the same issue arises with children, that bus service running until the early hours of the morning. I'm really just trying to understand at what point, given that we know that we're not talking about more than 100 children. We're talking about half that number in Central Australia that at any one point in time would fall into that category. How come we're not seeing the services reducing those numbers?
So I would say, Senator, there are obviously a number of other actions that are designed to support those children and their families. In the Central Australia program, obviously there are things like the Learning on Country program, which are obviously are designed to try and ensure that children have the opportunity to attend school. There are other supports as well for families. There is FASD screening, because I know that was raised in previous testimony by Commissioner Hollins. So there are a range of different things that we are trying to do. As all the testimonies throughout the day have indicated, the needs of these children are obviously extremely complex and require sort of a multidisciplinary response. And so NIAA, of course, is providing funding, which we would often say is supplementary to other mainstream agencies and mainstream services, but we generally try and ensure that our programs, to the extent that they are in these communities and are supplementary, are designed in partnership with community organisations. In the Central Australia instance, of course, the Aboriginal Leadership Group plays a fairly central role in deciding on where that funding is actually going to.
Just trying to understand where these children are, because in South Australia just recently it was reported that less than 3% of children actually at school regularly. The numbers probably aren't reflective in the schools themselves. Where are those children? Do we know where those children are, and that we're actually funding the right programs in the right places? Because if we're funding some programs in the APY lands, where are the children? Where's the participation rates? Not the enrolment rates, the participation rates in these programs.
So I have some more information because when we heard your question earlier today, we did go and have a look at the programs we're funding in that part of Australia. So we do fund a range of education engagement and attainment initiative activities in the APY lands. We had a look at the attendance rates, and it looks like there's a difference between what's called an attendance rate, which is the number of actual full-time equivalent student days attended as a percentage, sorry, this is very long, of the total number of possible full-time equivalent student days attended over the reporting period, and attendance levels, which is the proportion of students attending 90% or more of the time. And in the APY lands, that first one sort of looks like it varies between about 40% as the attendance rate and 58%. And then that latter number that you referenced, the 3% as an attendance level, which is the proportion of students who are attending 90% or more of the time. And that varies between 2% to 15%. Oh, and sorry, worse than that, 0% to 15%. Okay. So there's, it's not as bad as children only attending school, sort of 3% of the time, but it's still obviously a level that we would like to see significantly higher. and the national attendance rate for Indigenous students is 76.9% in years 1 to 10, compared with the non-Indigenous rate, which is 89.2%. So the sorts of activities that we do have in place, and we've worked to reform a former program, the Remote School Attendance Strategy, we have worked to focus on engagement-focused approaches, which are co-designed within the local communities and with the schools, to encourage a sense of belonging for students and encourage participation. And there's a range of different activities that might be chosen by a school to encourage students to attend.
Okay, thank you. I want to ask the question about the Help Way Forward report that we've just been talking about. Talks about responses being piecemeal, uncoordinated and inadequate. I want to give you an example and try and help me to understand how we overcome this. I saw for myself a youth worker in Murrajulu who was looking after children after hours in a hall. It was pretty basic. And I asked the question about this young fella. Kids seemed to engage with him really well. Now, they were desperate to actually give him a full-time job, but they couldn't because another provider wouldn't give up the funding that was from the Commonwealth to allow another agency in another location to provide a 5-day-a-week operation. These organisations have the same footprint coverage. How is it that you can start intervening to go, actually, it's not okay that because you're well-resourced, you can apply for the funding and you tend to get it because your application looks great. But if you can't resource that activity because nobody wants to work for you, or you can't for whatever reason, what triggers being able to give that resource to someone else in a reasonable time frame so that young people actually get a service that they should get? I'm just trying to understand what stops this from happening when people aren't playing nice.
I think, Senator, you've raised some of the very sort of practical issues that we try and address through some of the discussions that do take place in the policy partnerships under Closing the Gap. So I know there's been a number of references today, obviously, to the activities under the Justice Policy Partnership, but certainly I know in the early years Care and Development Policy Partnership, looking at those sorts of practical things that are a barrier to children being able to access services are things that are discussed at those meetings. And you're right, it's not just a question of the services provided by the Commonwealth, but how do we actually more effectively coordinate with states and territories in their activities. And so a lot of the policy partnerships have sort of been through mapping exercises designed to look at, well, what other services that are being provided by each level of government. To your point about sort of, is the footprint similar? Could we be doing this better? Those are the sorts of questions that people are trying to work through in those policy partnerships. I think, and I've heard previous testimony today, that they're by no means perfect, but they are at least an opportunity for people at the federal level to have discussions with their state and territory counterparts and of course, the Aboriginal community-controlled organisations at various levels. Just one more.
Okay, one more.
Those really powerful, well-resourced Aboriginal community-controlled organisations, if you go to their annual reports, there are sometimes projects that aren't delivered and they're sitting there, unspent funds, either to be absorbed by other programs or returned. How do you actually prevent them from essentially scooping up all the money that's available, these scarce resources, and holding that at the expense of other programs that might be able to deliver? I mean, it takes some courage for somebody who's sitting in an environment, a desk like you are, to say, actually, we think we can deliver that better over here rather than through you because we've been doing it there for 10 years. Just tell me how you try and work through those pressures.
I might defer to some of my other colleagues who are actually also responsible for policy partnerships on this, but I would say there are a range of obviously ways of engaging through the Closing the Gap agreement with states and territories, and we do it at various levels to try and encourage the right types of focus. One of them, of course, is the policy partnerships that we have, and Justice Policy Partnership has been spoken about here a lot today. But of course, there are other mechanisms under the Closing the Gap agreement, including the partnership working groups and also the Joint Council, of course, which is co-chaired by the Minister for Indigenous Australians and also Pat Turner, who appeared here earlier today. I think both Ms Turner and the Minister have sought to use their convening power to try and ensure that particularly focus on things like youth justice is there. So you may have seen the last Joint Council meeting for the Closing the Gap was in Perth on the 15th of November. There was a particular discussion about youth justice, which was at the directive of the Minister and Ms Turner. After that Joint Council meeting, there was a letter that was written to all state attorneys outlining some of the issues that we thought it would be beneficial to actually receive further advice on what could be done to address youth issues that related to, for example, housing for children on remand or coming out of remand. Those letters are just one example of how we're trying to, I guess, exert influence on what states and territories might be doing.
So, Senator, we might offer, through the Chair, of course, there's a range of different ways that the department looks at performance, need, coverage, providers and relativity. My colleague might offer some testimony as an example to support your question.
So under Safe and Supported, there's a $10 million investment through the National Child and Family Investment Strategy and Innovation Fund, and the fund has a focus on shifting from crisis-driven support responses towards preventative and early supports that build on the social determinants of family and child wellbeing. So as an example, we're shifting towards adequate and coordinated funding of early targeted, healing-informed and culturally safe services to support children and families and to ensure that they are delivered appropriately, including, basically Aboriginal community-controlled organisations. We did fund SNAICC to...
You're not excluding others, you're including...
It is to be delivered by Aboriginal community-controlled organisations, but there's two parts to it. So the first is the investment strategy itself. So we funded SNAICC and Families Australia to work across the partners under Safe and Supported to develop an investment strategy, including 7 principles for funding. And that investment strategy is still in draft. It will be released, we hope, sometime this year. But in the meantime, we also have live at the moment a tender process, an innovation fund on our website. It closes on the 12th of February, where we're encouraging applications to be able to test and trial these principles. So these principles are being developed so they can be implemented broadly at the Commonwealth, state and territory government levels, and it does look at some of the focus shifting from, I think we've heard evidence today and obviously through a lot of the submissions, shifting away from that too late crisis. And this is in the context, as I said, of Safe and Supported, the child protection side, but we know a lot of the drivers that are leading to children falling into the child protection system are similar to those that are actually leading them to fall into the youth justice systems, for example, as well. So if we can actually test these principles, then what we're seeing is the opportunity to then apply them more broadly. How do we actually move to culturally appropriate early intervention and prevention services?
But Senator, just to hone in, I think, on what your question was around the performance, because I think your language was providers scooping up all the resources, not delivering the services, having expenditure of funds move, which means other actors in the environment can't get entry and they can provide services and they want to. So I think that's the nature of your question, yeah? Under the grants that we operate within DSS, we have grant activity work plans and we have grant activity work plan managers that actually ensure they're working with communities to make sure the services that they've signed up to, one, are adequately delivered. Where we've got a network of state managers who look after feedback on the ground about where there's disjunct there. We also have so there's a range of things that we have in the space around performance, including expenditure of funds, to make sure that the money that's been committed is being delivered to the services on the ground. And that's across all programs, not just specifically within this cadre or this cohort. And happy to provide more detail on notice about how we do that within the portfolio.
Thank you. Senator Shoebridge.
Oh, thanks, Chair, and thanks for the submissions and your attendance today. To go to the submission from the AG's department, perhaps if we go to the part where you speak about Australian government initiatives relevant to youth justice. I don't have time to deal with them all, so we'll just deal with the first 3 points you raise. The one is apparently there's national leadership and coordination on the minimum age of criminal responsibility reform, talking about the action since a working group was established on the 22nd of September 2023 and about Commonwealth leadership in that regard. What you failed to mention in that very short passage is that since the 22nd of September 2023, pretty much every action has gone backwards, apart from the ACT, which is held firm, the smallest jurisdiction in the country. Victoria has reversed its intention. New South Wales has confirmed it's doing nothing. Queensland has confirmed it's doing nothing. And the NT has actually legislated to reduce the age of criminal responsibility. In light of that, what do you say about the performance of the Commonwealth Government on national leadership and coordination? You sort of failed to mention any of those failures, and I don't understand why.
Senator, thanks for your question. So you're right, there was a report provided to SNAICC at the end of 2023, and that was co-chaired by the Commonwealth with Western Australia. We provided a lot of leadership by convening that group and drafting large portions of that report along with the members of the group, which also included members of the Justice Policy Partnership. The report itself provides a principles-based framework for jurisdictions to consider
just
when...
Given the time, Ms Bogan, I'm not really interested in the report. I've read the report. It's a fine report. I'm interested in what's actually happened. And what's actually happened is, under this so-called national leadership from the Commonwealth, it's gone backwards. It's got worse in the Northern Territory. Commitments have reversed in Victoria, and every other state and territory has stalled. It's got worse. How do you explain it getting worse since that was delivered?
Senator, the report was to provide a framework for jurisdictions for their decision-making around raising the minimum age of criminal responsibility and the principles and factors they needed to take into account when and if their governments made decisions about raising the age. It doesn't recommend the age be raised. It recommends how governments may go about raising the age if they do make that decision within each jurisdiction, which is a matter for each jurisdiction.
Well, you see, that wasn't made clear in the report, that the Commonwealth was neutral about whether or not states and territories raised the age. It seemed to be a report designed to have states and territories raise the age of criminal responsibilities. You're now saying, having failed to get states to raise the age, and in fact having gone backwards in the NT, it was never the Commonwealth's intention to get states and territories to raise the age of criminal responsibility. It didn't care one way or another. Is that right?
The report was intended to provide states and territories with a framework for when they were to raise the age for considerations that they should take into account in doing that. So it had things around trauma-informed approaches, the role of Aboriginal and community-controlled organisations in supporting children.
And the fact they've done none of that, in fact done the opposite of that, that's fine, is it?
I'm not commenting on whether it's fine or not. That was the purpose of the report.
Was there a purpose in it? I mean, was there a purpose in producing the report? Was it intended to raise the age of criminal responsibility, or was it just an exercise in keeping Commonwealth bureaucrats busy? Was it intended to raise the age of criminal responsibility, or was it just intended to produce a report you could point to?
It was intended to provide support for and best practice for jurisdictions in decision making around if and when they raise the minimum age, what they should be taking into account, and that was what the report did, using a principles-based framework.
But they haven't. In fact, they've done the opposite. What do we say about that? They've done the opposite.
Minimum age of criminal responsibility is a standing agenda item on SCAG agendas, and jurisdictions are asked to comment and report back on their progress. But the raising of the age of criminal responsibility is a matter for each jurisdiction and their governments.
Well, let's go to the next piece of national leadership and coordination that your department has been driving. On the 23rd of February last year, SCAG asked the JPP, which you co-chair, to provide advice on bail and remand reform. A report was provided in June 2024. There's a working group established. Now, was the intention of that to make the bail laws in relation to kids worse, to remove presumptions against bail, to actually make, for the example of Queensland, it harder to get bail as a child than as an adult? Was that the intent of that report? Is it working?
So, Senator, the working group has met twice now, and it is working through a range of issues around bail and remand, recognising that bail and remand and the laws that and policies and practices in place within all jurisdictions does have an impact on incarceration rates, particularly of Aboriginal and Torres Strait Islander people and children. It's not just specific to children. The working group will report back to SCAG in mid-2025. I'm co-chairing that working group along with NATSLs. So we're in early stages, but there is a lot of considerations that we're taking into account for that to report back to SCAG. And so each jurisdiction is represented on that working group and will contribute to the recommendations in that report.
Do you intend to produce another report like the Criminal Responsibility Working Group report? Is that the intent, another report?
Senator, at this stage, yes, another report will be produced.
And does it matter to the Commonwealth if states make bail laws worse for kids? Does the Commonwealth have a view about it, or are you just going to produce a report?
Senator, working with all of the states and territories on best practice around bail and remand practices, legislation and providing recommendations to SCAG is the intention of that report, and we will work constructively with each jurisdiction, but as with minimum age, it is a matter for each jurisdiction how they ultimately legislate.
And what is best practice? Is Queensland best practice where bail laws are harsher for kids than adults? Is that best practice? Is
the working group is
Commonwealth neutral on best practice?
The working group is still working together on what that looks like, and the working group has equal representation from government and non-government representatives, so it will have a really broad remit and consideration of those issues, but it's too early to comment on what the report will contain.
We'll wait for the report, will we? Okay. Yep. The Justice Policy Partnership. Now, that produced a strategic framework in June 2023. It had a whole series of goals. Each one of those goals is tracking badly. It's going backwards on every one of the goals. I'll give you just one example. One of the goals was to reduce the overrepresentation of Aboriginal and Torres Strait Islander people in prisons, going backwards pretty much in every jurisdiction in the country. Again, was the work done when the document was produced? Is the Commonwealth neutral about whether the outcomes are achieved?
Senator, I think you're talking about the closing the gap targets and outcomes, which are reducing incarceration rates. And
I'm not. I'm talking about the Justice Policy Partnership Framework. And I'll point at goal 1, transforming justice systems. Transform justice systems so that they work for and not against Aboriginal and Torres Strait Islander people by eliminating racism, embedding self-determination across the justice systems as an essential pillar of reform, ensuring policies and programs are culturally safe and designed in partnership, and all justice agencies engage with families and individuals in a strength-based way. That's one. Partnership Partnerships and accountability, point 2. Establish formal partnerships, share decision-making, ensure accountability to meet justice targets and implement priority reforms, including reducing the overrepresentation of Aboriginal and Torres Strait Islander people in prisons and increasing positive contact with justice systems. So I'm talking about the Justice Policy Partnership.
Yep.
It's not working. It's going backwards. Things have got much worse since it was produced. But is the Commonwealth neutral about that? It's not your problem?
Senator, the Commonwealth puts a lot of resources into the Justice Policy Partnership. Again, co-chairs that group, and the strategic framework is set against the same time frame as the National Agreement on Closing the Gap, which is till 2031.
You haven't got a strategic framework. You're implementing, you're finalising your implementation roadmap to implement the strategic framework. That's what you tell us. You haven't even got a strategic framework. You're now finalising your implementation roadmap to implement the strategic framework of a document produced 2 years ago that's already failing. Is that what we're up to?
Strategic framework, I think, is what you're reading from, Senator, and I don't
I'm reading your submission, page 4 of your submission. You say you're now finalising your implementation roadmap to implement the strategic framework. You haven't got a strategic framework.
No, we do have a strategic framework. It's on the department's website, but I can...
But you haven't got an implementation roadmap to implement the strategic framework.
So we do have an implementation roadmap which we're working through, and there are several priorities over the next 12 to 24 months for that implementation roadmap. So
does any of this include...
Sorry, Senator Shoebridge. You can give the witness... an opportunity.
I'm interested in the
well, sorry, just let me finish first. I really want to especially when you ask a question which is based on an assumption, I think it is especially appropriate to give the witness an opportunity to give a fulsome answer. So, Ms Bogart.
Thank you, Chair. So work is underway on a range of projects sitting underneath the strategic framework in the implementation plan. So we are, as a group, developing a national anti-racism strategy to address racism experienced by Aboriginal and Torres Strait Islander people within the justice system. We're developing a national sector strengthening plan to strengthen Aboriginal and Torres Strait Islander community-controlled justice sector. We're developing justice partnerships between the national JPP and jurisdictional partnerships, and we're also establishing new cross-sector partnerships between the JPP and other sectors. And I know that there's been a lot of evidence given today about the need to have that cross-sector joined-up support. The first priority for cross-sector partnerships that we've commenced work on is the disability and health sectors with the justice system. And at the last JPP meeting on the 19th and 20th of November, it was agreed to start scoping work on a cross-sector partnership on youth justice. So there is significant work underway under that strategic framework. We have working groups or subgroups set up on each of those, co-chaired by a state or territory and a non-government representative. That work is being progressed and reported back to the JPP. So there is work underway, Senator, under that implementation plan.
Senator Shoebridge, the Deputy Chair does have questions. Do you have one last question, please?
All of these documents, all of these apparent actions by the Commonwealth, and we then have the Queensland Government, just as recently as, I think, a few months ago, actively passing a law which the Minister accepted was, at the outset I acknowledge the bill is incompatible with human rights. It identifies it's in breach of Australia's international obligations which have been entered into by the Commonwealth on the Convention of the Rights of the Child, on UN standard minimum rules for the administration of juvenile justice. It accepts that it's going to be putting children, largely Aboriginal and Torres Strait Islander children, in watch houses for extended periods of time, in breach of their human rights. It accepts that it's going to be disproportionate impact on First Nations kids, acknowledges, and that according to international human rights standards, the negative impact on the rights of children likely outweighs the legitimate aims of punishment and denunciation. The amendments will lead to sentences for children that are more punitive than necessary to achieve community safety. This is all the Queensland Government's own words. Then says the amendments will treat children less favourably than adults in the same circumstances, and I'll quote it here, this will in essence create a sentencing system where adults are better protected from arbitrary detention than children. All of it in gross breach of international obligations the Commonwealth's entered into, in gross breach of the Justice Policy Partnership that the Queensland Government signed on to, in gross breach of the bail and remand form that you're proposing. The Queensland Government did that in plain sight as recently as last year. What did the Commonwealth Government do to stop it? What, if anything? Or do you just accept it? It's fine. What did you do to stop it?
The fact that Queensland can pass laws that relate to its own criminal justice system really just, I guess, reflects our federal system, that the states and territories do have responsibility, primary responsibility for criminal justice systems in their jurisdiction. If I can make a comment in relation to international law, it's the Commonwealth that enters into treaties as the level of government that has responsibility for our foreign relations. But those commitments bind all levels of government, so it's not just the Commonwealth that is taking those obligations on. The Commonwealth, the states and territories all have those obligations. So states and territories, they have a responsibility to be complying with international law in the passage of their legislation in respect of their policies. Sorry,
Senator Shoebridge, if we could just let the witness finish her answer, and then I do have to give the call to the Deputy Chair. Thank you.
I mean, what I was going to say is there are a variety of mechanisms by which the Commonwealth does engage with the states and territories in respect of what those international obligations are. When the Commonwealth is entering into treaties, we do engage with states and territories through the Standing Committee on Treaties to ensure that states and territories understand what those obligations are. We've talked about some of the engagement that happens with states and territories through mechanisms such as Standing Council of Attorneys General. There's other forums such as police ministers' meetings through the Justice Policy Partnership as well. So there are a variety of ways in which we do continue to engage with the states and territories on these issues.
Well, I asked a specific question about this bill, if anything was done to stop it, and I have not had an answer. Was there even a briefing produced to the Attorney General? Was there a single thing done in the Commonwealth?
Senator Shoebridge, it's up to the witness how they answer the question. Is there anything else you'd like to add, Ms. Sheehan, or would you like to take those additional points on notice? Or
was anything done?
Queensland can pass laws within their own legislative competence.
Okay. So, well, I think the witness has answered the question. Well, that's your comments, and
they're all there. Was
the deputy chair now has the call.
Yeah.
Nothing.
Deputy Chair.
Senator Shoebridge, sorry, I'm not the chair, but I'm calling a point of order because Senator Shoebridge continues to interrupt and speak over you as chair. Do I have the call now?
You have the call, Deputy Chair.
Thank you very much. Well, let's start there then. In terms of the Commonwealth's role in the criminal justice system, this is an inquiry into the youth justice and incarceration system. In terms of justice and incarceration, what role does the Commonwealth have in legislating those laws and implementing those laws?
The states and territories are primarily responsible for criminal justice offences. The Commonwealth is responsible for offences which fall within their constitutional head of power. The Commonwealth has provisions related to bail where they connect to those Commonwealth offences. Predominantly through the Judiciary Act that bail is provided for in the states and territories, and those bail matters are heard in accordance with state and territory court procedurals.
Okay. I want to ask some questions about national justice reinvestment. I think that's still with the Attorney General's. Yes. You've provided some information about it. I just want to be clear. How has the program been designed to ensure that it meets different needs for different communities? Because I think we recognise that not every community is the same or has the same issues, and it's not a one-size-fits-all.
Yeah, thank you, Senator. So justice reinvestment is a long-term, place-based and community-led approach that enables Aboriginal and Torres Strait Islander communities and leaders to come together to identify local solutions to local issues that reduce First Nations adult and youth coming into contact with the criminal justice systems. So the program has been designed in a way that it is community-led, and communities are asked to identify in applying for grants under the program where what needs to be done within that local community, within that local context, to reduce contact with the criminal justice system. So we have funded now 27 initiatives across the country, 12 of which have a focus on youth. And they are very different because they do need to respond to the specific needs within that community or jurisdiction. And I can give you some examples of some of the youth-specific justice reinvestment initiatives that have been funded, if that's useful.
It is. Can I ask, so just in terms of working with the states and territories, they have primary responsibility for the justice system, but this is justice reinvestment. Is there a conversation with the state or territory government about which programs they want to be funded, or is it local providers that are applying for the funding?
It's local providers applying for funding. The whole program was designed on it being community-led and the initiatives being identified by community for community, but we do work really closely with the states and territories. So at the end of 2023, SNAICC endorsed some national collaboration principles about how the Commonwealth states and territories will work together collectively, but also bilaterally on justice reinvestment. We're in the process of finalising MOUs with each jurisdiction that does have a funded one or more funded initiatives on how we will work together, including opportunities for exploring co-funding of initiatives, but working together then with those communities on what their additional, so if we're funding the initiative, what other needs might that community have that only the state can meet? So, for example, working with local police in that area, we really need the state to be involved in there, or maybe data sharing of state data that might help those communities to measure the success of their initiative.
What were some of those examples of the activities that are happening on the ground?
There are, so as I said, there are 12. I won't go through all 12 of them. There's a really good example being run by the Aboriginal Legal Service of Western Australia to prevent youth reoffending, and that's being delivered in a consortium with a range of other Aboriginal organisations within the community in the Perth metropolitan and southwest regions. So that's being designed as a flexible intervention program for at-risk youth and those already engaged in the justice system. So in that program, youth are supported by a case manager. They attend mentorship programs, including an education and activity course. There's on-country healing and caring for country camps. And youth are also provided through care support so that they are placed on a path to a better future. That's the wording of the initiative.
Yeah. I've got a lot of questions. I'll try to get through as many as I can quickly. We've heard about young people in detention centres also having a disability. That was from some of our first witnesses today. What is the government doing to assist people with a disability who are in the youth justice system? I don't know if that's a question for Attorney Generals or Social Services, but around people with a disability.
So I mentioned before that under the new action plan, so this is the Safety, Rights and Justice Targeted Action Plan. It is actually Commonwealth states and territories, and it does commit governments to specific action. So there's probably some things that we can provide on notice about some of the examples underneath there, but it was launched on the 28th of January, and I read out a couple of examples from New South Wales, Queensland, South Australia earlier.
Sorry, I missed that.
No, that's okay. But yeah, there's some examples of how, for example, New South Wales Justice, is working to ensure young people with disability are provided with timely, targeted, youth-centric and culturally appropriate interventions and support. So we can certainly point you in the direction of some specific examples that are included underneath the action plan.
Yep. Probably on notice, and I'll put this question on notice if I can to the NIAA. You've probably gone to this in previous answers to questions, but the Indigenous Advancement Strategy, I wondered on whether on notice you can provide some information about the current programs that are receiving funding through that program and how they relate to youth justice outcomes. And just for DSS, I guess the other question I had was around the National Commissioner for Aboriginal and Torres Strait Islander Children and Young People. Just interested in how the department's working with the Commissioner to get the Commission established, and also what thinking has been has the department done around how the Commissioner will consult with children and young people. Obviously, there's a handing over of responsibilities, but I'm sure that because it's such a new position that the department's still doing some of that work. So that would be very helpful to understand.
Just to confirm, Senator, would you like us to put that on notice to you, or would you like an
putting
answer
these
now?
questions on notice to you now?
We can absolutely.
Just because of the time.
No problem. No
Thanks,
problem at all.
Chair.
Thank you, Deputy Chair. And thank you to all the witnesses for giving evidence today. Greatly appreciated. I don't think we have any table documents. No. Deadline for answers to questions on notice.
Sorry, Chair. I mentioned earlier today just the letter that has been written by the Minister and Ms Turner to Attorneys General just in respect of youth justice, and we'd be very happy to table that for the committee just in terms of, as I said, the convening role that the Minister for Indigenous Affairs plays in terms of the Closing the Gap agreement.
Sure. Okay. So I think, can I just have a motion from the Deputy Chair to accept that, and also questions on notice by close of business 14 February? Okay, thank you. So that concludes today's proceedings. The committee has agreed that answers to questions taken on notice of the hearing should be returned by close of business Friday, 14 February 2025. I thank all witnesses who have given evidence to the committee today. Thanks also to broadcasting. Thank you. Thanks also to Secretariat. Thank you. I declare the hearing adjourned. Thank you.